How America Gets Away with Murder. Illegal Wars, Collateral Damage, and Crimes Against Humanity. Michael Mondell. Part I. Illegal Wars/Collateral Damage 1-1. Iraq 2003-3 The Law and the War Against Iraq 10 Security Council Authorization 10 Self-Defense 19 Humanitarian Intervention 21. 2 Afghanistan 2001 29 Collateral Damage 46. 3 Kosovo 1999 57 Kosovo 68 The Road to Rambouillet 69 Rakok 72 Rambouillet 80 Humanitarian Intervention 89. Part 2. Crimes Against Humanity 115 4. The War Crimes Tribunal 117 The Holocaust Analogy 118 Bosnia and the Birth of the ICTY 120 The ICTY at War 132. 5 The Trial of Milosevic 147 Milosevic at The Hague 152 Victor's Justice 160. 6 America Gets Away with Murder 176 The Case Against NATO 177 Crimes Against Humanity 178 Crimes Against the Laws and Customs of War 180 Targets 201 The Illegality of the War 202. 7 Rounding Up the Usual Suspects While America Gets Away with Murder 207 The International Criminal Court 207 The Americans Have Ways 215 Nuremberg 219 Tokyo 222 The Pinochet Case 223 Belgium 230 Justice 233 Deterrence 237 Truth 239 Peace 242 Vision 248. 1. Iraq 2003. America's war on Iraq in 2003 was its third illegal war in just under 4 years. Each one was a bloody horror, but the Iraq War distinguished itself both for its bloodiness and for the flagrancy of its illegality. It was virtually certified as illegal by a defeat at the Security Council so unspinnable that President Bush had to back down from his boast to make the members show their cards by forcing a vote. 1 The illegality of the Iraq War was not due to some lawyer's technicality. The reasons for it were the same as the reasons for the defeat at the Security Council, the failure of the United States to demonstrate one decent moral justification for resort to war, with all the death and destruction that were sure to follow. The United Nations weapons inspections had turned up nothing, and, despite crude attempts by the Americans and the British to discredit the inspectors before the war with phony intelligence, risk assessment enhancement as the American comic strip Doonesbury called it too, they themselves would do no better when they scoured the country afterwards. There was admittedly no threat of Iraq attacking the United States or its allies, so there was no plausible claim of self-defense. Those few who believed that the war would be about freeing Iraqis were rapidly disabused of this when, with the regime of Saddam Hussein overthrown, the Americans made it clear that the Iraqis would have a hard time ever freeing themselves from the American military occupation. Nor could concern for Iraqi human rights be taken seriously as a motive from a country that had punished Iraqis for 12 years with an inhuman sanctions regime. And where was the humanity to be found in a war that had destroyed so many human lives? Iraq Body Count, an international research group dedicated to documenting scientifically the Iraqi civilian casualties, estimated the number of those killed in the war and occupation at between 6,100 and 7,800, with 20,000 wounded. Most of these people, about 4,100 to 5,200, had been killed during the invasion. A Los Angeles Times survey of Baghdad hospital records counted 1,700 civilians killed in the battle for Baghdad alone. The same records showed 8,000 injured. Injured included losing both your arms and suffering deep burns to 35% of your body, not to mention having your father and mother killed. Like 12-year-old Baghdadi Ali Ismail Abbas. While the war deaths of American and UK soldiers were carefully counted at 164, with 569 injured, the number of Iraqi soldiers killed and wounded would probably never be known. 5 estimates ranged from 2,300 to tens of thousands. 6 The killing didn't stop with the overthrow of the Iraqi regime. What the Americans called the bitter enders immediately started a guerrilla war against the occupation, attacking American soldiers and many other targets daily throughout 2003. American deaths from these attacks, about 200 in the period from May 1 to December 1, sent shockwaves through the U.S. But about 3,000 Iraqi civilians were killed during the same period, whether as bystanders in the attacks on Americans or in the inevitable counterattacks, or in other violence related to the occupation. Jittery American soldiers shot dead 5 members of the same family on June 13, then 9 Iraqi police and 3 civilian bystanders on September 12, and all 5 occupants of a farm truck carrying chickens on November 11. The August truck bomb attacks against United Nations headquarters in Baghdad and a Shia mosque in Najaf took the lives of over 100 Iraqis, as well as those of UN Operations Chief Sergio Vieira de Mello and top cleric Ayatollah Mohammed Bakr al-Hakim. When attacks against Americans reached a crescendo in November with the shooting down of 4 American helicopters and about 70 U.S. combat deaths, America responded with Operation Iron Hammer, and the bombing war had essentially recommenced. "This is war," said a U.S. Major General on November 19. "We're going to use a sledgehammer to crush a walnut." 7 on that day and the next, the Americans killed 10 Iraqi insurgents, and another 10 Iraqi civilians died in bomb blasts in 3 separate cities. 3 were children killed in an explosion at a school, and it wasn't known whether the bomb had been placed there or one of the children had been playing with unexploded ordnance. 8 Compounding the violence was the fact, soon evident, that the U.S. had done virtually no planning for actually administering Iraq after it had been conquered. A country reduced it to a fifth of its pre-1991 productive capacity by more than a decade of sanctions quickly descended into the chaos of looting, violent crime and sabotage. Not only the treasures of the Baghdad Museum, but the hospitals, schools, and power plants were stripped of everything that wasn't bolted down. The murder rate soared, and oil, water and electricity systems remained a shambles throughout 2003. Already in June, with anti-American discontent and guerrilla attacks steadily rising, U.S. Ground Forces Commander Lt. Gen. David McKiernan had concluded that Iraq will be a combat zone for some time. 9 In early 2003 a global anti-war movement the likes of which had never before been seen demonstrated in its millions to show that the world did not believe the revolving justications the Americans kept serving up for the war. A poll released by the American Pew Research Center on the day before the war showed opposition in every country surveyed except for the United States, including America's main ally Britain, where opposition ran at 51 to 39%. Opposition was massive not only in opposing countries like France, Germany, and Russia but also in coalition of the willing countries Italy, Spain, Poland and Turkey. 10 The world was convinced that this was not a war fought because of some new realities of terrorism, weapons of mass destruction, much less for freedom, but rather for the old familiar reasons of empire, private wealth and public strategic power. Iraq had the second largest oil reserves in the world, a source of both, and it was clear that the Americans wanted to be the ones in charge, not only of Iraq, but of the whole, increasingly unstable region. 11 Why does the administration seem unconcerned about an exit strategy from Iraq once Saddam is toppled? Because we won't be leaving. Having conquered Iraq, the United States will create permanent military bases in that country from which to dominate the Middle East. 12 The ancient coinage of empire, credibility, was at stake. Every 10 years or so, the United States needs to pick up some small crappy little country and throw it against the wall, just to show the world we mean business. 13 The world's representatives at the United Nations and on the Security Council, prodded by opinion on the world's streets, scrutinized America's trumped-up claims that some legitimate collective interest or human good was at stake and rejected them. Despite the enormous pressure it could wield as the richest and most powerful country in the world, the United States was able to muster only 4 votes for war out of the 15 on the Security Council, the body entrusted by the 191 members of the United Nations with the duty to decide matters of war and peace. In technical terms, this was a war of aggression, the legal word for a war that does not fall within the narrow confines of the right of self-defense and has not been authorized by the Security Council as absolutely necessary in the collective interest of international peace and security. What does it mean for a country to wage a war of aggression? If we judge it by the standards laid down by the Nuremberg Tribunal that judged the Nazis after World War II, it is the supreme international crime. The first count against the Nazis in the Nuremberg Charter was the crime against peace, namely planning, preparation, initiation, waging of a war of aggression, or a war in violation of international treaties just like the Charter of the United Nations. The judges of the tribunal came from the four victorious powers: America, Russia, Britain, and France. In one of the best-known passages from the judgment of the tribunal they declared, "War is essentially an evil thing. Its consequences are not confined to the belligerent states alone, but affect the whole world. To initiate a war of aggression, therefore, is not only an international crime, it is the supreme international crime, differing only from other war crimes in that it contains within itself the accumulated evil of the whole." 14. So according to this foundation judgment of all international criminal law, the Americans, and that means their leaders, Messrs. Bush, Rumsfeld, and Powell, General Franks, Ms. Rice, etc., and their associates Messrs. Blair, Hoon, Straw, et al., are guilty of having committed the supreme international crime in Iraq, the one that contains within itself the accumulated evil of the whole. But even more than this, these leaders are also guilty for every act of violence with which this war was pursued. In the words of the American Chief Prosecutor at the tribunal, the much venerated American Supreme Court Justice Robert H. Jackson, "Any resort to war, any kind of war, is a resort to means that are inherently criminal. War inevitably is a course of killings, assaults, deprivations of liberty, and destruction of property. An honestly defensive war is, of course, legal and saves those lawfully conducting it from criminality. But inherently criminal acts cannot be defended by showing that those who committed them were engaged in a war, when war itself is illegal. The very minimum legal consequence of the treaties making aggressive war illegal is to strip those who incite or wage them of every defense the law ever gave, and to leave the war makers subject to judgment by the usually accepted principles of the law of crimes." 15. In other words, President Bush and his colleagues are legally guilty of the murder of many thousands of people, not to mention the grievous assault of many tens of thousands more, and so on down the list of the most serious crimes in the criminal codes of every country of the world. It's the kind of thing that, when done on a fraction of the scale in the Bush family's Texas, gets you a one-way ticket to the lethal injection chamber. And it doesn't matter that the war was authorized by the American Congress, even if that made it legal according to American law, because the fact that a war is legal according to the law of the country that launches it is irrelevant to international law. The Nazi war was legal according to Nazi law. International law is about international norms and international treaties, like the Charter of the United Nations that made the war unquestionably illegal. According to Principle 2 of the Principles of International Law recognized in the Charter of the Nuremberg Tribunal and in the judgment of the Tribunal, the fact that internal law does not impose a penalty for an act which constitutes a crime under international law does not relieve the person who committed that act from responsibility under international law. 16. Principle 3 adds, the fact that a person who committed an act which constitutes a crime under international law acted as head of state or responsible government official does not relieve him from responsibility under international law. But the president isn't headed for death row, he's not even going to court. Because, for all we hear about war crimes and international criminal courts, there isn't one that has any jurisdiction over these supreme criminals for their supreme crimes. There is a brand new international criminal court at The Hague that is supposed to try people for war crimes, but, in order not to offend the Americans, who aren't even parties to the court, it doesn't have jurisdiction over the supreme crime of starting an illegal war in the RST place, only the lesser ones, crimes against the so-called laws and customs of war. It's as if there were no law against murder, only murdering without reasonable regard for the safety of bystanders. Think of it as a loophole. One Nuremberg prosecutor wrote at the time that, since the laws and customs of war are typically violated by both sides, they are at best a fragile barrier between the violence of war and its victims. Modern war, no matter how chivalrous, involves so much misery that to punish deviations from the conventions without punishing the instigators of an aggressive war seems like a mocking exercise in gentlemanly futility. 17. It's because of this loophole that there was so much talk during the Iraq War about the Geneva Conventions and the laws and customs of war, but nothing about the crime of starting the war itself. When the attack was launched, stern warnings were issued to all the belligerents by Human Rights Watch, Amnesty International and groups with lesser prominence, reminding them of their duties under the laws and customs of war. 18. But neither said a single word about the illegality of the war itself or the supreme criminal responsibility under international law of the leaders of the countries that had started it. During the war, too, an enormous amount was said about the lesser crimes. The U.S. was very vocal about the mistreatment of American prisoners of war, who were, according to the U.S., subject to humiliating and insulting circumstances designed to make them objects of public curiosity, contrary to Article 14 of the Third Geneva Convention. Amnesty International agreed that questioning U.S. prisoners on Iraqi TV was wrong, but pointed out that the Americans were violating the very same proscriptions, not only with respect to Iraqi prisoners, but also the steady stream of prisoners it had sent and was continuing to send to Guantanamo Bay, which it had unilaterally declared a Geneva Conventions-free zone. 19. The Department of Defense also complained about Iraq's alleged purdy in using fake surrenders and dressing soldiers as civilians, to draw the invaders into ambush. 20. When a suicide bomber disguised as a taxi driver blew himself up along with 4 American soldiers at a checkpoint, Human Rights Watch condemned it as purdy, distinguishable from permissible ruses of war and even suicidal attacks by undisguised military forces, because they do not depend on taking advantage of an enemy's willingness to abide by the law protecting non-combatants. 21. Then an American tank opened at a car loaded with people at a checkpoint near Karbala and killed 10 civilians, ve of them children. There were conflicting accounts of whether there had been adequate warning, but the Army spokesman Brig. Gen. Vince Brooks was quick to point to cases of purdy as the context. General Brooks suggested that other checkpoints had been rushed by several Iraqi vehicles at a time. Sometimes a car carrying civilians would precede others full of armed combatants. He would not say whether that had been the case on Monday. 22. At his press conference, General Brooks invoked the soldiers' inherent right to self-defense and said, "While we regret the loss of any civilian lives, at this point they remain unavoidable, as they have been throughout history." 23. Amnesty International was also critical of these perfidious practices for the way they endangered civilians, but they also condemned the invading forces for the use of inherently indiscriminate cluster bombs and the bombing of a TV station. Amnesty also questioned whether the required precautions were being taken to protect civilians, and called for investigations into civilian deaths like those at the Karbala checkpoint and the shooting of demonstrators in Fallujah. 24. But never once did Amnesty International, let alone Human Rights Watch, mention the fundamental reason why none of these incidents really had to be investigated at all, namely that all of this death and destruction was legally, as well as morally, on the heads of the invaders, whatever precautions they claimed to take, because it was due to an illegal, aggressive war. Every death was a crime for which the leaders of the invading coalition were personally, criminally responsible. When General Brooks said the soldiers at the Karbala checkpoint were exercising their inherent right to self-defense, he was talking nonsense. An aggressor has no right to self-defense. If you break into someone's house and hold them at gunpoint and they try to kill you but you kill them first, they're guilty of nothing and you're guilty of murder. 25. General Brooks got one thing right: civilian deaths remain unavoidable, as they have been throughout history. Which means that the people who started this war knew that precisely this kind of thing would happen. And that's why they're guilty of murder. The best they can say for themselves is that the thousands of dead were the absolute minimum that anyone could expect from the war they started. Despite all this, and despite the evidence of major coalition criminality against civilians reported by independent journalists such as Robert Fisk 26 and John Pilger 27, when the time came for talking about prosecution, the only subjects were Saddam Hussein and his associates. In fact, because the Iraqi war crimes of 2003 were, after all, rather minor in the context, attention was turned to digging up the graves of all Saddam's crimes from the time of the RST Gulf War. There would nightly be trials, it was just a question of where, in The Hague, in the US, or in American-run Iraq. 28 For reasons explored in Chapter 7, it was the last option that had been settled upon by the time of the capture of Saddam in December 2003. But the trials had been announced much earlier by the Bush administration, a few days prior to the war, in fact, and the point of the announcement was obviously not to commit America to trying Saddam, they were trying to kill him at that point, but to justify the illegal war. 29 Likewise for the war criminal provisions in the post-war Security Council resolutions, and indeed all the earnest pondering after Saddam's capture. No mention in any of this, of course, of the enormous complicity of the supreme criminals in these very crimes, and no question of their prosecution for the supreme crime they had just committed, not even for any of the lesser crimes. The Americans were boycotting the International Criminal Court, and when the famous Belgian universal jurisdiction law was invoked by some Iraqis against General Tommy Franks for indiscriminate and even deliberate attacks on civilians, it turned out the law had just been changed so that the charges would now be sent for investigation to the United States. 30 So here is the problem with international criminal law, it lets the Americans get away, not only with murder, but with the supreme international crime, and it punishes only the individual evils of the Americans' enemies, even though these are but the inevitable result of the supreme crime that contains within itself the accumulated evil of the whole. It does this so regularly that it cannot be regarded as some minor kink that has to be worked out of the system. Despite international criminal law's banner commitment to ending impunity, its operating principle is really one of selective impunity. The question is, what is this war crimes business about that always winds up punishing only the usual suspects? In an attempt to answer it, the rest of Part I explores the criminality of the Iraq War and the two illegal wars that preceded it, as well as the concepts of collateral damage, self-defense and humanitarian intervention. Part II examines the various species of international criminal law in action, especially the International Criminal Tribunal for the former Yugoslavia, but also the new International Criminal Court and other types of universal jurisdiction. The law and the war against Iraq. The war against Iraq was denounced as illegal by a great many experts on international law throughout the world. They vastly outnumbered those few, mainly the protagonist governments and their hired guns, who defended its legality. You can pursue the details of these arguments from the sources themselves. 31 It should be enough here to briefly outline the main points. International law prohibits the use of military force by one state against another, except on one of two conditions: either it is pursuant to a valid authorization by the Security Council of the United Nations, or it is in the exercise of the narrowly defined inherent right of self-defense. The first condition dates from the Charter of the United Nations of 1946, a treaty binding on all its members and the supreme document of international law. The second predates the Charter but is preserved and limited by it. To these two accepted cases, it has been advocated that there be added a third, namely humanitarian intervention. The Americans tried to justify their war against Iraq by reference to all three criteria. Self-defense and humanitarian intervention are discussed in detail in chapters 2 and 3 respectively, so they will be touched upon only briefly here. What needs some attention is the question of Security Council authorization. Security Council authorization. The Charter of the United Nations is essentially an anti-war document. Its very RST words condemn war as a scourge. We, the peoples of the United Nations, determined to save succeeding generations from the scourge of war, which twice in our lifetime has brought untold sorrow to mankind. The principles by which the Charter seeks to save us from war include these. Article 2.3. All members shall settle their international disputes by peaceful means in such a manner that international peace and security, and justice, are not endangered. 4. All members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state, or in any other manner inconsistent with the purposes of the United Nations. The Charter does not ban the use of force completely, but it creates a powerful presumption against it by concentrating the authority for its legitimate use in the Security Council. Even the right to self-defense is only temporary under the Charter, until the Security Council can intervene. The idea of concentrating this authority in the Security Council is to fulfill a fundamental objective of the Charter, namely to ensure by the acceptance of principles and the institution of methods, that armed force shall not be used, save in the common interest. 32 The Security Council's quasi-monopoly over the legitimate use of force aims to ensure that it is used in the common interest by the Council's representative nature. It is made up of 15 member states, 10 of which are elected for 2-year terms by a 2/3 vote of the General Assembly of all the 191 members of the United Nations, which represents virtually the entire population of the world. In March 2003, the elected members were Angola, Chile, Germany, Pakistan, Spain, Bulgaria, Cameroon, Guinea, Mexico, and Syria. In addition to these 10, of course, there are the 5 permanent members, each with a veto on any decision of the Council. While resolutions of the Security Council can pass with 9 affirmative votes, even 14 cannot act over the objection of one of the permanent members. This means that the permanent members cannot act without complete support from each other and substantial support from members elected by all the other members of the United Nations, but any one of the permanent members can defeat any action of the Security Council. The system is clearly less than perfectly democratic, but it doesn't take much reflection to see that it's better at ensuring force is used only in the common interest than is the Americans acting alone, or even with their self-appointed coalition of the willing. Article 24 of the Charter gives the Security Council primary responsibility for the maintenance of international peace and security, and all members agree that in carrying out its duties under this responsibility the Security Council acts on their behalf. But even the Security Council has limits on its power. The second paragraph of Article 24 provides that, in discharging these duties the Security Council shall act in accordance with the purposes and principles of the United Nations and within specific powers, laid down in Chapters 6, 7, 8, and 12. What are these specific powers? Chapter 6 provides for the pacific settlement of disputes. It requires that the parties to any dispute shall, first of all, seek a solution by negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies or arrangements, or other peaceful means of their own choice. If they fail to settle the dispute on their own, Article 37 lays down the absolute requirement that they shall refer it to the Security Council. Chapter 7, Action with respect to threats to the peace, breaches of the peace and acts of aggression, is the part that provides the Security Council with authority to use coercive measures including armed force, but only as may be necessary to maintain or restore international peace and security. It also has the power to make recommendations, or to employ measures not involving the use of armed force, which may include complete or partial interruption of economic relations and of rail, sea, air, postal, telegraphic, radio, and other means of communication, and the severance of diplomatic relations. Article 42 provides, finally, for the use of armed force. Should the Security Council consider that measures provided for in Article 41 would be inadequate or have proved to be inadequate, it may take such action by air, sea, or land forces as may be necessary to maintain or restore international peace and security. Such action may include demonstrations, blockade, and other operations by air, sea, or land forces of members of the United Nations. The American mass media tried its best in early 2003 to portray the Security Council as some dubious, meddling, alien body imposing itself on the United States, but it can be seen from this that nothing is further from the truth. This is not the International Criminal Court that the US has never accepted. The Security Council has been made the supreme international authority over war and peace by a solemn treaty, drafted, signed and still voluntarily adhered to by the United States, along with each of the 191 member states of the United Nations. It is binding on all members as a condition of their membership, all members, in order to ensure to all of them the rights and benefits resulting from membership, shall fulfill in good faith the obligations assumed by them in accordance with the present Charter. 33 Hence the importance of demonstrating that the Security Council has authorized any given use of force. In his pre-war speeches of March 6 and March 17, 2003, President Bush made the issue of weapons of mass destruction the central theme. But, according to Bush, possession of them by Iraq not only posed a threat to the United States, it also put Iraq in defiance of Security Council resolutions, and these authorized the United States to go to war. Under Resolutions 678 and 687, both still in effect, the United States and our allies are authorized to use force in ridding Iraq of weapons of mass destruction. This is not a question of authority, it is a question of will. Last September, I went to the UN General Assembly and urged the nations of the world to unite and bring an end to this danger. On November 8, the Security Council unanimously passed Resolution 1441, finding Iraq in material breach of its obligations and vowing serious consequences if Iraq did not fully and immediately disarm. Today, no nation can possibly claim that Iraq has disarmed. And it will not disarm so long as Saddam Hussein holds power. 34. Now, in fact, none of these resolutions, taken singly or combined, can be made to read as authorizing military action by the United States, not on its own or with any number of allies, not in any imaginable circumstances in 2003 or at any time after 1991. You just have to read them to see for yourself. Resolution 678 of November 29, 1990 explicitly, if euphemistically, authorized the unilateral use of force, but it did so only for very specific purposes, none of which had any relevance to the war of 2003. Resolution 678 was the one that authorized the RST Gulf War. It was a brief resolution, following 11 previous ones dealing with the crisis that started with Iraq's invasion of Kuwait on August 2, 1990. It said that the Security Council 1. Demands that Iraq comply fully with Resolution 660 and all subsequent relevant resolutions, and decides while maintaining all its decisions, to allow Iraq one NAL opportunity, as a pause of goodwill, to do so. 2. Authorizes member states cooperating with the government of Kuwait, unless Iraq on or before January 15, 1991 fully implements, as set forth in paragraph 1 above, the above-mentioned resolutions, to use all necessary means to uphold and implement Resolution 660 and all subsequent relevant resolutions and to restore international peace and security in the area. Resolution 660, the one that the necessary means were supposed to enforce, was relatively short and had essentially 2 operative paragraphs. They said that the Security Council 13. 1. Condemns the Iraqi invasion of Kuwait. 2. Demands that Iraq withdraw immediately and unconditionally all its forces to the positions in which they were located on August 1, 1990. Resolution 678 said that all necessary means could also be used to enforce all subsequent relevant resolutions, but this could only help the United States in 2003 if it meant all future resolutions. In fact, the phrase specifically refers to the 10 listed resolutions passed between August 2 and November 28, 1990, specified in the preamble to 678 as the above-mentioned subsequent relevant resolutions. All of these resolutions had only one object, ending the invasion of Kuwait and all the behavior associated with it. Even the restoration of peace and security in the area was specifically restricted by the preamble, determining that there exists a breach of international peace and security as regards the Iraqi invasion of Kuwait. 35. It did not authorize any state to militarily and unilaterally enforce peace in the Middle East. The main thing to notice about Resolution 678 is that it specifically authorized both all necessary means and their unilateral deployment by individual member states. Many protested in 1990-1 that war was not necessary in the circumstances, meaning either that the use of force was invalid under the resolution, or the resolution itself was invalid as a breach of the Council's duty under the Charter to exhaust peaceful means. But nobody could doubt, and nobody has doubted, that all necessary means could include military force. The next thing to notice about Resolution 678 is that the authorization was expressly for a specific purpose, to eject Iraq from Kuwait. And since Iraq had definitively quit Kuwait on February 27, 1991, the resolution obviously had not the slightest relevance to justifying the war of 2003. The third thing to notice is that neither Resolution 678 nor any of the prior 11 said a word about weapons of mass destruction. That was up to Resolution 687 of April 3, 1991, the second resolution mentioned by President Bush in March 2003. Resolution 687 indeed imposed major disarmament obligations on Iraq, but it did not even suggest that any member state could enforce them through the use of force. Not all necessary means, not any means whatsoever. Quite the contrary, it said that a ceasefire would go into effect as soon as Iraq notified the UN of its acceptance of the terms of the resolution. Paragraph 33 declared that upon official notification by Iraq to the Secretary-General and to the Security Council of its acceptance of the above provisions, a formal ceasefire is effective between Iraq and Kuwait and 14. The member states cooperating with Kuwait in accordance with Resolution 678. 36. Iraq promptly gave this official notification, by letter of April 6, 1991 from its permanent representative at the UN to the President of the Security Council and the Secretary-General of the United Nations. The letter detailed Iraq's objections to the resolution, but it ended with an unequivocal, Iraq has no choice but to accept this resolution. 37. The ceasefire then went into effect. By paragraph 34 of the same resolution, the Security Council decided to remain seized of the matter and to take such further steps as may be required for the implementation of the present resolution and to secure peace and security in the region. Whence the inspections regime and the many other measures of the resolutions that followed, all of them lacking any hint that any member state could use military force in the event that Iraq did not comply. So neither 678 nor 687 could possibly be read to authorize the use of force in 2003 by the US and the UK. That leaves 1441 of November 8, 2002. Resolution 1441 made a lot of demands on Iraq, many completely unreasonable, given that the US and its client state Israel vastly outgun Iraq in weapons of mass destruction, however defined, and that Israel has vastly outdefied Iraq in the matter of Security Council resolutions. But Resolution 1441 did not say or even imply that any state or group of states could attack the country for failing to comply with any of those demands. Resolution 1441 said that the Security Council decides that Iraq has been and remains in material breach of its obligations under relevant resolutions, including Resolution 687, and that it decides to afford Iraq, by this resolution, a final opportunity to comply with its disarmament obligations under relevant resolutions of the Council, and accordingly decides to set up an enhanced inspection regime. It also said that non-compliance will be reported to the Council for assessment and directed the Security Council to convene immediately on receipt of the Weapons Inspector's report in order to consider the situation and the need for full compliance with all of the relevant Council resolutions. Resolution 1441 further recalls, in that context, that the Council has repeatedly warned Iraq it will face serious consequences as a result of its continued violations of its obligations. All these words were carefully chosen after alternative versions were picked over between October 2, 2002. When the Americans submitted their first draft, and November 8, when the final very different draft was passed. Their meaning is all too plain. The Security Council was serious about Iraqi compliance with its disarmament requirements, but it was the responsibility of the Security Council to decide whether and to what extent there had been 15. 16. Compliance, and what to do about it. That means the Security Council as an institution, all 15 members voting according to the rules written into the Charter of the United Nations, which require a majority of 9 for any action, with no vetoes from any of the 5 permanent members. What Resolution 1441 lacked, in other words, was any hint of authorization of unilateral military action, much less the explicit authorizes member states to use all necessary means found in 678. This was no slip. These very words were in the draft submitted by the U.S. to the members of the Council on October 2, 2002. 10 decides that false statements or omissions in the declaration submitted by Iraq to the Council and failure by Iraq at any time to comply and cooperate fully in accordance with the provisions laid out in this resolution, shall constitute a further material breach of Iraq's obligations, and that such breach authorizes member states to use all necessary means to restore international peace and security in the area. 38. But this draft was rejected, and the final, italicized words were nowhere to be found in 1441. 39. The Americans came back on October 25 with a formulation that omitted the objectionable words and concluded with shall constitute a further material breach of Iraq's obligations. 40. Even that was rejected by the other members of the Council, who insisted that the words and will be reported to the Council for assessment be added, making it clear that the Council itself would decide the consequences of any material breach. There was an attempt to make something out of the words material breach as they appear in an earlier part of 1441, decides that Iraq has been and remains in material breach of its obligations under relevant resolutions, including Resolution 687. Since 687 was the ceasefire resolution, some lawyers argued that the declaration in 1441 that Iraq was in material breach had the effect of releasing the United States from its ceasefire obligations under 687, as if it were a treaty. One big problem with this theory is that for a material breach to suspend a multilateral treaty, unanimous agreement by all the parties is required. The ceasefire of 1991 was not just between Iraq and America but between Iraq and all the forces aiding Kuwait, a coalition of 34 countries, among them many vocal opponents of the 2003 war, such as France, Germany, Saudi Arabia, and Syria. Nobody heard any of them saying that they wanted to rescind the ceasefire. 41. An even bigger problem with this theory is that it depends on an obviously willful misreading of Resolutions 1441 and 687. Resolution 1441 doesn't say that Iraq has been in material breach of the ceasefire conditions of 687, but rather its disarmament obligations under 687. The ceasefire conditions were quite distinct from the disarmament obligations themselves. They consisted only of the notification of Iraq's acceptance of the disarmament obligations. Ongoing compliance with the actual obligations was not made a condition of the ceasefire. This may sound like a quibble, but it is actually very important. The American argument depends on reading 687 to mean that a resumption of hostilities was to remain perpetually at the discretion of any party to the ceasefire, if they didn't think that Iraq was living up to its disarmament obligations. But 687 says the ceasefire will go into effect the moment Iraq says it agrees to the terms, and leaves it to the Security Council as a body to police those terms. The material breach theory wants us to assume that the Security Council used the wrong language to describe what it really wanted, namely to give any party the unilateral right to restart the war at any time, thus renouncing Council control over the question of war and peace. But the Security Council acts through resolutions, and we have the authority of no less a figure than George W. Bush himself for the importance of giving their words merit and weight. This is not only an important moment for the security of our nation, I believe it's an important moment for the Security Council itself. And the fundamental question facing the Security Council is, will its words mean anything? When the Security Council speaks, will the words have merit and weight? 42. Well said, Mr. President, but to give the Security Council's words merit and weight means concluding that 678, 687 and 1441 could not possibly be read as authorizing America's war. In fact, even the last, ill-fated resolution introduced by the US, UK and Spain in February 2003 could not be read as authorizing force, since it merely referred back to 1441 and declared, rather melodramatically, that Iraq has failed to take the final opportunity afforded to it in Resolution 1441. 43. But everybody knew what the Americans were going to try to do with these words if the resolution passed, and since the inspectors were calling for more time to carry out the job the Council had given them, France and Russia declared they would veto the resolution if it came to a vote. The sponsors then desperately tried to get a majority of the Council to agree, pretending the veto was unimportant. This, even though America exercises the veto more than all the other Security Council members put together, 76 out of a total of 138 vetoes since 1966. 44. Without the American veto, Israel would have been sanctioned long ago for violating dozens of Security Council resolutions over its 36 years of occupation of the Palestinian territories. Without the American veto, Boutros Ghali would not have been replaced by the more US-friendly Kofi Annan as Secretary General. 45. But not only did a majority in the Security Council elude the Americans on this resolution, when they finally backed out of the card-showing contest, the three sponsors had only been able to add Bulgaria to their list, for a grand total of 4 votes out of 15, and only 2 out of 5 veto-bearing permanent members. 46. The Americans are well known to international lawyers for trying to distort the words of resolutions, in order to claim to be acting on behalf of the international community. 47. Even before the war of 2003, they and the UK had been bombing Iraq, and killing Iraqis, for a decade to enforce self-declared no-fly zones in Iraqi territory under the supposed authority of Resolution 688 of April 5, 1991. But all that resolution did was innocently appeal to all member states and to all humanitarian organizations to contribute to humanitarian relief efforts being undertaken by the Secretary General. The American and British forces expanded this to the right to bomb any facilities capable of threatening their military flights over Iraqi territory. It was widely acknowledged that those attacks had no basis in the resolution, and the Bush administration strikes of early 2001 were protested by European NATO members. 48. All humanitarian pretext for this was dropped in the lead-up to the 2003 war when, as the inspections were being carried out, the bombing was clearly designed to soften up Iraqi defenses for the impending war, well before even the United States had declared that its diplomatic efforts had been exhausted. 49. The Americans engaged in the same resolution twisting in Afghanistan in 2001 and, before that, in Kosovo in 1999. In 1998, after obtaining a resolution on Iraq that clearly stopped short of authorizing the unilateral use of force to back up weapons inspections, they simply said, "We think it does," and bombed away 50. But where the law is concerned, it doesn't matter what they think, it's what the resolution actually says that matters. Everything turns on the elemental difference between means and ends. The Charter gives the Security Council a number of options short of military force to get its resolutions put into effect. In its resolutions, the Council very carefully delineates not only the ends but also the means. Then the Americans come in and argue that, whatever the means chosen by the Security Council, the US is free to use military force. They even write it into their domestic law, though they themselves take care to be very specific about means. The President is authorized to use the armed forces of the United States as he determines to be necessary and appropriate in order to enforce all relevant United Nations Security Council resolutions regarding Iraq. 51. And they do this pretending concern for the credibility of the Security Council. 52. Of course, if this were indeed the law, Any other country would have the same entitlement as the US to use military power, but, naturally, only to the extent they had it. Presumably, that's why the Americans like this theory so much more than everybody else does. The new American doctrine of self-defense holds similar attractions. Self-defense. In the absence of authorization from the Security Council, the United States had to try and squeeze its war into the inherent right of self-defense, a right that, under Article 51 of the Union Charter, allows the use of military force without Security Council approval. Bush put it simply in his press conference of March 6. Secondly, I'm content the American people understand that when it comes to our security, if we need to act, we will act, and we really don't need United Nations approval to do so. When it comes to our security, we really don't need anybody's permission. 53. The right of self-defense was central to the American justification for war in Afghanistan and is discussed in detail in Chapter 2. The problem with its use in the war against Iraq is that the notion of self-defense in international law, similar to the ordinary criminal law of any country, depends on there being an armed attack, either actual or demonstrably imminent, so that there is no alternative but to respond with force. Furthermore, the United Nations Charter, while preserving the right of self-defense, limits it to cases where the Security Council has not yet intervened and taken measures to restore international peace and security, the idea being that international disputes are to be settled peacefully if possible, and that it is up to the Security Council to seek those peaceful alternatives. The reasons for these limits are moral. Self-defense can justify the taking of life only where demonstrably necessary to save life. If there is a nonviolent alternative, it must be taken. Hence the role of the Security Council. The law only allows self-help where there is no time to seek a collective peaceful solution. Now the Americans knew that the accepted doctrine of self-defense under international law posed a problem for them if they wanted to invade Iraq, so as part of their war preparations they elaborated a new doctrine, which they called anticipatory and preemptive, but which Noam Chomsky has correctly pointed out is really preventive. 54. This was RST publicly elaborated in a speech given by President Bush in June 2002 to the West Point Military Academy graduating class. In that speech, Bush claimed the right to respond militarily to threats before they fully materialize. If we wait for threats to fully materialize, we will have waited too long. And our security will require all Americans to be forward-looking and resolute, to be ready for preemptive action when necessary to defend our liberty and to defend our lives. 55. In other words, not attacks, not even mere threats of attacks, but threats that haven't even fully materialized, potential threats. In September 2002, when Bush started to beat the war drums in earnest, the doctrine was elaborated in the so-called National Security Strategy of the United States. Our enemies have openly declared that they are seeking weapons of mass destruction, and evidence indicates that they are doing so with determination. And, as a matter of common sense and self-defense, America will act against such emerging threats before they are fully formed. The United States has long maintained the option of preemptive actions to counter a sufficient threat to our national security. The greater the threat, the greater is the risk of inaction, and the more compelling the case for taking anticipatory action to defend ourselves, even if uncertainty remains as to the time and place of the enemy's attack. 56. In his war speech of March 17, Bush said, "The danger is clear, using chemical, biological or, one day, nuclear weapons obtained with the help of Iraq, the terrorists could fulfill their stated ambitions and kill thousands or hundreds of thousands of innocent people in our country or any other. In 1 year, or 5 years, the power of Iraq to inflict harm on all free nations would be multiplied many times over. With these capabilities, Saddam Hussein and his terrorist allies could choose the moment of deadly conflict when they are strongest. We choose to meet that threat now where it arises, before it can appear suddenly in our skies and cities. The cause of peace requires all free nations to recognize new and undeniable realities. Terrorists and terrorist states do not reveal these threats with fair notice in formal declarations. and responding to such enemies only after they have struck first is not self-defense. It is suicide. 57. Not only did Bush provide no evidence that there was any action underway by Iraq to attack the United States or help others do so, or any plan to do so, he never even claimed this was the case. He claimed only that the fact that Iraq had such weapons made it a potential threat. One day, with the help of Iraq, the terrorists could fulfill, in 1 year, or VE years, these capabilities, could choose. Of course, evidence for the existence of the weapons was non-existent as well. The inspectors and the US Army turned up nothing. But even that was beside the point, because international law has never accepted and could never accept the legally and morally nonsensical doctrine Bush elaborated. There are two decisive reasons for this. Above all, the doctrine would justify the deliberate infliction of death and destruction on a massive scale where no evidence had been produced to show that this was necessary to prevent any broadly equivalent tragedy from befalling the people doing the inflicting. That would mean treating the lives of the people of the country attacked as less worthy of protection than the lives of the people of the attacking country, because it would displace all the risks onto them. To counter an unsubstantiated risk to the people of the attacking country, the people of the attacked country would be sentenced to death and destruction. You can imagine that international law cannot proceed on that assumption, even when the lives subject to the unsubstantiated risk are so precious as American lives. Secondly, the Bush doctrine is a disguise for the doctrine of might makes right so thin that a child could see through it, because it would also theoretically give every country the right to attack the US, but no means to do so. The US has threatened the world with weapons of mass destruction for about 60 years now, since it dropped the atomic bombs on the civilians of Hiroshima and Nagasaki. It has the world's largest cache of weapons of mass destruction, however you care to define them. In the wildest delusionary fantasies of the American administration, the capabilities of Iraq to threaten anybody were infinitesimal compared to the threats the US brandishes every day. There is no law or morality without universalizability, which means the US would have to recognize the right of any country to act preventively against the US itself, and you won't find that in any of President Bush's speeches. So self-defense was not available here. Humanitarian intervention. Though Iraqi freedom gave the operation its name, the object of freeing Iraqis came a distant third in the arguments of President Bush for the invasion. In his penultimate war speech of March 6, Bush said the world needs him to answer a single question: has the Iraqi regime fully and unconditionally disarmed, as required by Resolution 1441, or has it not? 58. Bush did not say, has the Iraqi regime stopped oppressing its people? On the other hand, he pledged, in the event of war, to protect innocent lives, bring food and medicine and, finally, to help that nation to build a just government after decades of brutal dictatorship. The form and leadership of that government is for the Iraqi people to choose. Anything they choose will be better than the misery and torture and murder they have known under Saddam Hussein. We will be changing the regime of Iraq for the good of the Iraqi people. In his March 17 speech, Bush promised Iraqis, we will tear down the apparatus of terror and we will help you to build a new Iraq that is prosperous and free. In free Iraq there will be no more wars of aggression against your neighbors, no more poison factories, no more executions of dissidents, no more torture chambers and rape rooms. The tyrant will soon be gone. The day of your liberation is near. 59. Despite its low ranking in pre-invasion justifications for war, after the occupation turned up no evidence of weapons of mass destruction, the liberation of Iraq became the main ex post facto argument for war. When mass graves dating from the first Gulf War started to be uncovered, Thomas Friedman wrote in the New York Times, as far as I'm concerned, we do not need to find any weapons of mass destruction to justify this war. That skull, and the thousands more that will be unearthed, are enough for me. Mr. Bush doesn't owe the world any explanation for missing chemical weapons. It is clear that in ending Saddam's tyranny, a huge human engine for mass destruction has been broken. The thing about Saddam's reign is that when you look at that skull, You don't even know what period it came from, his suppression of the Kurds or the Shiites, his insane wars with Iran and Kuwait, or just his daily brutality. 60. When Tony Blair, under attack at home for misleading the British public on the weapons question, journeyed to Washington to be honored by the U.S. Congress, his fallback was the same. Can we be sure that terrorism and weapons of mass destruction will join together? Let us say one thing: if we are wrong, we will have destroyed a threat that, at its least, is responsible for inhuman carnage and suffering. That is something I am confident history will forgive. 61. Humanitarian intervention by military force was an important theme in the 1999 Kosovo War, and its legal status is discussed in detail in Chapter 3. To briefly anticipate that discussion, the main reason a claim of humanitarian intervention could never succeed in the Iraq War is that, as usual, what the Americans were claiming was a unilateral right of humanitarian intervention, whereas, if the right exists at all in international law, it exists only as a collective right, that is, one that can only be authorized by the Security Council, and, as we've just seen, the Security Council did not authorize this war. The obvious reason for restricting military intervention for humanitarian reasons to cases authorized by the Security Council is to give some assurance that it is not being abused to disguise aggressive war, which is exactly the use the Nazis made of it to justify the invasion of Poland that launched World War II. The drafters of the UN Charter had this and many other examples before their eyes when they gave the Security Council the exclusive responsibility for authorizing non-defensive wars. There are indeed some proponents of a unilateral right to military intervention for humanitarian reasons, but, as the discussion in Chapter 3 will show, they are few and on virtually non-existent legal ground. And even these proponents lay down conditions that the Americans could never have hoped to meet in the case of Iraq. First, there is the question of motivation. The US made it very clear that it would never have invaded Iraq purely to defend the human rights of its people. This was stated explicitly in the speeches of George W. Bush, and most succinctly by Secretary of Defense Donald Rumsfeld during his Iraq victory tour. Our coalition came to Iraq for a purpose: to remove a regime that oppressed your people and threatened ours. 62. In other words, Saddam Hussein could have gone on oppressing his own people forever as far as the Americans were concerned, as long as he was not regarded as a threat to the American people, or, more frankly, their interests. Now, according to the advocates of unilateral humanitarian intervention, mixed motives are acceptable, as long as the non-humanitarian ones don't interfere with the humanitarian ones. Collateral non-humanitarian motives should be such as to not impair or reduce the first paramount human rights objective of the intervention. 63. But there is plenty to show that the non-humanitarian motives for this war overwhelmed any incidental humanitarian ones. In the first place, the US and the UK seem to have made no plans whatever to actually care for the needs of the Iraqis once they had conquered the country. Though they made sure everything having to do with the oil industry and the secrets of the regime was secure, they evidently couldn't have cared less about the plundering of infrastructure and heritage that occurred under their noses. Robert Fisk reported the following from Baghdad. After days of arson and pillage, here's a short but revealing scorecard. US troops have sat back and allowed mobs to wreck and then burn the Ministry of Planning, the Ministry of Education, the Ministry of Irrigation, the Ministry of Trade, the Ministry of Industry, the Ministry of Foreign Affairs, the Ministry of Culture and the Ministry of Information. They did nothing to prevent looters from destroying priceless treasures of Iraq's history in the Baghdad Archaeological Museum and in the museum in the northern city of Mosul, or from looting 3 hospitals. The Americans have, though, put hundreds of troops inside 2 Iraqi ministries that remain untouched and untouchable because tanks and armored personnel carriers and Humvees have been placed inside and outside both institutions. And which ministries proved to be so important for the Americans? Why, the Ministry of Interior, of course, with its vast wealth of intelligence information on Iraq, and the Ministry of Oil. 64. 1 month after the war was declared won, the press was echoing human rights groups and reporting a descent into lawlessness and chaos, and the plundering of government property, often under the eyes of American soldiers. Most government ministries have been gutted. 65 According to the advocates of unilateral military humanitarian intervention, the final test will be whether human rights have been effectively restored as a result of the intervention. 66 But as the occupation wore on, it seemed that human rights had actually been worsened by the invasion, even taking into account the end of the Saddam Hussein regime. In the war's immediate aftermath, UNICEF reported that child malnutrition in Baghdad had almost doubled since before the war. 67 Iraqi doctors were reporting an increase in infant mortality from the lack of clean drinking water, due to the unrested electricity. 68 In one ghastly event, a nuclear power facility was looted for barrels by thirsty villagers who dumped their radioactive waste and used them to carry drinking water. 69 In September, the Iraqi Governing Council said it would be 2 years before electricity was back to pre-occupation levels if someone came up with $8 billion. 70 And even that did not take into account the sabotage that was still blacking out the country in November. And electricity, as one Baghdad merchant pointed out, means safety. It's the chain of life. 71 In Baghdad, the murder rate appeared to have increased to 10 times its pre-war level, even before the car bombings started. 72 A Gallup poll of September 2003 reported that 94% of Baghdadis still considered the city a more dangerous place than before the invasion. 73 Another reason the Iraq War would fail as a humanitarian intervention is because of the premium naturally placed by the theory on the right of self-government. President Bush had promised that the form and leadership of government is for the Iraqi people to choose. Anything they choose will be better than the misery and torture and murder they have known under Saddam Hussein. But that promise was quickly broken. As soon as the extent of opposition to the occupation became clear, plans for elections of an interim government were replaced by consultations for an appointed governing council, ultimately chosen by the staff of American Civil Administrator L. Paul Bremer III, also referred to in the press as Viceroy, who would have veto powers over any significant decisions. 75 In calling a halt to even local elections, Bremer declared that he was not opposed to. I want to do it in a way that takes care of our concerns. 76 The question of how long the coalition would stay in Iraq depended only in part on how quickly the Iraqi people can write and approve a constitution. 77 When the governing council quickly proved to be a farce that, most importantly, failed to give any legitimacy to the occupation, the Americans decided to dump it and demote the constitution writing process to an interim one. Instead, there would be an Afghanistan-style assembly in June 2004, which would elect a provisional government, but there would be no actual elections, and the Americans would have an effective veto, via the governing council, over the choice of delegates to the assembly. The plan, immediately denounced by the Shiites, was explicitly part of a longer, not shorter, exit strategy, and any new government was expected to invite the U.S. troops to stay. 78 Also relevant in judging this war as a humanitarian intervention was American complicity in the oppressiveness of the Iraqi regime. 79 Complicity argues against a right to a humanitarian intervention on a number of grounds. It speaks to the sincerity of the motives, and above all it speaks to the crucial question of the necessity of the intervention. If the Americans were a big part of the problem, then non-military means of improving the lives of Iraqis were in their own hands. Thus, the relevance of all the reminders during the build-up to the war of how much the U.S. had to do with what Iraq had become, starting with its support for the disastrous Iran-Iraq War of 1980-8. America played both sides of that war to some extent, but mainly kept it going by being a very helpful ally to the regime of Saddam Hussein, providing crucial economic, military, and diplomatic support. The costs to both sides were enormous. A median estimate is about 800,000 dead. 80 The atrocities that have since been laid at the feet of Saddam Hussein, the wartime gas attacks against Iran and the Anfal campaign against the Kurds, now fatuously used by presidents and journalists to justify the war of 2003, were committed when the U.S. was Saddam's good friend and benefactor, with a younger Donald Rumsfeld as the U.S. emissary. 81 In those days the American attitude was it was just another way of killing people, whether with a bullet or phosgene, it didn't make any difference. 82 The Iran-Iraq War was followed by the probably pretextual and certainly wildly excessive Gulf War. 83 A median estimate puts the Iraqi dead at 80,000 to 85,000, including about 3,000 civilians. 84 Civilian life support systems were devastated. Then came the separatist uprising of Kurds and Shia, famously encouraged but not aided by the Americans, which led to brutal reprisals, the results of which were being unearthed in 2003 as justification for the latest war. This was followed by the pseudo-humanitarian bombing campaign of the US and the UK, with its regular toll of civilian death, lasting through 3 American presidencies. 85 Above all, there were the sanctions. Unlike the bombing, the sanctions had the explicit authorization of the Security Council, having been put in place before the attack that expelled Iraq from Kuwait. But they were maintained for 12 years by the veto power of the United States and enforced by its military and economic muscle. Though they gave the appearance of being renewed periodically by consent of the whole Security Council, what were actually renewed were the time-limited exceptions that allowed Iraq to sell some of its oil for food and other humanitarian supplies. Without these renewals, the blanket sanctions imposed in 1990 would have sprung back into effect. It was the US alone that was responsible for the maintenance of the sanctions regime. 86 Already in 1991, then Secretary General Perez de Cuellar, in an often quoted speech on humanitarian intervention, was warning that the primary victims of economic sanctions in developing countries are the most vulnerable sections of the affected population, women and children, the poor and the infirm. 87 In Iraq it was the children who were hit hardest. In 1996 UNICEF reported that 4,500 children under the age of 5 were dying monthly in Iraq from malnutrition, polluted water and lack of medicine, all traceable to the destruction that occurred during the war and the sanctions that made it impossible to restore sanitary and health services. 88 The UNICEF report put pressure on the US to ease the sanctions somewhat to allow a limited oil for food program in which Iraq was allowed to sell a small amount of its oil. But even with these limits eased, the devastation of the Iraqi economy by the sanctions was such that UNICEF reported a rate of infant mortality in 1999 that was still double what it had been before the war. The death rate for children under 5 had risen to 131 per 1,000, from 56 per 1,000 before the economic sanctions. Infants less than 1 year old were now dying at a rate of 108 per 1,000, up from 47 per 1,000. 89 By 2001, America's NATO allies were publicly stating their disgust at the sanctions. 90 Tariq Ali wrote of them in 2000, Clinton and Blair are personally responsible for deaths of hundreds of thousands of small children, callously slaughtered to save their joint credibility. Since without America and Britain, the blockade would have been lifted long ago, the role of other Western leaders, craven though it is, need not be reckoned. 91 The US and the UK tried to blame the effect of the sanctions on the spending habits of the government, Saddam's palaces, but even those who believed that the primary responsibility for this disaster is Saddam's had to admit that the UN, an increasingly divided UN we should add, has become a secondary perpetuator of it. 92 In this case divided meant the US and the UK against the rest. And the simple fact is that, without these sanctions, those children would not be dead. The American-led embargo, wrote John Pilger in opposition to America's humanitarian war of 2003, was every bit as barbaric as the dictatorship over which Iraqis have no control. 93 The first act of the Iraqi Governing Council chosen by Bremer's staff was to declare the American overthrow of the Saddam Hussein regime a national holiday. 94 Even those who opposed the occupation, the great majority of Iraqis by every indication, even some of those who opposed it violently, were happy to see Saddam gone, and if not Saddam, then at least the sanctions. 95 But, given American complicity in the brutality of this regime, to justify the invasion on this account would be like the guy who hit his head with a hammer because it felt so good when he stopped. If America really had the human rights of Iraqis at heart and did not merely want, as Pilger argued, a more compliant thug to run the world's second greatest source of oil, it would have done things very differently. It would have worked through and not against the United Nations, and its first order of business would have been to lift the sanctions and end Iraq's isolation. It would have sought peaceful means to rebuild prosperity and human rights in Iraq on the basis of the country's enormous natural wealth and advanced level of development. This is called engagement when there is no ulterior motive for going to war. It is difficult to imagine how military action could ever sincerely have been thought useful to the people of Iraq, given the horrifying costs and the quagmire that had to be entailed by the sudden overthrow, by foreign armies, of a strong government firmly based in the country's traditional ruling group, even if that government was hated by the rest of the country. No problem of political and social structure, in the Middle East or elsewhere, can be resolved by a war, wrote Italian journalist Rossana Rossenda the day after the attack on Italian military headquarters that left 19 Italians and 13 Iraqis dead. To the contrary, it can only make matters worse. 96. This simple proposition is so widely understood that the US would not have had a prayer making the case for war to even its own people, let alone the UN, if it had argued on exclusively humanitarian grounds beforehand. But a sincere humanitarian war, if such a thing were even imaginable, would have been rather more painstakingly prepared, one imagines, with a view to ensuring that post-war Iraq was indeed a better place to live for the Iraqis who survived it. It would have to have been a whole lot better to justify these costs. Even the legal ideologists of humanitarian war say it should be permissible only in the face of ongoing or imminent genocide, or comparable mass slaughter or loss of life, something nobody claimed was the case with Iraq. 97. In other words, a humanitarian war would not have squandered tens of thousands of lives to punish a regime for atrocities far in the past or as an exercise in wishful thinking for the future. Iraq is a good example of why the law does not accept unilateral humanitarian intervention under any circumstances, a matter explored fully in Chapter 3. That America's war on Iraq was a flagrant violation of the Charter of the United Nations was implicitly corroborated by the pundits who thought it appropriate to conclude from it that the fundamental legal prohibitions in the Charter on making war were no longer valid. It is hard to avoid the conclusion that the Charter provisions governing use of force are simply no longer regarded as binding international law. 98. But what would that leave of a treaty whose very first commitment is to save succeeding generations from the scourge of war? So others have concluded that it is the United Nations Charter itself that is no longer valid, that it has gone the way of the Covenant of the League of Nations. 99. Pentagon guru Richard Pearl drew this conclusion and thanked God for it. 100. This may all be a bit premature, of course, and even wishful thinking on the warmongers' part, but even if it were true, it would take nothing of significance away from the supreme criminality of this war or America's other aggressive wars. The Nuremberg judgment pre-existed the Charter, and it was based on a moral logic that cannot be refuted by the mere fact of supreme criminals going unpunished. Murder is still murder, even if America manages to get away with it. What the meaning is of an international criminal law that systematically lets them get away with it is a more complicated question. On February 4, 2002, American forces in Afghanistan killed Daraz Khan because he was tall. They killed him, and 2 other Afghan villagers who happened to be with him hunting for scrap metal, with a Hellfire missile launched from a pilotless Predator drone. They did it on the off chance that, because he was tall, he might have been Osama bin Laden. Daraz Khan and his friends together left a dozen wives and children to mourn them. In late May, 6-year-old Zarguna was killed while she was trying to hide during an attack on her village near Kandahar by American and Canadian forces acting on incorrect information that there were senior Taliban and Al-Qaeda officials there. The Americans nevertheless considered the raid a success because they managed to kill one 70-year-old supporter of Taliban leader Mullah Omar II earlier in the war. On October 18, 2001, the village of Bibi Maru on the outskirts of Kabul was hit by an American precision 500-pound bomb. It killed Gul Ahmed, 40, a Hazara carpet weaver, his second wife Seema, 35, their 5 daughters and his son by his first wife, as well as 2 children living next door. We buried them together in the graveyard. We divided it with separate gravestones, but their bodies were all in pieces, said Mr. Ahmed's first wife, who was living in another village at the time of the bombing. None of these incidents even made it into a New York Times review of the principal sites where American bombs killed Afghan civilians: Gardez, Khost and Zanikal, Madu and Kanai Mujahideen, Asmani and Pokhara, Nizakala, and Kakrok. For America launched a ferocious war on Afghanistan in October 2001 that took a conservatively estimated 20,000 lives in its RST 6 months, about half of them non-combatant men, women, and children. By March 2002 the war had already seen 22,000 bombs dropped and missiles read, of both the smart and dumb variety. These included cluster bombs that spread lethal yellow bomblets, many of which did not explode when dropped, and just lay around to kill and maim civilians who easily mistook them for the food packets of the same color, that the Americans dropped at the same time. The war also saw important military innovations, from the historic RST use of pilotless Predator aircraft and their Hellray missiles, like the one that killed Daraz Khan, to bunker busters that could penetrate caves and kill troops where they hid or slept, and daisy cutters, 15,000-pound bombs pushed out the back of transport planes to oat down on parachutes and incinerate everything within 500 meters of the blast. These weapons were rained down on cities and villages and anywhere else the Taliban might be, or where rival warlords settling scores claimed they were, on power plants and even food depots, because the Taliban might take the food. 5. By the end of July 2002, civilians directly killed in Afghanistan by the American bombing probably numbered between 3,125 and 3,620. This was the number University of New Hampshire economics professor Mark Harold derived in the most thoroughly documented and best argued study available. 6. The American Project on Defense Alternatives made a more conservative estimate of between 1,000 and 1,300. 7. But they added that at least 3,000 civilians on top of this were killed through disease, exposure, and the disruption of aid. This latter figure was certainly an underestimate. An article from the New York Times tells the story of one tiny region, Abulgan, isolated by the fighting, where in just 3 villages 600 people were known to have died from malnutrition and lack of medicine. These are just 3 villages out of 55. The total number of dead over the last few months has to run into the thousands. 8. The British Guardian newspaper conservatively estimated that the civilian deaths caused indirectly by the war, not by the bombs alone, but by starvation, disease, and exposure. Afghanistan was already on a lifeline, and for 3 months we cut the line, amounted to between 10,000 and 20,000. 9. The killing of civilians did not stop with the overthrow of the Taliban and the installation of a new Afghan government, because U.S. troops continued to meet armed opposition. In July 2002, an American AC-130 Spectre gunship attacked a Pashtun village with cannon fire, killing at least 54, mostly women and children, and wounding more than 120. An entire wedding party of 25 was wiped out. 10. Afghan and Iraqi collateral damage started to overlap in April 2003 when American forces still fighting in Afghanistan killed 11 members of one family during a skirmish near the Pakistan border, even as their colleagues were in the process of conquering Baghdad. 11. It continued to do so throughout the year. 12. Even though they were not given prole in the New York Times, each one of these lives was just as precious to the dead, their loved ones and dependents as the 3,000 killed in New York, Washington and Pennsylvania on September 11, 2001, as were the lives of 10,000 or so Taliban guerrillas killed in combat or as prisoners, as well as 600 Afghan allies of the U.S. 13. The Taliban and Northern Alliance guerrillas also killed hundreds of civilians during the attack. Looting, raping and killing by the triumphant Northern Alliance made tens of thousands of Pashtuns refugees and continued well into 2002. 14. U.S. losses amounted to about 30, of which 12 were incurred on the battlefield. Michael E. O'Hanlon of the American Brookings Institution called the war a masterpiece of military creativity and ness that caused relatively modest harm to innocents, characterizing 1,000 civilian deaths from bombing as a mercifully low number. The only real failings of the war, to his mind, were in not capturing or killing Osama bin Laden and the image problem of violating the Geneva Conventions on the treatment of prisoners of war. 15 We can all marvel at the ability of Americans to rage and weep over 3,000 deaths from a single attack while deeming the death from their own incessant bombings of even 1,000 souls as relatively modest harm, but this point has been made over and over. The point I want to make here is that these events, like similar ones in Yugoslavia before and Iraq afterwards, constitute not only tragedies, but crimes, very serious crimes, in fact supreme international crimes and mass murder by the individual leaders of the United States and its allies. These were the same people who would repeat their crimes in Iraq, plus some who would not come along for the ride in Iraq, and those who devised and executed the military strategy, such as General Tommy Franks, and so on down the line. That the U.S. image problem should arise, not from this mass murder of civilians, but from the comparatively minor, if blatant, violation of the Geneva Conventions in failing to afford prisoner of war status to captured enemy fighters, is testimony only to the loyalty of the American mass media. But there is no point in calling for the Bushes and the Rumsfelds of the world to be hauled in front of some international criminal court, like Slobodan Milosevic, because everything there is to know about international law shows us they won't be, not for Afghanistan and not for Iraq. The Americans argue that the simple explanation for this is the world of moral and legal difference between what they do and what real criminals do. Justice, after all, is not only treating like cases alike, but also treating different cases differently. They argue that the war in Afghanistan was, like the others, in self-defense and in full respect of international law. They argue that they, unlike their enemies, always aim to prevent and minimize human suffering, that collateral damage, though regrettable, is not criminal. They even argue that the war in Afghanistan, like the wars in Iraq and Yugoslavia, was, in part, a humanitarian intervention, in this case to overthrow the odious Taliban regime of fundamentalist women haters. 17 But this is what the Revolutionary Association of the Women of Afghanistan says. They're the women who risked their lives to expose the crimes of the Taliban and were celebrated in the American media for doing so. 18 Here's what they said of American humanitarianism on September 14, 2001, 19. On September 11, 2001, the world was stunned with the horrific terrorist attacks on the United States. RAWA stands with the rest of the world in expressing our sorrow and condemnation for this barbaric act of violence and terror. But unfortunately we must say that it was the government of the United States who supported Pakistani dictator Gen. Zia-ul-Haq in creating thousands of religious schools from which the germs of Taliban emerged. If it is established that the suspects of the terrorist attacks are outside the U.S., our constant claim that fundamentalist terrorists would devour their creators, is proved once more. The U.S. should stop supporting Afghan terrorists and their supporters once and for all. Now that the Taliban and Osama are the prime suspects by the U.S. op jails after the criminal attacks, will the U.S. subject Afghanistan to a military attack similar to the one in 1998 and kill thousands of innocent Afghans for the crimes committed by the Taliban and Osama? On October 11, 2001, they said this. America, by forming an international coalition against Osama and his Taliban collaborators and in retaliation for the September 11 terrorist attacks, has launched a vast aggression on our country. Despite the claim of the U.S. that only military and terrorist bases of the Taliban and Al-Qaeda will be struck and that its actions would be accurately targeted and proportionate, we have witnessed for the past 7 days leaves no doubt that this invasion will shed the blood of numerous women, men, children, young and old of our country. On December 10, 2001 RAWA issued this statement. The people of the world need to know the Northern Alliance criminals. These are the very people who immediately upon usurping power, proclaimed, amongst other sordid restrictions, the compulsory veiling of all women. The people of the world need to know that in terms of widespread raping of girls and women from ages 7 to 70, the track record of the Taliban can in no way stand up against that of these very same Northern Alliance associates. If the United Nations is sincerely concerned in regard to the independence, unity, and democratization of Afghanistan, it must under no name or pretext continue its support to the Northern Alliance and swiftly and unequivocally condemn and punish any country which tries to supply funds and arms to these murderers. In other words, according to these Afghan women, it was the Americans' own fault that September 11 happened. The U.S. war against Afghanistan was aggressive and not defensive. The civilian deaths were to be expected, and the government installed to replace the Taliban was as bad as, if not worse than, what it replaced. As far as can be ascertained, most of the world's people agreed with RAWA's opposition to the war. According to an Ipsos Reid poll of December 21, 2001, only the people of the rich countries of the G7 supported the war, while the rest of the world opposed it. 20 That the world believed the war in Afghanistan was wrong, however, did not make it any more a crime deserving of punishment than it did in Yugoslavia or Iraq. It also had to be illegal. Was it? The grounds for a lawful use of military force by one state against another were outlined in Chapter 1. It must either be validly authorized by the Security Council of the United Nations, or it must fall within the strictly limited inherent right of self-defense. Was the attack on Afghanistan authorized by the Security Council? The Security Council passed 2 unanimous resolutions on terrorism between September 11, 2001 and America's attack on Afghanistan on October 7, SCR 1368 of September 12 and SCR 1373 of September 28. The argument that these resolutions authorized the Americans to attack Afghanistan cannot withstand a simple reading of the resolutions themselves, which contain not even an implicit authorization of war on Afghanistan. The resolutions condemned the attacks of September 11 and took a whole host of measures to suppress terrorism. Resolution 1373 has 24 operative paragraphs outlining legislative, administrative, and judicial measures for the suppression of terrorism and its financing, and for cooperation between states in security, intelligence investigations, and criminal proceedings. The resolution sets up a committee of all its members to monitor progress on the measures in the resolution, and gives all states 90 days to report back to it. But military force? Not once does either of these resolutions mention military force or anything like it. They don't even mention Afghanistan by name. Nor do they use the fateful euphemism "all necessary means," contained in the RST Gulf War Resolution 678 of November 29, 1990, discussed in Chapter 1. Defenders of the war tried to cut and paste the words of these resolutions to make it seem like they authorized force, just as they would in Iraq in 2003, but their efforts can only be regarded as fraudulent. For instance, the words "to combat by all means threats to international peace and security caused by terrorist acts and to take all necessary steps to respond to the terrorist attacks" were emphasized. These words do indeed appear in Resolution 1368, but only as things the Security Council is determined and ready to do by the non-military means outlined in the resolution, with further measures perhaps to be specified in the future. The Security Council, determined to combat by all means threats to international peace and security caused by terrorist acts. 1. Unequivocally condemns. 5. Expresses its readiness to take all necessary steps to respond to the terrorist attacks. 6. Decides to remain seized of the matter. Similarly, defenders of the war pointed out that, in Resolution 1373, the Security Council decides also, that all states shall take the necessary steps to prevent the commission of terrorist acts, as if there were nothing else in the sentence or the resolution. But the complete sentence reads, "take the necessary steps to prevent the commission of terrorist acts, including by provision of early warning to other states by exchange of information." The provision of early warning is not generally taken to include an invasion. and in the rest of the resolution, all sorts of necessary means are specified except military force. Did they just forget? So this was just another case, like Iraq, of the Americans trying to distort the words of resolutions, in order to claim to be acting on behalf of the international community. 21. They seem to count on nobody actually reading the resolutions themselves. Afghanistan was different from Iraq, though. The Security Council resolutions were passed in the immediate aftermath of the shocking attacks on New York and Washington, and the war followed before a month had passed. Thus the claim of self-defense had a superficial plausibility that the war against Iraq lacked. This was reacted in the resolutions of September 2001, particularly in one much-discussed paragraph of the preamble to each of them. Recognizing the inherent right of individual or collective self-defense in accordance with the Charter. This is indeed suggestive. It suggests support for military action by the U.S. at a time when Afghanistan was an obvious target. But a mere suggestion of support is a far cry from an authorization. Authorization is a legal act, and the Security Council knows how to do that when it wants to, and how not to do it. An example of how to do it is the case of Iraq's invasion of Kuwait. There, the Council affirmed the right of self-defense to occupied Kuwait in the most unequivocally focused way. Affirming the inherent right of individual or collective self-defense, in response to the armed attack by Iraq against Kuwait, in accordance with Article 51 of the Charter, 22. That was in August 1990, 4 days into the invasion. It was the second of 12 resolutions that explicitly authorized everything from diplomacy to sanctions to the threat of war crimes prosecutions, but not military force. Not at least until the very last one on November 29, which was short and to the point. Resolution 678 had only VE operative paragraphs, the central one of which authorizes member states to use all necessary means to uphold and implement relevant resolutions and to restore international peace and security in the area. Here was a resolution that did nothing but authorize the use of force, while the September 2001 resolutions, with their non-committal preambulatory invocations of the right to self-defense, authorized everything but the use of force. So anyone who can read can see that the passages in the preambles to the September 2001 resolutions are clearly only a non-committal recognition of a legal right that exists even without the recognizing. For all these passages say, it could be Afghanistan that had the right to attack the United States. The legality of the war depended not on the resolutions, but entirely on the only other way to justify the use of military force, the inherent right of self-defense itself, in other words, on whether the attack did within that right, something on which the resolutions take no position whatsoever. By virtue of the veto, nothing can get into a Security Council resolution without the consent of the United States, but the wording also has to satisfy a majority of the other members, including the other 4 with vetoes. For the U.S., treating this as a matter of self-defense and not as Security Council authorization would have had the distinct advantage of taking its actions outside all formal supervision or control by the United Nations. The inherent right to self-defense is the unilateral one. Being non-specific about the target of self-defense would also TUS designs, clearly expressed in President Bush's speeches, to spread this war far beyond Afghanistan. Before the Iraq ASCO of 2003, it was assumed, because of its powerful means of persuasion, that the U.S. could generally get its way with the other members of the Security Council. Mahajan argued that, in the extraordinary circumstances following September 11, we had to assume that the U.S. could have obtained Security Council authorization for war if it had wanted. 23 But such speculations have to be revised after March 2003. Authorizing an attack on Afghanistan, even in the circumstances of September 2001, would have been a grave breach of the Security Council's duties to seek, above all, the peaceful resolution of threats to peace. In fact, it's unlikely that the Security Council would have been willing to go further than this non-committal preamble, because granting the U.S. the carte blanche it has since claimed would have constituted a major leap into the unknown for traditional rivals Russia and China, and even for traditional ally France. So if the preamble suited the US, it also let the other members of the Security Council off the hook, because it left everything to be decided by the inherent right to self-defense, as if the resolution had never been passed. But the inherent right of self-defense has very stringent requirements which absolutely ruled out the attack on Afghanistan. The requirements all stem from the fact that the resort to military force, with its terrible, irreversible costs, has to be necessary, and demonstrably so. It is not enough that there be a threat to a state's safety, there must also be no plausible, effective, non-military solution to the threat, or at least there must be such urgency for a military response that there is no time to explore non-military alternatives. And the extent of the response has to be measured, so that it is no more than necessary in the circumstances to meet the threat. This makes absolute moral sense. It is in fact impossible to imagine any other rule consistent with respect for humanity. Given the inevitable loss of life and limb, not to mention innocent life and limb, unnecessary wars are an abomination. And all of this has to be demonstrable in the light of day, it can't just be claimed, that is what makes it legal and not merely rhetorical. This has been the law of the inherent right of self-defense for more than 150 years. It was formulated by the American government itself in the Caroline case of 1841 to justify U.S. rejection of a British claim to self-defense in an attack on an American naval vessel. The British were attempting to obtain the release of a British subject charged with the murder of U.S. citizens in the attack, murder, notice, not a violation of the laws and customs of war. U.S. Secretary of State Daniel Webster, in his letter to the British government of April 24, 1841, laid down what he thought the British would have to show to make out the case for self-defense. A necessity of self-defense, instant, overwhelming, leaving no choice of means, and no moment for deliberation, that did nothing unreasonable or excessive, since the act, justified by the necessity of self-defense, must be limited by that necessity, and kept clearly within it. It must be shown that admonition or remonstrance was impracticable, or would have been unavailing, that there could be no attempt at discrimination between the innocent and the guilty, that there was a necessity, present and inevitable, for attacking in the darkness of night, while unarmed men were asleep on board, killing some and wounding others, setting her on and, careless to know whether there might be in her the innocent with the guilty, or the living with the dead. Committing her to a fate which lls the imagination with horror. A necessity for all this, the government of the United States cannot believe to have existed. 24. This rule has never been questioned. It was even applied by the Nuremberg Tribunal in 1946 to reject the Nazi claim that their invasion of Norway was in self-defense. The defense that has been made here is that Germany was compelled to attack Norway to forestall an Allied invasion, and her action was therefore preventive. It must be remembered that preventive action in foreign territory is justified only in case of an instant and overwhelming necessity for self-defense, leaving no choice of means, and no moment for deliberation. It is clear that when the plans for an attack on Norway were being made, they were not made for the purpose of forestalling an imminent Allied landing, but, at the most, that they might prevent an Allied occupation at some future date. It was further argued that Germany alone could decide whether preventive action was a necessity, and that in making her decision final judgment was conclusive. But whether action taken under the claim of self-defense was in fact aggressive or defensive must ultimately be subject to investigation and adjudication if international law is ever to be enforced. 25. The same principles were applied in 1986 by the International Court of Justice to reject the American claim of self-defense in an attempted justification of the U.S. terror campaign against Sandinista Nicaragua, which included bombing it, mining its harbors and supporting the counter-revolutionary Contras in a civil war that took tens of thousands of lives. The U.S. claimed its military activities against Nicaragua were an exercise in collective self-defense. But, according to the court, the American actions lacked proof of necessity. Thus it was possible to eliminate the main danger to the Salvadorian government without the United States embarking on activities in and against Nicaragua. Accordingly, it cannot be held that these activities were undertaken in the light of necessity. The court cannot regard the United States activities, that is, those relating to the mining of the Nicaraguan ports and the attacks on ports, oil installations, etc., as satisfying that criterion. 26. Reading this case after the attack on Afghanistan is like déjà vu, because the American argument for military force in the case was that the Nicaraguan government was allowing insurgents from El Salvador to operate from its territory, that is, harboring them. But the court held that, for self-defense to justify an attack upon a state, that state had to be involved in the attack itself, more than by merely harboring the attackers. For the purposes of the law of self-defense, an armed attack required either the sending by or on behalf of a state of armed bands, groups, irregulars, or mercenaries, which carry out acts of armed force against another state, or its substantial involvement therein. But the court does not believe that the concept of armed attack includes assistance to rebels in the form of provision of weapons or logistical or other support. 27. The point is, simply, that if it was not the government of the state that was carrying out the attack, there might be an alternative for preventing further attacks other than war against that state, with the inevitable bloody consequences for civilians and soldiers alike. The international law of self-defense is the same as the domestic law of self-defense, which does not allow somebody who has been attacked to chase the attacker, 6 guns blazing, into somebody else's crowded house, or to burn the house to the ground with everybody inside because the owners may have been sheltering the attacker. These were the conditions of the inherent right to self-defense before the Charter of the United Nations existed. The Charter reinforces them and even adds others. Article 33, for example, requires that the parties to any dispute shall, rst of all, seek a solution by peaceful means such as negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, and so on. Article 51 denies self-defense as a temporary right that subsists only until the Security Council intervenes. Nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations, until the Security Council has taken measures necessary to maintain international peace and security. The article adds that actions by members in the exercise of the right of self-defense shall not in any way affect the authority and responsibility of the Security Council, to take at any time such action as it deems necessary in order to maintain or restore international peace and security. The point of the article is clearly to recognize an attacked state's right to repel the attack, but to leave anything other than immediate solutions to the Security Council. It underlines the rigorous legal distinction between self-defense and reprisal. 28 Like domestic law, international law allows you to defend yourself when the law is not around, but it does not allow you to take the law into your own hands. Now, it has been argued that this article must mean that the right of self-defense persists until the measures taken by the Security Council have actually succeeded in restoring international peace and security. Otherwise, it is said, we would have the absurd position of a state being at the mercy of an aggressor just because the Security Council took some measures, even though they were clearly inadequate, or measures that were adequate but needed time to be effective. 29 But it is impossible to see how the U.S. could make this argument in the case of September 11. The attack, even if considered to be an ongoing one, had ceased for the moment. The U.S. needed a month to get its armed forces in readiness. It immediately set about trying to solve the enormous security lapses that had made September 11 possible. The Security Council, with the necessary U.S. vote, took a host of non-military measures aimed at effectively combating international terrorism. It's obvious that the U.S. did not find itself lacking in time to go to the Security Council. Nobody is even claiming that the U.S. encountered any obstacles at the Security Council that would have made it defenseless if it had to work through the proper channels. Nor did anybody claim that the United States had proposed what it thought were more effective, collective measures, which the Security Council rejected. The only way to make sense of what happened is to conclude that the U.S. wanted to have a free hand to act alone and not to be bound to seek non-military alternatives, the very antithesis of international law and the Charter of the United Nations. If Article 51 were interpreted to require the Security Council to have eliminated all potential threats to a country's security before the right of self-defense was superseded, then Article 51 would have no conceivable application, especially to a permanent member who could always block any action and then use that as a pretext. Legally speaking, that's a pretty good reason for concluding that it would be wrong to interpret Article 51 in that way. But even apart from Article 51, the other conditions of the inherent right to self-defense were nowhere to be seen in the case of the attack on Afghanistan. The right of self-defense requires a demonstration that no non-military solution is available. This, like Article 33 itself, imposes an obligation on a state to seek a negotiated solution, before embarking on war. Now in the case of Afghanistan, as early as September 19, the Taliban Supreme Leader Mullah Omar, repeating denials of Afghan involvement in the September 11 attacks, publicly offered to negotiate a settlement with the United States that could even include the extradition of bin Laden. We have told America that we deny Osama's involvement in the latest incidents in America. However, we repeatedly put forward proposals concerning ways of solving Osama bin Laden's issue. We have told America that if it has any evidence of Osama bin Laden's guilt, it should be given to the Supreme Court of Afghanistan, so that we can take action in the light of it. America has rejected all this. We have proposed to America to let representatives of the Organization of Islamic Conference come to Afghanistan to assess Osama bin Laden's activities for its satisfaction. But this has been rejected by America also. If the American government has some problems with the Islamic Emirate of Afghanistan, they should be solved through negotiations. 30. On September 20, the Grand Council of Afghan clerics, to whom the Taliban had submitted the question, recommended that the UN investigate independently and precisely the recent events to clarify the reality and prevent harassment of innocent people. 31. Yet in his speech of September 20, President Bush declared that there would be no negotiation or even discussion. And tonight the United States of America makes the following demands on the Taliban: deliver to United States authorities all of the leaders of Al-Qaeda who hide in your land. Close immediately and permanently every terrorist training camp in Afghanistan. And hand over every terrorist and every person in their support structure to appropriate authorities. Give the United States full access to terrorist training camps, so we can make sure they are no longer operating. These demands are not open to negotiation or discussion. The Taliban must act, and act immediately. They will hand over the terrorists or they will share in their fate. 32. These demands were obviously impossible to accept for the government of any sovereign state that wished to remain so. 33. Rahul Mahajan and John Pilger have concluded that in making these demands on Afghanistan, the U.S. deliberately sought war. In fact, they argue that the U.S. intentionally made it impossible for the Taliban to hand over bin Laden, by refusing to present them with any evidence of bin Laden's involvement, the minimum that any nation demands, even of its friends, when it is asked to extradite a criminal. 34. According to Pilger, since the invasion of Afghanistan had far wider objectives that transcended bin Laden and long preceded September 11, the U.S. didn't want him before they'd had a chance to make war. 35. Not that capturing bin Laden could possibly have justified in law or in morals the devastating attack on Afghanistan. Remember, we're talking about killing tens of thousands of people, much less avoiding seeking a solution through the Security Council. In the first place, bin Laden had plenty of time to evade capture, even with the Americans' unilateral attack, something he appeared, after more than 2 years of war and occupation, successfully to have done. Secondly, and far more importantly, one is not allowed to invade a country to effect an arrest. When the Israelis kidnapped Adolf Eichmann from Argentina, they were unanimously condemned by the Security Council, even though they didn't harm a hair on his or anybody else's head. And he was a Nazi with the blood of millions on his hands. 36. Furthermore, far from showing the required necessity of self-defense, instant, overwhelming, leaving no choice of means, and no moment for deliberation, it is clear that even if the overthrow of the Taliban were a necessary and legitimate self-defense objective, there was ample time to contemplate more effective, collective action that could have avoided the terrible human costs of the Americans taking the law into their own hands. In December 2001, the American Project on Defense Alternatives published a detailed study of the alternative legal options clearly available to the United States that would have spared thousands of innocent lives. They pointed out that the negative side effects of the campaign had little to do with fighting the Al-Qaeda threat, and instead came from the decision to overthrow the government by relying on aerial bombardment. Less costly and destabilizing approaches were available, which might have included limited and selective airstrikes, but would have been much more effective if they had focused on law enforcement and intelligence against the real danger of terrorist operations coming from outside Afghanistan. Resolving the broader problems of Afghanistan might have required a major military operation, but this would have been more effective and would have resulted in much less harm to innocents if it had involved more careful planning, perhaps 6-8 months of intensive diplomatic, intelligence, and military preparations. Above all, this would have required working through the United Nations Security Council to facilitate the formation of a more 42. Effective and representative government, and end the use of Afghan territory as a base for terrorist and insurgent activities elsewhere. The full panoply of persuasive tools would have had to be brought into play, among these, trade bargains, economic assistance, sanction relief, promises of security cooperation, and debt forgiveness. 37. The same reasoning, with only slight changes, would also clearly have applied to the invasion of Iraq in 2003. Events seem to bear out the futility of the Americans' unilateral military approach as a way of confronting either terrorism or the broader problems of Afghanistan. At the time of writing, 2 years after they launched their attack, Afghanistan was still a place ruled by fundamentalist warlords, where women were obliged to wear the ghostly burqa and marginalized by law, but above all by social conditions, which hadn't changed merely through the banishment of the Taliban. 38. After the Taliban is the same as before the Taliban. It's all the same people, with the same guns. What was the American bombing for? 39. Though the Loya Jirga held under UN auspices in June 2002 was billed as an exercise in democracy and self-determination, the selection of the government to replace the Taliban was essentially a deal worked out between the United States and its Northern Alliance warlord allies, and then imposed on the Afghans. The interim leader himself, Hamid Karzai, seemed more a representative of the US than the Afghans. American intelligence agencies and oil companies had been working with him since the mid-1980s, and he had even served as a consultant to the American oil company Unocal when it was working on the Caspian Sea oil pipeline project in the mid-1990s, a project that appeared crowned with success on Karzai's accession to OPSEE. 40. To justify the war, cheerleading journalists had made it seem like the overthrow of the Taliban would solve everything. When the Taliban finally fall, and they will, billions of dollars in reconstruction aid will flood in. Far from being a tragedy for Afghans, this war could be the best thing that has happened to them in 2 decades. 41. But the incentive to promise big things while bombing the Taliban did not become an incentive to deliver once they were vanquished. The few billions pledged were a spit in the ocean of Afghanistan's needs, and much even of what arrived never got past the warlords' pockets. 42. The only result of the regime change seemed to be a regime friendlier to the U.S. Long after the U.S. had become enmeshed in the occupation of Iraq, there were still 11,000 U.S. troops in Afghanistan fighting a resurgent Al-Qaeda and Taliban, who seemed reinvigorated, not only by popular opposition to the return of the warlords, but also by the Iraqi resistance. 43. Karzai ruled only in Kabul, with a few hundred U.S. soldiers as his personal bodyguards and 5,000 NATO troops as the government's guarantors. 44. Even as an exercise in rooting out terrorism, the attack on Afghanistan appeared to be a failure. A front-page article in the New York Times of June 16, 2002 had American authorities agreeing with what the war's opponents had been saying from the beginning, Classified investigations of the Qaeda threat now underway at the FBI and CIA have concluded that the war in Afghanistan failed to diminish the threat to the United States, 45 failed even to diminish it. Of course, this admission now suited America's plans to take its war on terrorism to new pastures, hence the doctrine of preventive self-defense announced precisely at this time for use in Iraq in 2003, international law be damned. 46 It was as if the Nuremberg Tribunal's decision on the Nazi invasion of Norway had gone the other way. The evident failure of America's war on Afghanistan to begin to resolve either terrorism or the broader problems of Afghanistan was relevant to the crucial question, both legal and moral, of alternatives to unilateral military action by the United States. The main point made by the anti-war movement here was once again that of American complicity. The violent fundamentalists of Afghanistan were simply, in RAWA's words, America's Frankenstein monsters, backed by the US to the tune of billions of dollars and highly sophisticated weaponry, all for the purpose of bringing down America's Soviet rivals, whose 10-year war in Afghanistan spelled the end of the USSR. 47 The Soviets supported the reformers, so the Americans backed the fundamentalists. After the fall of the Soviets until well into 2001, American interest in Afghanistan centered on access to Caspian Sea oil, and the US supported whatever regime, now the Northern Alliance, now the Taliban, seemed capable of exerting control. 48 Opponents of the war in Afghanistan mounted a powerful case for linking the phenomenon of terrorism itself to the behavior of the Americans in the world. Louis Lapham called September 11 an attack on American foreign policy, which, for the last 30 years, has allied itself, both at home and abroad, with despotism and the weapons trade, a policy conducted by and for a relatively small cadre of selfish interests. 49 Naomi Klein labeled the attacks part of a war not so much on U.S. imperialism but on perceived U.S. imperviousness has produced a blinding rage in many parts of the world, a rage at the persistent asymmetry of suffering. 50 The most frequently asked question in America in the days following September 11, 2001 was why do they hate us? To which one commentator had the wit to reply, they hate us because we don't even know why they hate us. 51 This asymmetry of suffering had its basis in a structure of inequality such as the world had never seen before, with America the richest country in the world and Afghanistan one of the poorest. 52 One index of inequality was oil itself, which the Arab world produced and the West, above all the US, consumed. 53 Despite the fabulous wealth of the elite of the oil-rich countries, the average Arab had to survive on about 1/7 the average American's income. 54 The American musician Quincy Jones had an earthy assessment of the war in Afghanistan, that's why this fucking war is going on, that's why, because the gap between rich and poor is too large. 55 This was essentially the message, if in more genteel language, of 100 Nobel Peace Prize winners, who declared that the most profound danger to world peace in the coming years will stem from the legitimate demands of the world's dispossessed for the wider degree of social justice that alone gives hope of peace. 56 Everybody seemed to understand that if you could explain the attack on America by America's own transgressions, then the justification for the retaliation would evaporate, because America would be responsible for starting the whole thing. Donald Rumsfeld acknowledged this indirectly when he said of the deaths of Afghan civilians by American bombs, we did not start this war. So understand, responsibility for every single casualty in this war, whether they're innocent Afghans or innocent Americans, rests at the feet of the Al-Qaeda and the Taliban. 57 There was a desperate quest to detach the events of September 11 from America's foreign policy. The American media and the politicians tried their best to explain September 11 as a result of pure evil or envy, or as an attack on the things that were good about America. In a famous cartoon by Tom Tomorrow, one of the criteria for being a real American was to answer yes to the question. Do you genuinely believe the terrorists are motivated by nothing more complex than a blind, unreasoning hatred of freedom? 58 Bush said that America had been attacked because we're the brightest beacon for freedom and opportunity in the world. 59 Some beacon for freedom, With 2 million adults behind bars on any given day, more people, even relative to its population, than any country in the world. 60 maybe if they'd attack Sweden you could say they were attacking a beacon for freedom, but the United States? The debate about terrorism didn't start with September 11th. It's an old one by now, with familiar contours. On one side we have a minority of peoples and states, the ones with the most powerful militaries, who can be heard to repeat the formula that individual and not state terrorism is the problem, and that ends never justify means, at least when these means are terrorist, so that you can condemn the means without even discussing, much less addressing, the ends. 61 On the other side, we have most of the people and states of the world, who find it impossible to detach terrorism from questions of social justice. This was summed up in the General Assembly resolution of 1972 following the Munich Olympics massacre, which expressed deep concern over increasing acts of violence which endanger or take innocent human lives or jeopardize fundamental freedoms, and which consequently urged states to devote their immediate attention to finding just and peaceful solutions to the underlying causes which give rise to such acts of violence. 62 Even the Americans seem to subscribe to this position when it suits them. The Kosovo Liberation Army, fighting the Serbs for independence, were officially branded terrorists by the Security Council. But when the Serbs argued that repressive measures were necessary to fight terrorism, the Security Council, with America's affirmative vote, underlined that the way to defeat violence and terrorism in Kosovo is for the authorities in Belgrade to offer the Kosovar Albanian community a genuine political process. 63 Most people and states, furthermore, appear to consider state terrorism to be the most harmful and deadly form of terrorism. 64 They appear to agree with Chomsky and Herman, who classically labeled it wholesale terrorism, as opposed to the retail terrorism that preoccupies the big powers and their clients. 65 But what else can you call the attack on Afghanistan if not a terrorist act? George W. Bush himself said he was aiming it not only at the terrorists but at anybody who decided not to join his crusade. Remember his words. Every nation in every region now has a decision to make, either you are with us or you are with the terrorists. Here is no such thing as a good terrorist. No national aspiration, no remembered wrong can ever justify the deliberate murder of the innocent. Any government that rejects this principle, trying to pick and choose its terrorist friends, will know the consequences. This can only be understood as an attempt to instill fear, not in the terrorists, but in anyone who might stand in the way of American military might as they pursued them. And the means by which the Afghanistan war was undertaken, how can these escape the label terrorist? Tens of thousands of civilians and soldiers killed with the most effective conventional technology of death ever known, Hellry missiles fired from Predator drones, bunker busters, Daisy cutters and Apache helicopters, Ying tanks with rocket launchers and chain guns firing 600 rounds per minute. As you might expect, it is a terrifying machine to ground forces. 66 Or think about the nuclear weapons with which the United States seeks to deter its enemies. Is it only professors of criminal law who realize that the hidden word in deterrence is terror? Far from being a war against terrorism, it was much saner, as Noam Chomsky pointed out, to think of the war on Afghanistan as one being conducted by one of the world's leading terrorist states. 67. Collateral damage. One criterion by which America seeks to distinguish its far more terrifying violence from that of the real terrorists, a criterion which has even persuaded some respected intellectuals, is its attitude to the taking of civilian life. George W. Bush summed it up in his speech to the United Nations on November 10, 2001, "Unlike the enemy, we seek to minimize, not maximize the loss of innocent life." The idea is that there is a transcendent all-trumping difference between terrorist attacks as commonly understood and the collateral damage that the American military regularly inflicts, and that this is the difference between premeditated murder and unintended killing, as American political commentator Michael Walzer wrote in Dissent. A few left academics have tried to gore out how many civilians actually died in Afghanistan, aiming at as high a figure as possible, on the assumption, apparently, that if the number is greater than the number of people killed in the attacks on the Twin Towers, the war is unjust. But the claim that the numbers matter in just this way, that the 3,120th death determines the injustice of the war, is wrong. It denies one of the most basic and best understood moral distinctions, between premeditated murder and unintended killing. 68. The people who attacked the Twin Towers in New York meant to kill civilians. That was at least one of the purposes of the attack. Suicide bombers seek the maximum number of civilian deaths, whereas the Americans claim that they mean only to kill combatants and seek to minimize injury to civilians as much as possible, and, indeed, given their objectives, the claim is plausible in many cases. 69. The killings are therefore, according to them, unintended and accidental. This kind of killing is called collateral damage, the official American military definition of which is unintentional or incidental injury or damage to persons or objects that would not be lawful military targets in the circumstances ruling at the time. According to the military, such damage is not unlawful so long as it is not excessive in light of the overall military advantage anticipated from the attack. 70. It appears that the term was in wide use in the 1950s and 1960s as nuclear war jargon. Thomas Schelling of Harvard University used it in an article in 1960 in which he argued for the dispersal of U.S. nuclear weapons sites away from urban areas to minimize collateral damage from Soviet attacks on them. 71. The term became common currency only during the Gulf War of 1991, but when NATO spokespersons used it liberally in the Kosovo War of 1999, without any trace of shame, to describe civilians, including children, killed by NATO bombs, the opprobrium was so great that they had ultimately to try and distance themselves from it. For most of the war, you could find Jamie Shea, Wesley Clark, and the rest, using the phrase routinely at NATO press conferences. For instance, Jamie Shea, targets are carefully selected and continuously assessed to avoid collateral damage. 72. Major General Gertz, by trying to avoid collateral damage we are not using weapon systems which we could use if we were as brutal and as cruel as Milosevic is. 73. And Supreme Commander General Wesley Clark on April 13, after an American pilot bombed a passenger train crossing a bridge, not once but twice, and killed 16 civilians, it is one of those regrettable things that happen in a campaign like this and we are all very sorry for it, but we are doing the absolute best we can do to avoid collateral damage, I can assure you of that. 74. On the other hand, by the end of the war you could ND at least the media-savvy Shea trying to distance himself from the psychopathic coldness of this awful term. 75. Lord Robertson himself put the phrase between quotation marks in his Opchale defense of the war on its RST anniversary. 76. Its destiny to live on only in infamy seemed sealed when Gulf War veteran Timothy McVeigh used the term to describe the children killed in his 1995 bombing of a federal building in Oklahoma City, which he considered an act of war against the United States. 77. But you could still ND the odd old soldier usage of it during the Afghan War. 78. By Iraq, it was being used mainly by journalists, often as a condemnation. For example, Robert Fisk reported the sickening scene from Baghdad. It was an outrage, an obscenity. The severed hand on the metal door, the swamp of blood and mud across the road, the human brains inside a garage, the incinerated, skeletal remains of an Iraqi mother and her 3 small children in their still smoldering car. 2 missiles from an American jet killed them all, by my estimate, more than 20 Iraqi civilians, torn to pieces before they could be liberated by the nation that destroyed their lives. Who dares, I ask myself, to call this collateral damage? 79. Only rarely, and at very low levels, could the term be found in official military discourse. 80. President Bush's speechwriters completely shunned it in favor of solemn pledges to protect innocent lives in every way possible. 81. On the other hand, intellectuals were keen to defend the moral distinction. In mid-war, law professor Kenneth Anderson argued, 82. There is no moral equivalence between stray missiles aimed in good faith, using the best technology available, and deliberate violation of the categorical rules of war, like using human shields, shelling civilians to prevent them from fleeing Basra, and rape or summary execution of prisoners. Yet he had to admit that many people didn't see it quite this way. It does seem to millions of people worldwide that there is indeed a moral equivalence between the tactics of the Americans, hitting targets from the air and pleading collateral damage as a defense against responsibility, and the tactics of the Iraqis, who, lacking other means to attack, use their own civilians as a material and moral resource, no matter what laws of war it might violate. This was the attitude, it should be said, held by Churchill, who intended a scorched earth defense of Britain without much regard for the lives of British civilians, should the invader ever arrive. Anderson tried to salvage the distinction in the only way he could think of. There is, I think, only one way to evaluate these conflicting claims. To deny the distinction means that you either accept that virtual nonviolence is the only tenable position, or that you are indifferent to the lives of civilians, since you are guilty of anything that happens anyway, and in that case, anything becomes a target. The justification for the principle is that it appears to be the only principled way of steering between a pacifism that few of us, in real life, would accept, and a brutal realism that denies the moral necessity of even trying to distinguish between combatants and non-combatants. But these stark alternatives of, on the one hand, unrealistic pacifism and, on the other, placing no limits on the rules of war, are spurious because they ignore the fundamental question of the legality and morality of the war itself. It just shows how far wrong international criminal law has gone that anyone could not think this relevant. The question is only difficult for the international criminal law professionals because they take for granted the great big hole in the modern practice of international criminal law, its refusal to distinguish between legal and illegal war-making, between aggression and self-defense. The whole edifice depends on pretending all wars are legal on all sides. But what would have made Churchill's plans morally defensible was that the Nazis were the aggressors and Britain was forced to fight back by any means it could. The Nazis would have borne the blame, not Churchill. You can't possibly judge the morality of collateral damage while leaving out the question of the war itself, however congenial this may be to aggressors with the best technology available. It is the immorality and illegality of a war that makes collateral damage a crime. The real alternatives are to make war only when it is necessary and moral and legal, and not to make it when it is not. Then, if you take as much care as possible to avoid injury to non-combatants, nobody will have the right to criticize you when they are harmed, because their harm will be the responsibility of those who started the war, just like Rumsfeld said. To return to the argument of Michael Walzer, there is indeed a moral and legal difference between meaning to kill someone and killing someone accidentally, but it's not as fundamental as Walzer would have it, and it doesn't do much to help the aesthesis of collateral damage. The principles are exactly the same for national and international criminal law, and for law and morals. Meaning to kill someone makes killing murder. Some kinds of accidental, and indeed intentional, killings are lesser crimes and may even be no crime at all if it should be found that all reasonable care was taken to avoid harm. Take dangerous driving, run somebody down on purpose and it's murder, run somebody down by accident because you weren't driving carefully enough and it's manslaughter, run somebody down when you were driving very carefully and it's no offense at all. It was not your fault. But some accidental killing is treated very seriously, even as seriously as murder. Try to run down one person that you mistook for another and that's murder. That's the Deraz Khan situation, described at the beginning of this chapter. You intended to kill the person you killed, you just got the identity wrong. But the identity of the victim is irrelevant if you had no right to kill in the RST place. A very different question is whether, assuming the Americans had the right to kill Osama bin Laden, which they did not, they took sufficient care to ensure that it was him they were killing. In this case, collateral damage may not be criminal at all. Walzer has missed precisely the point that Anderson has, namely that it depends on the legality of the war, which in turn generally depends on its morality. What about the more classic case of collateral damage, for example trying to run someone down in a pedestrian mall, with malice towards none of the other pedestrians, trying your best to minimize the harm to them, but knowing that some will inevitably be killed. World Court Judge C.G. Weeramantry thought the answer so obvious that he used it as part of his argument for the illegality of nuclear weapons. It is not to the point that such results are not directly intended, but are byproducts or collateral damage caused by nuclear weapons. Such results are known to be the necessary consequences of the use of the weapon. The author of the act causing these consequences cannot in any coherent legal system avoid legal responsibility for causing them, any less than a man careering in a motor vehicle at 150 km per hour through a crowded market street can avoid responsibility for the resulting deaths on the ground that he did not intend to kill the particular persons who died. 83. Collateral damage is a very special kind of accidental, unintentional or unpremeditated killing. New York Times language columnist William Safire was only half right when he defined it as unintended, inadvertent. 84. It is not inadvertent, meaning, literally, that no thought was given to it. In fact, it is foreseen as inevitable. When the Americans planned the war on Afghanistan, they knew that many civilians, very probably thousands of civilians, would die. One of the questions in a CBS/New York Times public opinion poll conducted within a week of the attack on the World Trade Towers asked, should the U.S. take military action against whoever is responsible for the attacks? Even if it means many thousands of innocent civilians may be killed. 58% of respondents, representing the American population with a margin of error of 3%, answered yes. 85. Not just thousands, many thousands. Here's Secretary of Defense Donald Rumsfeld in October 2001. Any time that the Department of Defense is engaged from the air or on the ground, we have to know that there are going to be people hurt. Overwhelmingly, they will be people who we intend to hurt. On occasion, there will be people hurt that one wished had not been. I don't think there is any way in the world to avoid that and defend the United States from the kinds of terrorist attacks which we've experienced. 86. Here he is in December. One of the unpleasant aspects of war is the reality that innocent bystanders are sometimes caught in the crossfire, and we're often asked to answer Taliban accusations about civilian casualties. We know this much for certain: the United States has taken extraordinary measures to avoid civilian casualties in this campaign. That's not true of Taliban or Al-Qaeda forces. 87. And here he is again in July 2002. There cannot be the use of that kind of repower and not have mistakes and errant weapons exist. It's going to happen. It always has, and I'm afraid it always will. 88. This is not inadvertent killing. It is deliberate killing deliberately by mistake, one Palestinian journalist called it. 89. It is premeditated killing in the literal sense that it is clearly foreseen and contemplated beforehand, with the repeated claim that those killed are the very minimum to be expected. Otherwise, how could an expert like Michael O'Hanlon of the Brookings Institution characterize 1,000 civilians killed as a mercifully low number? 90. Not, oh my God, we killed innocent people, but what, we only killed 1,000. So we are being asked to distinguish between meaning to kill and killing knowingly, both, of course, without lawful excuse. Does the law make this distinction? Evidently, not since Moses. And if an ox gore a man or a woman, that they die, the ox shall be surely stoned, and its flesh shall not be eaten, but the owner of the ox shall be quit. But if the ox was wont to gore in time past, and warning hath been given to its owner, and he hath not kept it in, but it hath killed a man or a woman, the ox shall be stoned, and its owner also shall be put to death. 91. In March 2002 it wasn't an ox but a dog. That's when a Los Angeles jury convicted a woman of second-degree murder when the dog she was walking mauled a neighbor to death. Her husband, who was not present, was convicted of manslaughter. Nobody suggested that she wanted her dog to kill the neighbor or that she set her dog upon her neighbor, or anything like that. It was enough that she and her husband knew their dogs were time bombs that could kill someone, but did not care. 92 When the judge later ordered a new trial in the woman's case, it was not because she didn't mean to kill anyone, but because, in his words, I cannot say as a matter of law that she subjectively knew that day that her conduct would cause death. 93 Even so, he added, there is no question in this court's mind that in the eyes of the people, both defendants are guilty of murder. In the eyes of the law, they are not. 94 Criminal law, like most people, does not think it worth distinguishing between killing knowingly and killing on purpose, at least when there is no lawful excuse. Both are murder. The criminal law, in fact, punishes collateral damage under two distinct approaches. The RST is the universally accepted idea of transferred intent. Suppose that Smith shoots at Black with the intention to kill him. But his aim is bad, and Smith's bullet hits and kills White, a clearly visible bystander, instead. Since the early days of the common law, all Anglo-American jurisdictions hold Smith guilty of murder by the doctrine of transferred intent. 95. This doctrine has been applied consistently for hundreds of years. For instance, in the old case of the Queen v. Saunders and Archer, an English court held it murder where a man tried to poison his wife but by accident poisoned his daughter. 96 Somewhat more recently, in the case of People v. Sanchez, a California court held the accidental killing of an innocent bystander in a drive-by shooting to be RST degree murder by transferred intent. 97 As for criminal codes, the New York Penal Code provides that it is equally murder when, if intent to cause the death of another person, causes the death of such person or of a third person. 98 The Canadian Criminal Code provides the same thing. 99 Some scholars and the doctrine conceptually awkward in artificially transferring the intention to kill one person to a victim for whom the accused may have had no ill will at all. But even those who disagree with the technique of the doctrine agree with its substance, namely that such cases should be punished as severely as murder. 100 The second approach of the criminal law to collateral damage is almost as universal, and that is treating knowledge as the equivalent of intention for the purposes of the law. The approach of the Bible and the California court in the dog mauling case is common to many jurisdictions. This is also the attitude of the English common law. An example is the decision of the English House of Lords in Hyam v. DPP, which upheld a conviction for the murder of two children, where the accused set to a house merely intending to frighten their mother. The court decided that murder was not restricted to the intention to cause death but also included where the defendant knows that there is a serious risk that death or grievous bodily harm will ensue from his acts. 101 England's foremost authority on criminal law, Glanville Williams, puts the case this way, where the defendant desires result X, and anyone can see, by merely considering X, that another result Y, will also be involved, as the direct consequence of X and almost as part and parcel of it, then the defendant will be taken to intend both X and Y. He adds that certainty in human affairs means certainty as a matter of common sense, certainty apart from unforeseen events or remote possibilities. 102 In England this is called oblique intention, and it is accepted by most writers and authorities and in many codes throughout the world. The only objections that have been made to it are similar to those made against the doctrine of transferred intent, namely those relating to ordinary meaning and verbalness, not to punitive appropriateness. In other words, it may be awkward or even wrong to say of those who only knew someone was going to be killed by their acts that they intended to kill, but there is no objection to punishing them equally as severely as those who do. Professor Wayne Lafave, author of a leading American text, adopts this position. Intent has traditionally been defined to include knowledge, and thus it is usually said that one intends certain consequences when he desires that his acts cause those consequences or knows that those consequences are substantially certain to result from his acts. This failure to distinguish between intent and knowledge is probably of little consequence in many areas of the law, as often there is good reason for imposing liability whether the defendant desired or merely knew of the practical certainty of the results. 103. As for murder, Lafave writes, Apart from the question of when capital punishment should be permitted, there is no basis in principle for separating purposeful from knowing homicide. Many of the modern codes do not distinguish between them, although a majority do appear to require intent rather than knowledge, or at least, to classify intentional and knowing killings differently. 104. Of the many jurisdictions for which it is all the same, there is, interestingly enough, the Texas of George Bush, father and son. Under Texas law, a person commits murder if he or she intentionally or knowingly causes the death of an individual, intends to cause serious bodily injury, and commits an act clearly dangerous to human life that causes the death of an individual. 105. Since the collateral damage enacted in Afghanistan and Iraq by the former governor has involved so many perfectly predictable cases of multiple killings, of both adults and children, it might be worth pointing out that, under Texas law, murder is punishable by death if the person murders more than one person, during the same criminal transaction, or during different criminal transactions but the murders are committed pursuant to the same scheme or course of conduct, or the person murders an individual under 6 years of age. 106. This isn't some Texas exoticism either. According to the American Law Institute Model Penal Code, 1980, criminal homicide is equally murder when it is committed purposely or knowingly. Article 2.02 defines knowingly as including the situation where one is aware that it is practically certain that his conduct will cause a result. 107. Illinois law goes further yet and provides that person who kills an individual without lawful justification commits first-degree murder if, in performing the acts which cause the death, he knows that such acts create a strong probability of death or great bodily harm to that individual or another. 108. The New York Penal Code is one of those codes that restrict murder to cases where the conscious objective is to cause death. However, it still treats collateral damage as murder by adopting the universal doctrine of transferred intent discussed earlier. 109. The reason why the law almost always equates knowledge with intent is that the distinction is morally irrelevant for most of the purposes of punishment, which are the defining criteria of criminal law. A person who goes ahead with an unlawful act in the certainty that it will cause death is just as dangerous to life, maybe even more dangerous, than a person who goes ahead in the hope that it will cause death. This person is worth punishing as severely for the purpose of deterrence or protection of the public as the second, and protection is what most people want from criminal law. Furthermore, it would seem that the person who acts in full knowledge that death will occur is as deserving of punishment as one who actually seeks death, because they have both acted with their eyes wide open, voluntarily, and in disrespect of the lives of others, which they have equally sacrificed to their own illegitimate ends. This is not to deny that some people hold, evidently, that the intentional killer is more abhorrent than the mere knowing killer, and that is the explanation for the codes that sometimes treat it as a lesser, though always very serious, crime. Still, it is hard to see why. Certainly there are many well-known instances where the distinction is not regarded as at all important. When Timothy McVeigh called the children he killed in Oklahoma City collateral damage, he was not arguing that it was acceptable to kill them knowingly. He was actually arguing in his own defense that he did not know there was a daycare center, and that had he might have reconsidered his target. I recognized that someone might be bringing their kid to work. However, if I had known there was a daycare center, it might have given me pause to switch targets. That's a large amount of collateral damage. 110. In other words, McVeigh was not arguing about the difference between intention and knowledge, but about the difference between knowing and not knowing, just like the court in the California dog mauling case. And when the FBI responded to McVeigh's claim, it wasn't by saying that it was his conscious objective to kill children, but rather that he must have known that there was a daycare center in the building from the brightly colored children's pictures in the windows. In other words, he should be executed because he knew many children would die. This exact point is made in the movie Collateral Damage, an Arnold Schwarzenegger vehicle made shortly before the attacks of September 11, 2001. The movie is a bunch of cliches if there ever was one, but they are useful clichés meant to reassure the public by repeating back to them what they already know. The collateral damage in the movie is the Schwarzenegger character's wife and son, who die in a Colombian terrorist bombing of an LA office building aimed at visiting Colombian military officials. Schwarzenegger goes on a rampage when an apologist for the terrorist is broadcast on television using the term just like General Wesley Clark might have, "The deaths of the mother and the little boy are regrettable, it's called collateral damage." The movie's release was delayed by the attack on the Twin Towers and the Pentagon, supposedly because it involved terrorist attacks against off-CE buildings. But there are quite a few other things in the movie that might have offended off-chale US sensibilities, for instance, the display of off-chale American willingness to kill civilians, indeed the display of some terrifying attack helicopters in action against a terrorist camp full of civilians on the explicitly IMC pretext of rescuing an American. There was also the cynical deployment of the concept of self-defense by the bad guys. At one point the terrorist says the attack on LA that killed the star's wife and child was an exercise in Colombian self-defense. Cynicism about the American notion of self-defense was running high in Canada when the cockpit tapes were released of the American F-16 pilot who accidentally killed 4 Canadian soldiers with a 500-pound bomb near Kandahar on April 18, 2002. There was a national outpouring of mourning in Canada for these 4, and there's nothing wrong with that. But imagine if Afghanistan had the mass media to mourn the 20,000 plus Afghanis who Canada helped America to kill in the cause of terrorism. The Canadians were involved in a night training exercise, and the pilot sorry on the ground. It does not appear that he ever seriously thought he was being read upon, much less that he was in any danger at his altitude, so his routine use of self-defense, and its approval by the controller, are evidence of a complete debasement of the concept to mean its opposite, namely, any reasonably safe opportunity to kill with vastly superior repower. 56. Pilot, I've got some men on a road, and it looks like a piece of artillery ring at us. I am rolling in self-defense. And then, after he dropped the bomb, pilot, can you confirm they were shooting us? Air controller, you're cleared. Self-defense. 111 Rolling in self-defense, lacking any hint of urgent necessity, could be the motto of the entire war on Afghanistan. No doubt one of the biggest affronts to American feelings in the Schwarzenegger movie had nothing to do with 9/11 and everything to do with 10/7, namely, the use of collateral damage itself as an irredeemably dirty word, synonymous with murder, at a time when US forces were doing so much of it in Afghanistan. According to the Schwarzenegger character, the Colombian terrorist deserved to die because he knew innocent people like the star's wife and child would be killed when he tried to blow up the Colombian military officers, not because he wanted them to die. In fact, the only difference Schwarzenegger sees between himself and the terrorist is the willingness to accept any collateral damage. When he calls the terrorist a coward who kills women and children, the terrorist replies, "Well, it seems we're both willing to kill for a cause, so what's the difference between you and I?" Schwarzenegger's comeback is the movie's signature line, "The difference is, I'm just going to kill you." At one point Schwarzenegger sacrifices his plan to kill the terrorist and gets himself caught, all to avoid hurting bystanders. If this says anything, it says that popular wisdom, like law, holds collateral damage to be just as hateful as the standard variety of murder. So law and morals condemn the attack on Afghanistan, like that on Iraq, as severely as the attack of September 11, indeed more severely, given the disproportion in the actual amount of death and mayhem in East. But although a lot of people have been self-righteously slaughtered by the Americans to bring justice, in George W. Bush's words, to the perpetrators of the September 11 crime, it's a sure bet that no Americans will even stand trial for what they have done. 56 June 5, 04, 1:17 and 4 seconds p.m. June 5, 04, 1:17 and 4 seconds p.m. 3. Kosovo 1999. As the collateral damage accumulated in the villages and mountains of Afghanistan, far away in northern Europe, in a modern courtroom in the ultra-civilized Dutch city of The Hague, Slobodan Milosevic, ex-president of Yugoslavia, went on trial for war crimes and crimes against humanity. The court was the International Criminal Tribunal for the former Yugoslavia, the first of its kind since the Nuremberg and Tokyo tribunals of World War II. The international criminal justice movement was riding high. Milosevic's trial commenced in February 2002. In April, the movement's crowning glory, the new International Criminal Court, received the necessary 60th ratification to allow it to take effect, and it did so on July 1. But the movement was also encountering some powerful opposition. A couple of days after the Milosevic trial started, Belgian charges against Israeli Prime Minister Ariel Sharon for crimes committed during the 1982 Lebanon War were called into question by the decision of yet a third international court in The Hague, the International Court of Justice. The Belgian charges, based on universal jurisdiction, would be thrown out in June, and the law authorizing them completely declawed by the time of the American War on Iraq in 2003. Over in Chile, former dictator Augusto Pinochet was successfully ending a long entanglement with international criminal law that started with his arrest in London in 1998 for the torture and murder of thousands of Chileans during and following the coup by which he came to power in 1973. The biggest setback for the movement came in May 2002, when the United States formally withdrew its support for the court and set about muscling through exemptions for itself from the court's jurisdiction. U.S. opposition had stiffened during the war over Kosovo when, for a brief moment, the prosecutor for the Yugoslavia tribunal appeared to be seriously considering charges against NATO leaders for war crimes committed during the bombing campaign, with President Bill Clinton at the head of the list. ICTY prosecutor Carla Del Ponte very quickly backed off on the charges, and this taught different lessons to different people. To the movement's many supporters, the willingness of the tribunal even to contemplate charges against U.S. leaders showed how even-handed it was. Maybe one day, if the case warranted it, even an American leader could be brought to trial. To the Americans, however, this was decisive. That an international criminal court could even appear to consider bringing Americans to trial was proof that this was a movement to be opposed. To those who brought the charges, Del Ponte's decision proved that powerful countries like the US had nothing to fear from international criminal law and, furthermore, that the trials of America's enemies were an exercise in hypocrisy. And this was the point Milosevic himself hammered home every day of his trial. How could you charge me with war crimes when the Americans committed these very crimes against civilians in Yugoslavia? Milosevic went so far as to charge the tribunal with having been set up to justify NATO's war crimes against the Serbs. He added that in Kosovo he too was guiding Islamic terrorists, just like the Americans were at that moment in Afghanistan. These events were not merely linked in time or in the desperate defense strategy of an ex-president on trial for war crimes. From the point of view of international law, the wars in Afghanistan and Yugoslavia had a lot in common. For one thing, they were both supremely criminal. But the issue wasn't only that NATO wasn't on trial, it was that Osama bin Laden wasn't on trial either. The trial before an international criminal court of those suspected of being involved in the September 11 attacks was the main alternative stressed by those opposed to an attack on Afghanistan, in other words, the vast majority of humanity, not to mention the Taliban themselves, but it was rejected out of hand by the Americans as irrelevant. On the other hand, the arrest and trial of Milosevic and other Serb leaders before an international tribunal was absolutely central to the NATO campaign in Kosovo. That Milosevic's Serbia was responsible for war crimes in Yugoslavia was the dominant theme of NATO's approach to the CON-ICT from the very beginning. ICTY prosecutor Louise Arbour worked hand in hand not only with NATO governments, but with NATO military commander Wesley Clark and his colleagues, and one of the key demands that NATO made in the ultimatums that preceded the bombing was that Arbour be allowed to investigate alleged crimes against humanity in Kosovo. Furthermore, the war in Kosovo was extremely important in setting the precedent for America's illegal wars in Afghanistan and Iraq. It broke a fundamental legal and psychological barrier. When Pentagon guru Richard Perle thanked God for the death of the UN, The first precedent he could cite in justification of overthrowing the Security Council's legal supremacy in matters of war and peace was Kosovo. Facing Milosevic's multiple aggressions, the UN could not stop the Balkan Wars or even protect its victims. The rescue of Muslims in Kosovo was not a UN action, their cause never gained Security Council approval. But Kosovo was also the testing ground for the whole international criminal law movement, because it was here that we had, for the first time in history, an international criminal tribunal established prior to the war whose criminals it was putting on trial, and therefore capable of playing a role in that war. What's more, a tribunal with the firepower to enforce its actions. The actions taken by this tribunal, the relentless pursuit and eventual trial of one of the war's protagonists and the absolution of all the others, provided an unparalleled opportunity to evaluate the new international criminal justice in action. Not only did the Kosovo War lack Security Council approval, it also lacked the approval of the people of the United Nations. Despite NATO's frequent claims that the bombing was being carried out on behalf of the international community, the people of the world were severely split on the war, with most appearing to have been against it. An opinion poll taken in mid-April 1999 and published by The Economist showed substantial opposition to the war even inside the NATO countries, even when the question was the misleading, are you for or against NATO's decision to bomb Serb military installations? According to the poll, a third or more of the population were opposed in Canada, Poland, Germany, France, and Finland. They were almost evenly split in Hungary, precisely evenly split in Italy, and opposed by a 3-2 margin in the Czech Republic. In Russia opposition stood at 94%, in the Ukraine 89%, and in Slovakia 75%. Opposition in the world's two most populous states, China and India, was official and assumed to be widespread in the population. A poll taken in Greece, a NATO country, showed 99.5% against the war, with 85% believing NATO's motives to be strategic and not humanitarian. War criminals. 69% of those polled favored charging Bill Clinton with war crimes, 35.2% Tony Blair and only 14% Slobodan Milosevic, not far from the 13% who favored charging NATO General Wesley Clark and the 9.6% for charging NATO Secretary General Javier Solana. In the United States itself, despite the relentless pro-bombing coverage of the networks, public opinion started out favorable, but by the end of the campaign had fallen to below 50%. A year after the war, 133 developing nations gathered in Havana opposed the very premise of the war, the so-called right of humanitarian intervention. 6 intellectuals and artists were also divided. Those in favor included such literary luminaries as Susan Sontag, Salman Rushdie, and, of course, Czech President Václav Havel. But those opposed were no slouches either. Their ranks included Alexander Solzhenitsyn, Harold Pinter, Mikos Theodorakis, and Nelson Mandela. The disagreement was not about the immediate harm done by the war. Nobody on either side had any doubt that the bombing iced a huge amount of suffering and damage. The 78-day campaign read about 25,000 of the world's most devastating non-nuclear bombs and missiles at the former Yugoslavia. Somewhere between 500 and 1,800 civilian children, women, and men of all ethnicities were killed by NATO's bombs alone. The lower Gur is the one conservatively estimated by Human Rights Watch 7 and accepted by NATO with rather suspicious ease. The higher Gur of 1,800 was the Federal Republic of Yugoslavia government's Opchale Gur. The truth is probably closer to the Frey Gur. 9 No doubt many more were gravely, and even permanently, injured, given the experts 2 wounded for every 1 killed rule of thumb. 10 less damage than America would do in Afghanistan and Iraq, for sure, but a lot of dead and maimed adults and children nevertheless, to whom we can add a whole population terrorized by a relentless attack that spared no urban center. On top of this, an unknown number of soldiers killed and wounded, somewhere between the Frey's claim of under 600 and NATO's claim of between 5,000 and 10,000 dead. 11 Finally, and most controversially, Between 2,100 and 10,500 were killed in Kosovo not by the bombs but by the Serb-Albanian violence on the ground after the bombing had begun. The bombs also did a huge amount of property and infrastructure damage. There was extensive destruction of bridges, hospitals, schools, factories, livestock, crops, power grids, media facilities, religious buildings, including early Christian and medieval churches, archaeological sites, and museums. The effects of the war on the environment were disastrous. The repeated bombing of oil refineries, chemical plants, electrical networks, and fertilizer factories propelled huge quantities of toxins into the air and the ground, and into the Danube's drinking water. 12. This war was no exception in the way of the mortal residues of modern war, including unexploded cluster bombs and the carcinogenic residue of exploded ones made with depleted uranium. 13. The damage to the economy has been quantified at between $60 billion and $100 billion. 14. A lot of money for a country that was already very poor after 8 years of economic sanctions and 10 years of depression. In 1998 Yugoslavia was ahead of Romania but behind Albania in the race for the poorest country in Europe. In 1999, after the war, it was safely in the lead. 15. The bombing campaign also saw about 1 million people made refugees from Kosovo. The Organization for Security and Cooperation in Europe put the number at around 860,000 ethnic Albanians and 100,000 Serbs. Probably another million were made internal refugees. 16. Of course, there is a lot of disagreement on whether the refugees were eating the bombs or being forced out by organized terror, but there can be no doubt that at least a portion of the Albanians, not to mention the Serbs, were running from the bombs. They would have to have been crazy not to, because they were being killed by them, for instance in the 2 well-publicized convoy incidents. 17. The really important point though, is that the refugee crisis started after the commencement of the bombing. There were no refugees at all during the prior month period in which the observers of the OSCE were present and, according to the UN Secretary-General's report of December 24, 1998, there had been a significant return of former refugees from the Intensi Edcon ICT of the year before. 18. After 3 days of bombing in March 1999 the refugees amounted to only about 4,000, a week later there were 350,000. If it was ethnic cleansing that caused the death of many ethnic Albanians, it was ethnic cleansing that occurred after the NATO bombing started, something conceded even by official U.S. State Department reports. 20. NATO says the Serbs were planning to do it anyway, with or without the bombing, and that it would have been worse. This claim is vital to the case for the bombing and NATO still clings to it, despite the fact that the only evidence for it is the mythical Operation Horseshoe. Outside NATO itself, even supporters concede that the bombing would at least have helped any of the complicated plots they variously ascribed to Milosevic. For example, Michael Ignatieff, without any evidence at all, made this almost indecipherable claim: the air campaign did not cause the ethnic cleansing, but there seems little doubt that Milosevic anticipated an air campaign and gambled that he could use it as a cover, and as a justification, for an attack on unprotected civilians. 21. Well, cause is indeed a complicated philosophical concept, but both law and morals have no difficulty holding responsible those who, with their eyes wide open, make a necessary contribution to a crime, even if there are other contributors also to blame. To deny this is like saying, we bear no responsibility if we hand guns to acknowledged murderers and then beat them to a pulp, threatening worse, provoking them to carry out murders that we anticipate. 22. This isn't about whether Milosevic is responsible, it's about whether NATO was also responsible, it's about NATO's complicity. The point is not that Milosevic was charged with atrocities in Kosovo, it's that Clinton wasn't too. Of course, one is only responsible for wrongful conduct, and NATO's responsibility turns, like America's would in Afghanistan and Iraq, on the wrongfulness and illegality of the Kosovo War, a question addressed below. But on the question of eyes wide open, NATO clearly felt a refugee ow in the hundreds of thousands to be an entirely predictable result of the bombing, claiming only to have underestimated its extent. 23 Peter Gowan argues persuasively that the bombing was in fact an invitation to genocide that was unexpectedly not taken up. This would explain NATO's early claims that genocide was occurring as a condensed prediction rather than a mere lie meant to play out the Holocaust metaphor. Already on March 28, 1999, George Robertson was claiming the FRY was a regime intent on genocide and that the bombing was intended to stop genocidal violence and ethnic extermination. 24 In an often cited interview on CBS television, U.S. Defense Secretary William Cohen speculated that 100,000 military-aged men may have been murdered. 25 But reporters who went to refugee camps during the war found it impossible to get eyewitness confirmation of these claims. Audrey Gillen of the British Guardian reported from Macedonia that neither she nor other reporters could get anyone to confirm the existence of the mass killings, systematic rape or even robberies that NATO was talking about. 26 When the war ended and NATO had free access to Kosovo, there was a great rush to unearth atrocities. But it didn't take long for all the prior talk of genocide and Holocaust to die down in the face of a serious evidence problem. Cohen's 100,000 gur was never mentioned again, and the official estimates dropped fast. By September they were down to 11,000. Even that number seemed exaggerated from reports out of Kosovo, for instance by a Spanish forensic team with experience in Rwanda who categorically denied the claims of genocide. 27 The Trpça mines, another Auschwitz according to the British press, turned out to contain no bodies at all. 28 A Canadian Broadcasting Corporation story of the murder of a 20-year-old Kosovo Albanian girl had to be retracted after the war when her sister admitted to the reporter that she had lied to gain sympathy for the cause. 29 The only corroboration for the gur of 11,000 came from an American Bar Association report, coincidentally sponsored by the State Department, which, on the basis of interviews with refugees, made statistical projections that were uncannily close to the claims of their sponsors. 30 By the time Milosevic went on trial in The Hague, the prosecution was severely hedging its bets. Now it was only at least 4,500 people died, but estimates rise to 10. Even the refugees due to terror had been reduced to over 750,000 people, forcibly moved from Kosovo or forcibly removed within it. 31 Since the total number of ethnic Albanians refugees during the war is generally accepted as about 1.5 million, that appears to be an admission that about half of the refugees were simply fleeing the war that NATO had started. 32. And the main point about all of these deaths and refugee flows is that they occurred after the commencement of the bombing. Indeed, of the 385 murders in the original ICTY indictment of Milosevic, 340 were alleged to have occurred after the bombing started. These deaths couldn't justify the bombing, they were a cost of it to be added to all the death and destruction that NATO's bombs did on their own. Even in the Ignatieff scenario, the bombing made a crucial contribution to these deaths. A justification of all of these costs would have to prove that these people would have died anyway, or indeed, that more would have died had NATO not bombed. And if that justification failed, these would not only be costs, but crimes in which the NATO leaders were morally complicit and for which they were criminally responsible, on top of what their bombs did by themselves. Added to these costs would be the pathology of NATO-occupied Kosovo. The withdrawal of the FRY forces left Kosovo to the KLA, restrained only minimally by their NATO sponsors, and what followed was a reign of terror against non-Albanians. 33 The murder rate in Kosovo in this period was about the highest in the world, 20 times the Western European and Canadian rate, and 20 times the American rate. 34 Nor did this appear to be simple revenge, but rather part of a precise political program aimed at the expulsion of the minorities and, definitively, at the homogenization of Kosovo along a single ethnic pro-LE, reverse ethnic cleansing in aid of the project of an independent Kosovo. 35 100,000 Serbs left Kosovo before the year was out, joining the 100,000 who had fled during the war, leaving only one-third of the pre-war community. 36 The Roma fared equally badly, an estimated 70 of the pre-war 100,000 to 150,000 had been expelled by September 1999. If there appeared afterwards to have been a reduction in the incidence of human rights abuse, this was due principally to the effective reduction of the population belonging to the minorities, in other words to the very success of reverse ethnic cleansing. 37 Serbs remaining in Kosovo continued to be connected to NATO-guarded enclaves and to be the victims of ethnically motivated murder right through America's wars in Afghanistan and Iraq. 38 The West fought a war with Mr. Milosevic and his forces over Kosovo in 1999 and made the lives of Kosovo's Albanians significantly better, according to New York Times correspondent Stephen Erlanger. 39 This would be faint praise indeed, given all the lives wiped out or ruined and the destruction caused to each and every ethnic group. But whether the lives of Kosovo Albanians had been made even significantly better was debatable. Albanian refugees returned to a situation of extreme instability characterized by a violent struggle within the Albanian community for dominance of the new Kosovo. This struggle saw much violence directed against dissidents, including the murder of 2 Kosovo Albanian judges in December 1999, and terrorist acts of a clear matrix, as organized crime sought to take advantage of the open border with Albania to evade justice and carry out an illegal traffic in arms, drugs, oil, and so on. 40 The economy of Kosovo also suffered the classic distortions of war and military occupation. Not only were the Serbs expelled from factories, but many factories were dismantled and plundered, and their parts sent to Albania by criminal bands. 41 A coercive sex economy thrived in the zones with the densest foreign presence, military and civilian, which takes advantage of services that can be deemed as voluntary or even mercenary only with a lot of hypocrisy. 42 NATO sought to defend its war as a just and necessary action, a pure rescue operation for the Kosovo Albanians who were at the mercy of a genocidal regime. 43 But most of the world was deeply distrustful of NATO's motives, or more precisely of America's motives, because it was clear from the outset that this operation was conceived and executed primarily by the Americans. The US EU 80% of all strike missions, 90% of the advanced intelligence and reconnaissance missions, and read 95% of the cruise missiles. The other 18 NATO members representing the international community merely provided political cover, and even some restraint. They were, in fact, excluded from all targeting decisions and intelligence involving American missiles or planes, in other words 80% of what was going on. 44 People had a hard time swallowing the notion of the United States using its military power for humanitarian reasons, given its long and consistent record of purely self-interested aggression, its failure to intervene where its interests weren't at stake, its support for human rights abusers, and its human rights abuses of its own citizens. 45 Michael Ignatieff argues that the requirement that he who casts the RST stone should be without sin is a guarantee of inaction, and that the fact that the West does not live up to its ideals does not invalidate the ideals or invalidate their defense. 46 But the point was not whether the Americans were hypocrites, the point was whether, with their unbroken record, they should be trusted when they claimed that the kind of damage they did to human life in Kosovo, and would do again in Afghanistan and Iraq, was really for the good of the people they were bombing. Another powerful reason for opposing NATO's intervention was that the countries doing the bombing bore a large measure of responsibility for the Balkan crisis that the bombing was supposed to solve. This argued against the humanitarian intent of the interveners. They didn't care about the people before, what made us think they cared now? And, more importantly, it argued against the necessity of war by pointing to the peaceful alternatives that had always been in the hands of those doing the bombing. NATO tried, characteristically, to blame the whole thing on one evil person. The seeds of tragedy can be traced to the rise to power of Slobodan Milosevic. 47 But the war's critics hammered away at the widely accepted decisive contribution made by the United States itself, along with the rich countries of Europe, to the disintegration and descent into violence of the former Yugoslavia. The history of the West's complicity in the Balkan tragedy has often been told, and need not be repeated here. 48 In broad outline, it is a story of the rich countries of Europe and America taking advantage of the sad state of the post-Soviet economies to impose solutions through powerful credit institutions like the IMF and the World Bank. These solutions were highly favorable to the Western investors but devastating to the people of the countries concerned, leading to fiscal crises and massive depressions throughout Eastern Europe. Part of the goal was to encourage the fragmentation of the old Soviet bloc to create in its place hub-and-spoke arrangements dependent on the West. Economic advantages were matched by strategic ones, involving nothing more sophisticated than the old divide-and-conquer strategy and the ancient rule that debt and subjection go hand in hand. Yugoslavia was one of the early victims of shock therapy. By the time of its dissolution crisis in the 1990s, its economy was destroyed and its federal government bankrupted. This would try the civil peace of any country, as shock therapy architect Jeffrey Sachs explained. Bankrupt governments are prone to fail. Rarely does that failure mean a simple reversion to old practices, often it means a more dangerous state of affairs, including criminality, political extremism, civil unrest, hyperinflation, capital audit, and, in the worst cases, civil war. 50. Economic crisis does not inevitably lead to civil war, but Yugoslavia had the necessary additional ingredients in abundance. It was made up of several distinct and economically unequal ethnic communities, with a very short history of being uni-ed in a federation. On the eve of the dissolution crisis, the Serbs were the dominant ethnic group, followed by Croats, Slovenes and Albanians. But ethnic Serbs were mostly concentrated in Serbia, and the richest republics were Slovenia and Croatia to the north, where Slovenes and Croats were respectively dominant. The poorest region in the country was Serbia's province of Kosovo, where Albanian Muslims constituted the majority. The next poorest was Bosnia-Herzegovina, divided 66. Ethnically between Muslims, Serbs, and Croats. The economic crisis made it impossible for the federal government to provide the material incentives necessary to satisfy the various constituent elements. The richer republics of Slovenia and Croatia had little reason to stay with a sinking ship that was taxing it for redistribution payments to the poorer regions, while the poorer regions, like Bosnia and Kosovo, had little reason to hang on to what was left. The contribution of the Western countries to Yugoslavia's civil war did not end with their precipitation of a profound economic crisis. Their management of that crisis was characterized by the same self-centered recklessness. With the Cold War over, a united Yugoslavia as a foil for the Soviets was no longer of any value to the Western countries. Now their geopolitical and economic interests were all in favor of disintegration, which they did not leave to chance but rather encouraged despite the obvious dangers of ethnic civil war. Slovenia's independence was relatively painless, as there was only a tiny Serb minority, but in the case of Croatia, Europe underwrote independence despite the profound opposition of a Serb minority that was 600,000 strong, about 15% of the population, and that quite naturally preferred to keep its well-dened enclaves united with Yugoslavia and their Serb co-nationals. The result was an absolutely predictable civil war, which, though brief, saw thousands dead on both sides and hundreds of thousands ethnically cleansed, violently forced into refugee status to create facts on the ground for future territorial claims. The independence of Croatia and Slovenia, and the virtual collapse of the federal state, enormously increased independence pressures on the precariously balanced multi-ethnic Bosnia, which was about 43% Muslim, 31% Serb, and 17% Croat. But as much as independence appealed to Bosnian Muslims, it was seen as a threat by the Serb and Croat minorities, who naturally sought closer links to their parent republics. And when the Bosnian Muslims declared independence in April 1992, a vicious war broke out that would last 3 years and see tens of thousands dead. 51. The Europeans had been more cautious about Bosnia than they had been about Slovenia and even Croatia. They earnestly sought a solution that amounted to ethnic cantonization with a great deal of autonomy for each community. Agreement between the factions was almost reached on this basis in Lisbon in February 1992 and again in March, before war broke out, and it was almost reached again on several occasions during the first year of the war. These latter peace bids were under the joint auspices of the United Nations and the European Union, represented by the American Cyrus Vance, former Secretary of State under President Carter, and David Owen, former UK Foreign Secretary under the Labour government of James Callaghan. Owen has written a detailed account of the Vance-Owen peace plans. 52. According to him and many other authoritative sources, a major obstacle to achieving a peaceful settlement was American intervention. Both the Bush and Clinton administrations took it upon themselves to sponsor the Bosnian Muslims, and encouraged them to avoid compromises on the promise of support, including military intervention by NATO. For instance, of the Lisbon Agreements of February 1992, the Canadian ambassador to Yugoslavia at the time, James Bissett, has written, "The entire diplomatic corps was very happy that the Civil War had been avoided, except the Americans." The American ambassador, Warren Zimmerman, immediately took off for Sarajevo to convince Izetbegovic not to sign the agreement. 53. Zimmerman later admitted this, although he claimed, implausibly, just to be helping Izetbegovic out of an agreement with which the latter was uncomfortable. 54. However, according to a high-ranking State Department official who asked not to be identified, quoted in the New York Times, his policy was to encourage Izetbegovic to break the partition plan. It was not committed to paper. 55. That was Bush Sr. As for Clinton, in February 1993 David Owen made this public statement. "Against all the odds, even against my own expectations, we have more or less got a settlement, but we have a problem. We can't get the Muslims on board. And that's largely the fault of the Americans, because the Muslims won't budge while they think Washington may come into it on their side any day now. It's the best settlement you can get, and it's a bitter irony to see the Clinton people block it." 56. The U.S. then engaged in a long tug-of-war with the United Nations over authority to use NATO airstrikes, and was ultimately successful in obtaining it, explicitly, in several all-necessary means resolutions, but only under United Nations control. 57. The U.S. used this authority to bomb Serb positions in May 1995. The Serbs responded by bombing unestablished safe areas and taking UN soldiers hostage. In August NATO struck again, this time massively. Then the Americans supplied the missing ingredient, not bombs, but pressure on the Muslims. In Sarajevo and in New York the Americans were for the first time exerting real pressure on the Bosnian Muslims to agree to an overall settlement package. 58. There quickly followed a peace agreement in November in Dayton, Ohio, which resulted in a new Bosnia-Herzegovina, not far from what had been agreed to at Lisbon in 1992 or Geneva in 1993, except that it would now become a permanent protectorate run by NATO, and of course it had been brokered by American military power. 59. Boutros. 68. Boutros Ghali was the Secretary General of the UN from 1992 to 1996. This was his assessment of the American contribution to peace in Bosnia. In its first weeks in office, the Clinton administration had administered a death blow to the Vance-Owen plan that would have given the Serbs 43% of the territory of a unified state. In 1995 at Dayton, the administration took pride in an agreement that, after nearly 3 more years of horror and slaughter, gave the Serbs 49% in a state partitioned into 2 entities. 60. Kosovo. NATO's military support for the Bosnian independence movement greatly encouraged the separatist aspirations of the Albanian Muslims of Kosovo, the southernmost province of the Republic of Serbia. This was a region that had been disputed periodically by Serbs and Albanians since the 14th century, but which had a huge Albanian majority. The Albanians had demanded and been granted significant autonomy by the Yugoslav Constitution of 1974. When the bitter economic crisis of the 1980s hit, tensions were heightened further. A New York Times story of November 1, 1987 describes a Kosovo that was highly autonomous but increasingly hostile to Serbs. Ethnic Albanians already control almost every phase of life in the autonomous province of Kosovo, including the police, judiciary, civil service, schools, and factories. As Slavs flee the protracted violence, Kosovo is becoming what ethnic Albanian nationalists have been demanding for years, an ethnically pure Albanian region. 61. As well as being home to several 100,000 Serbs, Kosovo was also a place of great cultural and religious meaning to the Serbs as a whole, full of medieval Orthodox Christian monasteries and monuments. U.S. Ambassador Warren Zimmerman conceded that Kosovo is to Serbs what Jerusalem is to Jews, a sacred ancestral homeland. 62. It was also a place of great mineral riches. The Trpca mine complex was not just the site of alleged atrocities, it also generated 25% of the entire regional industrial output and figured as one of the principal sources of exports for the entire former Yugoslavia. 63. The year of the New York Times story was also the year of Slobodan Milosevic's infamous speech, which, according to NATO's official story, was the start of all the trouble. 64. In this speech Milosevic promised the Serb minority, "No one has the right to beat you. No one will ever beat you again." It's hard to understand how these could be regarded as immoderate words, given what everybody concedes was going on, including the beating of Serbs. Milosevic was elected president in May 1989. Earlier that year a constitutional revision had cut back on Kosovo's autonomy under the 1974 constitution. This was partly in reaction to Albanian separatism, but it was also directly related to the West's economic strangulation of Yugoslavia. In 1988 the IMF made the provision of a loan of $2.2 million conditional on centralized control of the economy. According to Susan Woodward, he pressures from the IMF and the banking consortium organized by the U.S. State Department to recentralize monetary control and create more effective economic administration were a primary reason for the Serbian constitutional revision reducing its province's autonomy. 65. From 1989 to 1996 the Albanians, under the leadership of Ibrahim Rugova, employed a mainly nonviolent form of opposition to Serb rule. They could not fail to be caught up in the dissolution of Yugoslavia, and in September 1991, shortly after the independence declarations of Slovenia and Croatia, a clandestine vote for independence was held and Rugova was elected president of the Proto-Kosovo. The Albanians boycotted Serb institutions and set up parallel ones. The turn to violence came only in 1997, and appears to have had nothing to do with Serb repression. A part of the Albanian independence movement became impatient with nonviolent methods, a mood change evidently related to the collapse in 1997 of the economy and government in Albania proper, the disbanding of its army, the looting of its arsenals and the consequent appearance of a mass of cheap arms on the market, which found their way into the hands of the Kosovo separatists. Thus the appearance in late 1997 of the Kosovo Liberation Army. The methods of the KLA were rather different from the nonviolence of Rugova. The first actions of the selective assassination of Albanians accused of collaboration with the Serbs. Subsequently they go on to attack police patrols and posts. 66. By February 1998, the KLA had launched a full-scale insurrection in which they took brief control of 40% of Kosovo. 67. The road to Rambouillet. In the year before the bombing campaign, violence dramatically increased in Kosovo, though the 2,000 dead on both sides combined were no more numerous than in many contemporary conflicts where the U.S. chose not to intervene. 68. There are enormous controversies about this year, but the facts that are beyond dispute show clearly that, far from seeking to avoid a fight, NATO was bent on provoking one. The KLA itself made major and deliberate contributions to the escalation of the violence, and this was aimed precisely at drawing NATO intervention on their side, on the Bosnian precedent. NATO knew this and encouraged it. This means that the KLA and NATO themselves bear a large share of the responsibility for the violence in Kosovo, and, moreover, that military intervention was not a humanitarian necessity but rather entirely avoidable. That the KLA was a full party to the spiral of violence was well understood at the UN, where Security Council resolutions were even-handed in their condemnation of the use of excessive force by Serbian police forces against civilians and peaceful demonstrators in Kosovo, and all acts of terrorism by the Kosovo Liberation Army. 69. Of course, terrorist was even then about as bad a label as you could nd in the US lexicon, signifying everything that is hateful and justifying the most extreme responses, so it is remarkable that it is associated in a Security Council resolution with the KLA, since all Security Council resolutions have to be agreed to by the United States itself. Yet, at the very moment of this resolution, NATO had already started preparing for military options against the Serbs. In fact, as told by Lord Robertson, American diplomacy consisted of little more than NATO threats to intervene militarily against the Serbs. Experience had taught that diplomacy without the threat of force would be wasted on 70. But even NATO had to admit that any balanced analysis of the situation in Kosovo would acknowledge that serious acts of violence and provocation were committed against the Serb population by Kosovar Albanians, and in particular by the KLA. According to NATO, though, these paled in comparison to the premeditated, well-orchestrated, and brutally implemented campaign of violence and destruction conducted by the forces of the Yugoslav regime against the Kosovar Albanian population. 71. This referred to the Serbs' ferocious military responses against the villages where the KLA had taken control, amounting to 40% of Kosovo by the summer of 1998, but it was really no more than the classic response of superior forces to popular guerrilla activity, regularly deployed by Israel against the Palestinians in territories acknowledged to be occupied. The Americans deployed it in Vietnam with a savagery unknown to the Middle East or the Balkans, and without the justification of defending their own territory from a separatist group, they would deploy it within a year in the battle for Kosovo itself, when they attack Serbia to break the morale of the people and force Milosevic to capitulate. But what could NATO's threats of military intervention mean, not to the Serbs, but to the KLA? How could the KLA miss the clear signal that their provocations would be understood by NATO, but that retaliation by the FRY would bring forth dire threats and, ultimately, if only for the sake of credibility, military intervention? According to Michael Ignatieff, writing from a pro-interventionist point of view, this was explicitly discussed by the KLA and the Balkan proconsul Holbrooke in December 1998, when Ignatieff accompanied Holbrooke on a visit to Kosovo. The Kosovars' taste for compromise is vanishing fast. There is already talk that the hidden Kosovar strategy is to provoke the Serbs into massacres and reprisals, which would force NATO troops to intervene. The first stage in provoking NATO intervention would be to drive out the unarmed monitors. Armed NATO troops would replace them and impose independence, or at least partition, on Milosevic. Such, at any rate, is the desperate dream. Holbrooke may favor a robust armed deployment himself, but he knows how reluctant NATO would be to authorize one, so he does his best to close down the idea that NATO is waiting in the wings to ride to the rescue. 72. Some desperate dream, it would come true within a span of just 6 months. But NATO reluctant? In December 1998, NATO had already explicitly threatened Yugoslavia with air attacks in September. Though the Security Council had condemned both sides, NATO's threats were reserved for the FRY 73, thus the FARI was persuaded to agree to withdraw troops from Kosovo and allow in a Kosovo verification mission under the auspices of the Organization for Security and Cooperation in Europe. The agreement was endorsed by Security Council Resolution 1203 of October 24, 1998. This resolution once again condemned violence on both sides and, most notably, given the war footing that NATO had put itself on and the claims that it would later make to implicit authorization for war by the Security Council, it pointedly reaffirmed that, under the Charter of the United Nations, primary responsibility for the maintenance of international peace and security is conferred on the Security Council. The resolution also repeated the commitment of all member states to the sovereignty and territorial integrity of the Federal Republic of Yugoslavia. Calm returned for a while when the Kosovo verification mission began to function. According to the Secretary General's report of December 24, 1998, 100,000 refugees had returned home. However, by the time Holbrooke was meeting with those desperate dreamers in the KLA, violence had returned. What is striking is how well understood it was in UN circles that the pattern was the familiar one of provocations by KLA paramilitaries and response by Serb authorities. Here's an excerpt from the Secretary General's report under the heading Obstacles to Return/Security, 74. On November 20, 2 policemen were killed and 3 injured in a suspected ambush by Kosovo Albanian paramilitaries in Prilep. On December 14, 30 Albanians were killed and 12 wounded near the Gorozep and Liken border posts in Gding between Yugoslav border guards and a group of armed Albanians. That same day, 2 masked men entered and attacked patrons in a cafe in Pek, killing 6 Serbs. On December 18, the deputy mayor of Kosovo Palje was kidnapped and murdered. Following the October 13 accord, Kosovo Albanian paramilitary units have taken advantage of the lull in the Gding to re-establish their control over many villages in Kosovo, as well as over some areas near urban centers and highways. These actions by Kosovo Albanian paramilitary units have only served to provoke the Serbian authorities, leading to statements that if the Kosovo Varikatayan mission cannot control these units, the government would. Rakok. The die of the Kosovo War was cast on January 15, 1999 at the small village of Rakok, just south of Pristina. The ICTY indictment of Milosevic, which came only 4 months later, put it simply enough: on January 15, 1999, 45 unarmed Kosovo Albanians were murdered in the village of Rakok. This is an event well worth pausing over if one wants to understand how international criminal law can be manipulated to legitimate an illegal war. It became known to the world when the head of the OSCE mission, William Walker, held a press conference the following afternoon, and denounced the killings as a massacre and a crime against humanity, for which he did not hesitate to accuse the government security forces of responsibility. 2 days later, Chief ICTY Prosecutor Louise Arbour arrived at the border of Kosovo demanding entry to investigate the crime, which the Frye government denied her. As chance would have it, she was accompanied by film crews and the scene was broadcast around the world, along with details of the mutilated bodies of 45 ethnic Albanians in a gully, men, women, and a child murdered in cold blood. 75 Rakok quickly became the emblematic episode of Kosovo. Bill Clinton played it for all it was worth. On March 19, 1999, in his justification of the war he was about to launch, the president told the world's press, "We should remember what happened in the village of Rakok, where innocent men, women, and children were taken from their homes to a gully, forced to kneel in the dirt, sprayed with gunfire, not because of anything they had done, but because of who they were." 76. But the Serbs had a different version of events, one that has received some considerable corroboration from independent sources. There is no dispute, for example, that this was a pre-announced police action against Rakok and 3 other villages to track down a KLA group that had attacked a police patrol a week before and killed 4 policemen. There is no dispute that heavy fighting took place, after which the Serbs withdrew and KLA fighters reoccupied the village. There is no dispute that KLA fighters were also killed in the fighting. 77. According to the Serb version, however, all of the dead were either KLA fighters or civilians caught in the crossfire. There was no massacre of civilians, but the KLA had plenty of time to dress their dead fighters in civilian clothes, arrange bodies in the gully, and then call in Walker and the press. There was some corroboration for even the contested elements of the Serb version. 78. The EU sent a team of Finnish forensic investigators to perform autopsies. They performed or witnessed about 40 autopsies on the Rakok bodies, alongside Frye and Belarusian pathologists. The Frye team confirmed the Serb version in most respects, though the change of clothes hypothesis was discounted. According to one of the Serb investigators, Dr. Dusan Dunjic, criminological technicians confirmed the presence of traces of gunpowder explosion on the hands of 37 out of the 40 examined bodies. The discovery of traces of gunpowder explosion indicates that directly before death, these people had handled firearms. All these facts led the investigating bodies to conclude that this concrete case did not involve a massacre in the village of Rakok, but a legitimate battle of the authorities against terrorists. 79. The EU forensic mission did not make its own endings available to the public, but on March 17, 1999, that is, on the day before the collapse of the Rambouillet talks, the head of the EU mission, Dr. Helena Ranta of the University of Helsinki, was asked by the presidency of the EU to give a press conference in Pristina about Rakok. In other words, this was not the fortunate coincidence for NATO that a Western diplomat made it out to be. The publication of the report in the midst of the talks may be a coincidence, but if it damns the Serbs, it will certainly add to the pressure and form part of the justification for any NATO action. 80. Nor was OSCE mission head William Walker taking any chances with what Ranta would have to say. Shortly before the press conference, they had an intense meeting that was later described by Ranta as a very unpleasant experience indeed. 81. Ranta seems to have struggled at the press conference. Not to let her professional duties succumb to political importuning, but she was only partly successful. She underlined the fact that the statement was only her personal view and should not in any manner be construed as an authorized communication on behalf of the EU forensic expert team. 82. But she then proceeded to go well beyond what she or her team had observed, and the result was very favorable to the NATO version of events. In several respects, she simply relied on what she had been told by Walker or his opchales. For example, on the very important question of whether the 22 men, not 45 men, women, and children as reported, had been shot in the gully where they had been found, she said, based on the information obtained from the KVM and KDOM observers, the total of 22 men were found in a gully close to the village of Rakok. They were most likely shot where they were found. 83. She made this entirely hearsay-based statement despite her earlier caveats that the team's investigations were hampered by the fact that they had only arrived a week after the deaths, that there had been no chain of custody of the bodies from the moment of death, and that, therefore, what may or may not have happened to the bodies during that time is difficult to establish, with absolute certainty. 84. Notice that even this wasn't good enough for Bill Clinton, who, in his pre-bombing press conference, invented the presence of women and children among the dead in the gully and even had them kneeling in the dirt, innocent men, women, and children taken from their homes to a gully, forced to kneel in the dirt and sprayed with gunnery. At the press conference, Clinton was also asked, apropos of the Lewinsky affair, what do you think your legacy will be about lying? 85. At her press conference in Pristina, Ranta concurred with the Yugoslav pathologists on some matters, but she went beyond observation to conclude, differently from the Yugoslav pathologists, that here were no indications of the people being other than unarmed civilians. 86. Still, she cautiously added, medico-legal investigations cannot give a conclusive answer to the question whether there was a battle or whether the victims died under some other circumstances. 87. At least she was cautious in her prepared statement. Her reported ad-lib responses to questions from the audience included a statement for which she had no professional competence, and very little, if any, basis in personal observation. This is a crime against humanity, yes. This naturally formed the headline of the news stories of the following day. 88. There was another highly misleading element to Dr. Ranta's statement that is so subtle it is impossible to grasp from reading the statement alone. As if to confirm her point about unarmed civilians, Dr. Ranta said that the Paraffin tests for gunshot residue used by the Yugoslav and Belarusian pathologists had been scientifically discredited in favor of an electron microscope and X-ray method known as SEMI-DX. Now, what could the following statement in her press release mean to anyone but that the latter tests had been done on the Rakok bodies and proved negative? Test samples for SEMI-DX were taken and they proved to be negative. 89. But the key word was test, because, as Dr. Ranta revealed to me in July 2001, these tests were not performed on the bodies found in Rakok at all. Tests on the bodies from Rakok would have been useless if not taken within 2 to 3 hours of death, so I ordered samples to be taken from certain other sites. 90 Not Rakok but other sites, where other people had been killed. When she took the witness stand in 2003 at Milosevic's trial, it was evident from the confusion of the prosecutors that Dr. Ranta had not disclosed this particular detail to them either. Nor did she take the occasion to do so on the stand, though she did point out the utter uselessness of the SEM-EDX test by the time her team arrived upon the scene, something completely absent from her crucial press release of March 17, 1999. Dr. Ranta did maintain that, in her opinion, on the basis of the bullet fragments found much later at the site, at least some of the victims were killed where they fell, and thus the event had not been staged, or at least not completely. However, she disclaimed any ability to say whether any had been executed, and she had no answer for the point made to her on cross-examination that the many layers of clothing, KLA trinkets, and gun belts worn by some of the autopsied indicated pretty clearly that they were GDRs 91. In February 2001, several members of Dr. Ranta's team published a report of the 40 autopsies, which seemed to support the Serb position. 92 The report revealed that all but one of the victims were male, all but one were over 15, and only one had been shot at close range. Unlike Dunjic and Ranta, these team members denied any capacity to judge the circumstances of the victims' deaths, determination of reasons for events, their political and moral meanings, or connection of victims to political or other organizations are questions which lie beyond the scope of forensic science. 93 Finally, they stood up for the professionalism of their Yugoslavian and Belarusian colleagues. Having some differences in practical questions between different schools complemented the end result. The autopsy endings were discussed in full professional consensus. 94 So NATO's version of the events at Rakok has been thoroughly discredited, and the Serb version seems, on the evidence, to have stood up much better, though certainly not completely. But two things are absolutely clear, and critically important for understanding this and subsequent events. First, to the extent there was a massacre, it was provoked by the KLA as part of a deliberate and consistent pattern aimed at bringing on NATO's military. 75-75. 76. Intervention. Second, as far as NATO was concerned, Rakok was not a reason, but an excuse, more like a pretext, for the bombing campaign. Even supporters of the NATO bombing had to admit that the KLA's tactics were designed to provoke the Serbs into violent overreactions that would bring on the bombs. Michael Ignatieff was already writing in December 1998. Hit-and-run attacks on Serb military and police targets exposed civilians to reprisals. Then they tried to liberate villages and towns, which they had neither the arms nor the men to hold. As soon as they were driven out, the Serbs massacred or evicted the population. It is more than possible, of course, that KLA tactics were not a miscalculation, but a deliberate strategy, designed to incite Serbs to commit massacres that would eventually force NATO to intervene. 95. More than possible is an interesting way of describing something that is otherwise impossible to understand. As the UN Secretary General reported, the KLA had been provoking this kind of massive retaliation all year, indeed since their inception. 96 Had they been doing it for the pleasure of seeing their own people die? Ignatieff, for no apparent reason, seems to think that Rakok was an exception, but other commentators have been more logical. His was entirely consistent with the KLA's pattern of provoking or condoning anti-Albanian atrocities by Serbs in order to stir up international opposition to Milosevic, as the Rakok massacre did. 97 So if it was a massacre, it was a useful massacre, and one for which the KLA has to bear a heavy responsibility. More importantly, it was an avoidable massacre. It was avoidable by the simple device of NATO's refusal to entertain intervention on the KLA's side. But NATO presented Rakok as a reason for military intervention. And this is the second important point about Rakok: it could not in a million years have been a reason for intervention, because, whatever the Americans believed to have really happened at Rakok, the responsibility of the KLA at least for provoking it was all too obvious. Or are we supposed to believe that the Americans were the only ones who didn't know what the KLA were up to? This isn't merely logic, there is also a smoking gun in the person of William Walker himself, the man who denounced the event to the world. From the fact that he was head of the OSCE Verikatayan mission, rated by UN resolution, you might think he was some European technocrat representing the international community. In fact, Walker was the opposite of this. He was, before, after and at the time of Rakok, a career American diplomat and a full-time employee of the U.S. State Department. His boss was Madeleine Albright and he had spent his whole working life 76 representing American interests. A complete newcomer to the Balkans, his specialty was Central America, where he was in charge of some very sensitive and unsavory missions. In the Reagan years he rose to Deputy Assistant Secretary of State for all of Central America. This was precisely the moment of Reagan's violent crusade against the Sandinistas in Nicaragua, complete with condemnations by the World Court. In fact, Walker was formally a subject of investigation in the Iran/Contra affair for his involvement with Oliver North in activities that led to North's indictment for the illegal funneling of guns, ammunition, and supplies to the Contra rebels who were trying to restore a version of the overthrown Somoza dictatorship. In 1988, Walker was named ambassador to El Salvador, a country which, at the time, was still in the grip of US-sponsored state terror. Walker was, in fact, famous for another massacre before Rakok, a massacre in late 1989, when Salvadoran soldiers executed 6 Jesuit priests, their housekeeper, and her 15-year-old daughter. Walker was not charging anyone with crimes against humanity then, I'm not condoning it, but in times like this of great emotion and great anger, things like this happen. As the Los Angeles Times of April 14, 1999 pointed out, this reputation as a crusader for human rights represents quite a change for Walker. 99 How did Walker get to be head of the OSCE Observer Mission? The OSCE is European in name only, in fact, it is more like NATO plus Russia. The presidency during the period of the Verikatayan mission was held by 3 NATO countries, Germany, Italy, and Norway. Walker was put where he was by Madeleine Albright, a fact he grudgingly admitted later on the witness stand at the Milosevic trial. 100 In fact, only 1 week prior to Rakok he gave an on-the-record briefe in which he left no doubt who he worked for, or what his job was. 101. Ambassador Walker, let me just begin by reminding everyone in the room that even though I was introduced as the head of OSCE, I am a serving career Foreign Service officer, but in my present capacity, I guess I'm speaking on behalf of the OSCE in Vienna and the KVM mission in Pristina. Walker was then asked out whether he was spying for Washington the way Richard Butler, head of UNSCOM, was by then known to have been spying in Iraq. 102 Walker denied that but admitted he reported back to Washington as well as all the capitals. Michael Ignatieff, in his defense of NATO's bombing campaign, concedes that Walker's Rakok denunciation appeared to bring the Verikatayan mission squarely down on the side of the KLA at a time when human rights violations were occurring on both 78 sides. 103 But he claims that Walker was acting on his own in calling the Rakok press conference. Having seen for himself, Walker did not clear his next move with Washington. At a press conference immediately afterwards, he called the Rakok massacre a crime against humanity and left no one in any doubt who was responsible. 104. Sure. Here was a lifelong diplomat, an employee of the State Department, who had never in his life been known to say anything publicly that the State Department did not want to hear. Spring has come early, Madeleine Albright is reported to have told National Security Advisor Sandy Berger when she first learned of Rakok. 105 It was even being openly stated in Washington circles as early as the previous August that Clinton was looking for just such an atrocity-type triggering event. 106 And Walker cleared his denunciation not only with Washington, but also with NATO command. While he was standing among the bodies at Rakok, He pulled out his cell phone and called Supreme Commander Wesley Clark. It was Clark who revealed this, not Walker. At the Milosevic trial in The Hague 3 years later, Walker claimed on the witness stand that he had no recollection of telling Clark, but would have to accept Clark's version, as well as that of Richard Holbrooke, Albright's man in charge of Yugoslavia. With the same breath that he swore he could not remember calling Clark and Holbrooke, while conceding that he did, Walker testified that he remembered not calling Madeleine Albright. Q. In your statement, you say that you do not remember having talked to Clark, Holbrooke, Albright, or the OSCE prior to the press conference in Rakok. You say, I cannot exclude the fact that my memory is lacking on that score. Let me remind you. Can we see some footage? Can we have the video played, please? Mr. Holbrooke, Walker, the head of the Kosovo Varikatayan mission, called me on a cell phone from Rakok. General Clark, I got a call from Bill Walker. He said, there's a massacre. I'm standing here. I can see the bodies. Q. Do you need to comment this at all? I leave it to you to decide. A. I stick by my statement. When I had that interview with BBC, I had no recollection whatsoever of having talked to either of those two gentlemen. As I said yesterday, there was tremendous commotion and activity going on in the immediate aftermath of my visit to Rakok and 78 June 5, 04, 1:17 and 8 seconds p.m. June 5, 04, 1:17 and 8 seconds p.m. Kosovo 1999-79. Before I made the press conference. Did I talk to those people? Are they telling the truth when they say they talked to me? I have no reason to doubt it. I believe they are both very honorable and truthful people. So I just have to plead a faulty memory when I was talking to BBC. But I'm quite positive I didn't talk to Madeleine Albright, but I have no doubt that people on my staff were calling the various capitals of the OSCE member states to tell them what had been seen on Rakok that day. Whether I made some of the calls or whether other people on my staff did, at this point in time, I have absolutely no recollection. 107. After speaking to Clark and Holbrooke, Walker went back to his OSCE and called the press conference, where he released a written statement entitled Massacre of Civilians in Rakok, containing this passage. Although I am not a lawyer, from what I personally saw, I do not hesitate to describe the event as a massacre, a crime against humanity, nor do I hesitate to accuse the government security forces of responsibility. The Frye government must produce the names of all involved in the police and VJ operations around Stimelj, who gave the orders, who executed those orders. The International Criminal Tribunal for the former Yugoslavia must come in, with visas, at the invitation of the Frye government, or without, to investigate this atrocity, and this must be accomplished in the next 24 hours. 108. Those working words, and certainly not the kind a career diplomat like Walker uses unless he is sure he has the approval of his superiors. But the reference to the ICTY, with the odd emphasis on visas, reveals yet another convenient memory lapse. The press release was issued on January 16, but in his testimony at Milosevic's trial, Walker claimed he did not speak to ICTY prosecutor Louise Arbour until the following day, that is, January 17. I believe it was the following day I received a call from Judge Arbour, and we discussed what I had seen Bree and what I had said Bree, and I told her I thought it was very important that either she or people from this tribunal, investigators, criminal investigators, come to Kosovo and do a thorough investigation. Judge Arbour reminded me that she had not been able to obtain a visa to enter the former Yugoslavia. She asked me if I thought it advisable for her to try to enter. I told her I thought that would be the best thing. I told her that if she was denied entry or her people were denied entry, that would indicate that the government was not terribly serious about ending out what had happened at Rakok. She said that she would personally get on a plane the following day, I believe it was, on the 18th, and try to enter 79 June 5, 04, 1:17 and 8 seconds p.m. June 5, 04, 1:17 and 8 seconds p.m. 80. Via Skopje, Macedonia, in other words, the southern border. I told her I would send people down. 109. Let's try to make sense of this. Walker claims at the trial that Arbor called him after the press conference, on her own initiative, just doing her job as it were, and wanting to investigate the crimes he had announced to the world, and reminded him of her need for visas. But in fact Walker was demanding that she be allowed to enter with visas at the press conference itself, which means that Arbor must have been informed before the press conference. That's when she must have reminded him about the need for the visas, because he obviously wouldn't need reminding after the press conference where he demanded them on her behalf. She was informed before the press conference, along with the State Department and NATO, and the press statement was worked out, at least in part, with her input. The point of bringing her in was precisely to embarrass the Frye government, and this was discussed with her before the press conference too. The people sent down by Walker also included the international press. That means the whole photo-op appearance of Arbor demanding entry at the Kosovo border was a public relations stunt cooked up to score points against the Serbs. A conscious decision was made by a State Department agent, with clearance from NATO and Washington, to deploy the ICTY prosecutor in this enterprise, and she appears to have lent herself willingly to the cause. We'll pick up this thread later, but for now, could anything be clearer than that? Whether Rakok was a real or fake massacre, it didn't make one bit of difference to the Americans. That it was just the pretext the Americans had been waiting for and now seized upon to justify a decision taken long beforehand to use force against Yugoslavia. That this was precisely the kind of thing that the Americans had been encouraging the KLA to bring down on themselves. And if this is all true, how could anyone possibly accept NATO's plea that this war was a humanitarian necessity that they were dragged into in spite of themselves? Rambouillet. On January 30, Javier Solana sent President Milosevic what he called a final warning, summoning the Serbs to Rambouillet, France, with a prominent invocation of Rakok 110. It is now widely accepted that Rambouillet was a war conference and not a peace conference, meant to justify a decision already taken to go to war, not to avoid it. That's the conclusion of many independent observers, including David Owen. Rambouillet was structured by the Americans in particular to bring matters to a head and create the political climate for NATO to fulfill its threat to bomb the Serbs. 111 key American players have admitted as much. For instance, after the war James Rubin said that while publicly, we had to make clear that we were seeking an agreement, privately we knew the chances of the Serbs agreeing were quite small. The other acceptable outcome was to create clarity where previously there had been ambiguity. That meant the Kosovar Albanians agreeing to the package and the Serbs not agreeing to the package. 112. The idea that Rambouillet was a hoax is overwhelmingly confirmed by the facts. Though it was the Serbs who were ultimately bombed for the failure of Rambouillet, it was they and not the Albanians who immediately accepted NATO's pre-announced so-called non-negotiable principles, which were an immediate end to hostilities, broad autonomy for Kosovo, an executive legislative assembly headed by a president, a Kosovar judicial system, a democratic system, elections under the auspices of the OSCE within 9 months of the signing of the agreement, respect of the rights of all persons and ethnic groups, and the territorial integrity of the Federal Republic of Yugoslavia, with Kosovo remaining within the country. 113. The Serbs had no difficulty in agreeing from the outset to these principles, and maintaining that position throughout. It was on the Albanian side that the objections were raised, RST, that the principles did not go far enough towards independence for Kosovo and, second, that they did not require the presence of NATO, for which the KLA had been working so hard. Evidently, with the Serbs agreeing and the Albanians disagreeing, something had to change, so at the very end of the RST session, a draft agreement was produced by the US with the big innovation of a NATO-led international peacekeeping force. A further concession was made to the Albanian side. They were promised that after 3 years there would be a mechanism for a NAL settlement for Kosovo, on the basis of the will of the people. 114 Everybody seemed to understand this as a referendum on independence that could only go one way, given the ethnic makeup of Kosovo. The key provisions were under the heading of Implementation 2, a late addition to the draft agreement that would give NATO control of Kosovo. The parties invite NATO to constitute and lead a military force to help ensure compliance with the provisions of this chapter. The appropriate NATO commander shall have sole authority to establish rules and procedures governing command and control of the airspace over Kosovo as well as within a 25-kilometer mutual safety zone, of free airspace within 25 kilometers outward from the boundary of Kosovo. In addition to this, there was also a breathtaking Appendix B that gave NATO the complete run not only of Kosovo, but of the whole of the FRI. For example, Article 8 provided, NATO personnel shall enjoy, together with their vehicles, vessels, aircraft, and equipment, free and unrestricted passage and unimpeded access throughout the FRI including associated airspace and territorial waters. This shall include, but not be limited to, the right of bivouac, maneuver, billet, and utilization of any areas or facilities as required for support, training, and operations. Much was made of these clauses in the debate over the war. NATO was even said to have put them there to ensure that Yugoslavia would not sign. There were indiscretions to this effect during Rambouillet. 115 According to Lord Robertson, Appendix B contained merely the standard clauses incidental to peacekeeping arrangements, and no specie objection was raised to it at the time. 116 This is true, but it is only a half-truth, because the FRI's objection was a global one to the whole of the implementation section that invited NATO to take over a chunk of FRI territory. That the Appendix B rights over the whole territory were entailed as standard equipment to that kind of occupation just proved how impossible it was for any self-respecting state to accept the NATO-led presence. The FRI voiced no objection to the rest of the agreement, in effect a complete interim constitution for Kosovo with a huge degree of autonomy within the Yugoslav Federation. The New York Times reported at this point that Mr. Milosevic has shown himself at least as reasonable as the ethnic Albanians about a political settlement for Kosovo. 118 And indeed, when they paused the conference on the day the draft agreement was tabled, the official statement by the co-chairs admitted that there was consensus on the political elements, and that all that remained to be finalized were the implementation chapters including the modalities of the invited international civilian and military presence in Kosovo. But to the co-chairs these had suddenly become as crucial as the rest. It is essential that the agreement on the interim accord be completed and signed as a whole. 119 In the period between Rambouillet and Paris, the desperately peace-seeking Americans and British were being condemned at the Security Council for their humanitarian bombing of Iraq, which, during the Rambouillet conference itself, took the lives of at least 11 Iraqi civilians. 120 The Serbs, meanwhile, were working furiously on a counter-proposal for an international presence alternative to NATO. But when the talks resumed in Paris on March 15, it was clear that negotiations were over and the whole thing was now a formality, because the Americans had obtained the Albanian signatures and they didn't have the slightest interest in what the Serbs had to say. The one-sided signing ceremony took place on March 18, 1999 in the presence of the two NATO mediators, but not, pointedly, the Russian Boris Mayersky, who agreed with the FRI objections to the NATO clauses. 121 The very next day the OSCE ordered its observer force removed, over the protests of the FRI. NATO told the FRI to sign what the Albanians had signed or be bombed. 5 days later the bombing began. What was the urgency? If America wanted to go to war, there was plenty, as there would be in Afghanistan and Iraq in the coming years. Everything was in place, including an enormously complicated multi-billion-dollar military operation. Rakok was still fresh, the Albanian signatures were on the documents, and nobody had time to scrutinize the events. But if there had been a real desire to make peace, was there no alternative? According to independent observers, Significant progress was being made by the observer force right up to the moment of the ordered withdrawal. 0 international refugees in the VE months preceding the bombardment, only a few thousand internally displaced persons in the weeks before the air bombardment commenced, and success in mediation programs between the various ethnic communities. The main obstacle was the familiar one of repeated KLA provocations. 122 Indeed, the provocations of the KLA continued unabated in the period between the adjournment talks at Rambouillet and their recommencement in Paris on March 15, in flagrant violation of the conditions set by the co-chair's statement of February 23. 123 The Ferry government maintained throughout the war that its opposition to NATO occupation was not opposition to an international presence to implement an agreement on self-rule. Its position was even vindicated in the actual peace accord signed by the FRY on June 3 and ratified by the Security Council on June 11, which approved the deployment in Kosovo under United Nations auspices, acting as may be decided under Chapter 7 of the Charter of an International Security Presence with substantial North Atlantic Treaty Organization participation, deployed under UNIED command and control. 124 NATO had insisted on NATO alone, but only until it had bombed the FRY into submission. 125 NATO claims the Rambouillet talks were a sincere effort to find a peaceful solution, and that it was Milosevic's failure to negotiate in good faith that caused them to fail. It is clear the Yugoslav government never seriously sought a negotiated peace at Rambouillet. 126 But how clear is it, since the Yugoslav government accepted all the so-called non-negotiable principles and the Albanians didn't? And the Albanians only signed when the Albanians and NATO got the additional clauses they wanted inserted? Here is what even the pro-interventionist Goldstone Commission wrote a year after the war. In fact, Albright and others had been so rm about the supremacy of NATO over any other institutional actor in this context, that there was little reason for Serbia to have expected exibility from NATO. 127. The very fact that it was NATO and not the FRY that broke off the talks would suggest that it was NATO and not the FRY that was the obstacle to peace. NATO's answer to this was that Milosevic was planning to expel the ethnic Albanians anyway, bombing or no bombing. The plan even had a code name, Operation Horseshoe. 128 The Serbs were pretending to be reasonable at Rambouillet just to buy more time to prepare. NATO saved lives by breaking off the talks and going to war. Far from being responsible for what happened on the ground during the bombing, NATO was responsible only for ending it. On April 11, 1999, the New York Times reported German Defense Minister Rudolf Scharping as saying, "Our analysis of Operation Horseshoe sadly confirms what we had inferred during the negotiations, which is that Milosevic wanted to win time to prepare a systematic deportation." 129 But neither the German government nor anyone in NATO ever produced any evidence to support the existence of Operation Horseshoe, apart from a series of maps the German government itself had drawn up. Nor did they get any mention whatsoever in the ICTY indictment of Milosevic. After the war, a retired German general denounced Operation Horseshoe as a complete fake. The maps were fabricated from a general Bulgarian intelligence report about FRY tactics against the KLA that had nothing to do with expelling the civilian population. The name was simply made up by the German Defense Ministry. 130 No doubt the Ferry had a contingency plan for occupying Kosovo and driving out the KLA in case of the invasion that NATO had been planning since June, and threatening since September of the preceding year. Even living in total peace and security, the US has innumerable contingency plans for actions ranging from nuclear to lesser actions. 131 Indeed, the KLA's operations on the ground during the war were lethal for Serb forces, informing NATO command on their positions and drawing them out into the open so they could be pulverized by NATO's bombs, hundreds at a time. 132 NATO's claim that it intervened to prevent genocide is also refuted by the very way it conducted the war. Withdrawing all of the observers and giving 84 June 5, 04, 1:17 and 9 seconds p.m. June 5, 04, 1:17 and 9 seconds p.m. Kosovo 1999-85. VE Days of Warning, followed by a desultory bombing that stayed away from the scene of the expected genocide for another week. A real rescue operation would have gone in massively with ground troops and without warning. Peter Gowan argues that there was an acute, indeed bizarre contradiction between the supposed goal, protecting the Kosovo Albanians, and the means, a bombing campaign, which left the Serbian security forces free on the ground to do what they wished with the Kosovar Albanians. 133 The foreseeable results of such a war, planned meticulously for at least a year, were largesse of refugees and intense warfare between Serbian security forces and suspected KLA activists in Kosovo. Furthermore, all such wars produce atrocities, rapes, looting and burning. Even highly trained soldiers can engage in wanton atrocities in war conditions. The tortures and other atrocities committed by NATO troops engaged in peacekeeping in Somalia testify to that. 134 What could possibly explain NATO's starting of the war in this particular way? There is only one serious explanation: the Clinton administration was giving the Serbian authorities the opportunity to provide the NATO attack with an ex post facto legitimation. The United States was hoping that the VE days before the launch of the bombing and the RST week of the war would give various forces in Serbia the opportunity for atrocities that could then be used to legitimate the air war. They could predict also that there would be a refugee ow across the borders into Macedonia and Albania. And the US planners were proved right. As for the Serbian government organizing a genocidal mass slaughter, this did not happen. The Clinton administration organized the launch of the war to invite the Serbian authorities to launch a genocide, but the Milosevic government declined the invitation. 135. Provoke a war with intended anti-humanitarian consequences? Why would NATO do such a thing? Kosovo's material and strategic value to the West does not exactly leap out at you the way Iraq's does. Some argued that at the bottom of this con-ICT were the same Caspian Sea oil reserves that made Afghanistan so strategically significant, namely a secure pipeline, this time to the Mediterranean instead of the Indian Ocean. 136 Diana Johnstone argues that another objective was to solidify a strategic alliance with Muslim countries in the region, and even to pay some dues to Arab allies to offset the resentment over Israel. 137 Chomsky, on the other hand, argues that oil pipelines and the like are far too narrow a way to think of a superpower's interests, and that the notion of credibility is far more powerful an explanatory tool. Credibility was indeed the refrain repeated by the NATO leaders whenever pressed for a reason for going to war against the FRY, for instance in President Clinton's war speech. We must also understand our stake in peace in the Balkans and in Kosovo. This is a humanitarian crisis, but it is much more. This is a con-ICT with no natural boundaries. It threatens our national interests. If it continues, it will push refugees across borders and draw in neighboring countries. It will undermine the credibility of NATO, on which stability in Europe and our own credibility depend. 138. As Johnstone has remarked, credibility in this context has nothing to do with truthfulness and everything to do with readiness to use force. 139 This means the willingness and ability to crush even mere annoyances like Serbia. 140 Credibility is also the other side of the coin of resource control, as Thomas L. Friedman wrote in the New York Times on the very eve of the Kosovo War, the hidden hand of the market will never work without a hidden ST. 141 To credibility one can add the more mundane explanations, the things that are always arguing for superpowers to go to war, if they can just end a suitable excuse. The weapons manufacturers' cash registers rang mightily every time a bomb was dropped on Yugoslavia. 142 The construction companies would make a killing in the reconstruction of Kosovo and, eventually, Serbia. The $1 billion in aid by which donor countries would later extort Milosevic's extradition would naturally wind up in the coffers of donor country companies like Vice President Dick Cheney's Halliburton, whose subsidiary Brown and Root got the contract for Camp Bond-Steel in Kosovo in 1999-143. The immense costs of reconstruction would also have the bounty of putting Yugoslavia at the mercy of Western lenders. 144. The military itself regarded Kosovo as a huge war game that answered a few simple questions. Could you win a war without sending in ground forces? Without losing one life in combat? Could you get away with violating the Geneva Conventions and ending a war primarily aimed at breaking civilian morale? 145. Added to these were the wag the dog political explanations. In the contemporary Hollywood LM of the same name, an American president is involved in a sex scandal and needs a diversion, so Washington calls on Hollywood to create a national war in Albania, no less. In the case of Kosovo, the real-life President Bill Clinton was being dogged by a series of women he had molested or otherwise taken advantage of, and the fallout for the whole Democratic Party was enormous. The Kosovo crisis coincided precisely with Paula Jones' lawsuit against Clinton for sexual molestation, and his public investigation, impeachment, and humiliation for lewd behavior in the Oval Office with the young intern Monica Lewinsky. At his press conference of March 19, 1999, at which the president devoted all of his opening remarks to an explanation of why NATO had to go to war over Kosovo, Clinton answered 9 questions from the assembled journalists. Only 3 were on the subject of Kosovo, the same number as were asked on the subject of his personal morality. The RST1 started this way: Mr. President, when Juanita Broaddrick leveled her charges against you of rape in a nationally televised interview, 146. Monica Lewinsky's dress clearly did not itself launch 1,000 ships, neither, we can rest assured, did Helen of Troy's face, but she occupied a lot more of Bill Clinton's thinking than Kosovo did. 147. Clinton would have had to be very strong and very committed to resist all the forces for war, from credibility, to the military, to the arms manufacturers. The more complicated and difficult road was the one to peace. It is not that he would have chosen this road without her, but Monica would have argued very strongly in his mind for the easier war option. In other words, there were lots of motives, all making much more sense of this war than the wildly out-of-character humanitarian one. This is altogether apart from what could have been achieved had the tens of billions spent on bombing, and then reconstructing everything that was bombed, been devoted to preventive diplomacy such as genuine support for the nonviolent Kosovar movement and addressing the massive polarization of wealth in Europe, since Kosovo is the most impoverished area in all of Europe. 148. Not to mention more pressing humanitarian crises, like the AIDS epidemic that kills about 2 million Africans every year. The $80 billion spent by America on 1 year of war in Iraq could have supplied every African in need with all the required antiretroviral drugs for life. 149. Peter Gowan has a theory about the Kosovo War that has great relevance for the question of how America gets away with murder. Gowan argues that the Kosovo War was essentially fought against the United Nations legal order. Gowan's thesis proceeds both from the demonstrable implausibility of the humanitarian thesis and from the difficulty of identifying any interests in the Balkans themselves that were both worth the effort of the bombing and common to all the NATO countries. He concludes that the Balkan Wars were primarily about political goals outside the Balkans, goals not of the NATO countries, but of the United States. The con-ICT between the Serbian state and the Kosovar Albanians was to be exploited as a means to achieve U.S. strategic goals outside the Balkans on the international plane. 150. The strategic goals had to do with the United States' perennial political and economic rivalry with Russia and the Western European states for dominance in Europe. During the Cold War, Russia was isolated, and the situation of confrontation, combined with U.S. military power, meant Europe had to accept U.S. leadership. With the fall of the USSR, the U.S. was challenged in its leadership role by Germany and France, acting through the increasingly powerful European Union. The U.S. moved to counter this challenge through NATO. It expanded eastward to include Poland, both marginalizing and challenging the Russians. And, most importantly, it sought to develop new tasks for NATO, out-of-area missions that would allow the US to deploy its military assets and once again subordinate Europe politically. The Balkan theater was particularly important for the US, because Europe took the lead at the start of the 1990s, encouraging Croatian and Slovenian independence and then brokering a peace deal in Bosnia. The Americans' determined opposition to an ultimate destruction of the various Bosnian peace plans is seen by Gowan as a quite deliberate strategy aimed at ensuring military solutions in which the US would inevitably play the dominant role, using NATO as the vehicle. 151. A central objective of the war in Kosovo was the overthrow of the authority of the United Nations. Instead of thinking that the US was ready to overthrow the authority of the UN Security Council for the sake of the Kosovar Albanians, we assume exactly the opposite. The US was wanting to overthrow that UN authority over NATO and used the Kosovo crisis as an instrument for doing so. 152. The enthusiasm of the French and British for bypassing the UN, despite their veto powers, was doubtless connected to the fact that in NATO these countries have an effective veto as well, and were no longer hostage to the anti-Western vetoes of Russia and China. The institutional power of Western Europe would thus be actually enhanced. For the US, the legitimation of the use of force outside the structure of the UN Charter would put it in a legal position commensurate with its effective world stature, transforming the international legal order from one based on a multilateral order founded at the end of the Second World War and maintained by big power rivalry until the collapse of the Soviet bloc. 153. To the unipolar world of global capitalism led by Uncle Sam. 154. Michael Ignatieff reports a pre-Kosovo conversation with Richard Holbrooke, America's Balkan proconsul in the Roman Empire, terms Ignatieff uses to describe him. 155. In which Holbrooke says he wants to demonstrate that his success at Dayton marked a watershed in the use of American power, not just in the region, but in the world. It showed the tired Europeans and dispirited UN, what America can accomplish when it uses ruthless means, air strikes or the threat of them, round-the-clock negotiations and the immense force of presidential authority, to achieve peace. One curious feature of the vision, comments Ignatieff, is how little place it accords the United Nations. 156. Humanitarian intervention. Whether the US went to war in Kosovo for the purpose of radically changing the UN legal order, to allow for ruthless means with little place for the United Nations, it was clear by the time of the Iraq War of 2003 that this was one of the prizes that America tried to extract from it. Hence Richard Pearl's claim, quoted earlier, that the death of the UN dates from Kosovo. But implicit in this very idea is the widely accepted view that the Kosovo War itself was illegal, supremely so, that's why it could be regarded as such a rupture with the prior legal regime. Though there were a few more defenders of the legality of the Kosovo War than of the Iraq War, they were still greatly outnumbered by those who argued for its illegality. These included some very eminent authorities, including Louise Arbour's colleague at the ICTY, its RST president, Italian law professor Antonio Cassese. In the middle of the war and while still a judge on the court, Cassese published an article that gave voice to the scholarly consensus. The breach of the United Nations Charter occurring in this instance cannot be termed minor. The action of NATO countries radically departs from the Charter's system for collective security, which hinges on a rule and an exception. There is no gainsaying that the Charter has been transgressed, in that a group of states has deliberately resorted to armed action against a sovereign state without authorization by the Security Council. 157. Of course NATO tried to defend its actions on legal as well as moral grounds. In Lord Robertson's corporate non-speak, the NATO countries were sensitive to the legal basis for their action. 158. They concluded that a sufficient legal basis existed in the following factors: the Yugoslav government's non-compliance with earlier UN Security Council resolutions, the warnings from the UN Secretary-General about the dangers of a humanitarian disaster in Kosovo, the risk of such a catastrophe in the light of Yugoslavia's failure to seek a peaceful resolution of the crisis, the unlikelihood that a further UN Security Council resolution would be passed in the near future, and the threat to peace and security in the region. These factors can be grouped into three categories: 1. Security Council resolutions, 2. Impending humanitarian disaster, and 3. Threats to peace and security. Common to all three was a big institutional question. While the UN legal order entitled the Security Council to act on any of these 89 June 5, 04, 1:17 and 10 seconds p.m. June 5, 04, 1:17 and 10 seconds p.m. 90 bases, it did not entitle any state or group of states to do so. In other words, this was another case of the United States, this time acting through NATO, trying to substitute itself for the Security Council. Nothing could be more obvious in this respect than the invocation of a threat to peace and security, something the Charter gives over explicitly to the Security Council, but only slightly less obvious is the invocation of Security Council resolutions that do not contain even a hint of Security Council authorization. As in the case of Iraq, the Security Council resolutions made demands, but they did not back them up with the threat of force. Even supporters of the bombing had to admit that there was no way to read these resolutions as authorizing the use of force against Yugoslavia for non-compliance, explicitly or implicitly. 159 NATO's invocation of Security Council authority was like saying that any non-compliance with any Security Council resolution would justify military intervention, no matter how limited the means the resolution itself envisaged for enforcement. This was precisely the claim the Americans had been using for years to justify bombing Iraq and would use to justify war in 2003. As the British scholar Christine Gray put it, it is no longer simply a case of interpreting euphemisms such as all necessary means to allow the use of force when it is clear from the preceding debate that the use of force is envisaged. The USA, the UK, and others have gone far beyond this to distort the words of resolutions and to ignore the preceding debates in order to claim to be acting on behalf of the international community. 160. As might be imagined, this is unacceptable to the vast majority of legal scholars for its 1984-ish violence to language, and for the usual problems of selective enforcement. The United States has not seen fit to bomb Israel for its complete defiance of 37 years of Security Council resolutions on the Palestinian territories Israel occupied in 1967. But beyond that, it would put the Security Council virtually out of business, because it could not make the mildest declaration or decision on an international dispute without thereby implicitly authorizing the United States, or anybody with the necessary muscle, to invade and bomb its way to a solution. That's why the notion of implicit authorization even disturbed supporters of the bombing. 161. The Security Council's primary responsibility for the maintenance of peace and security would exist only on paper, which seems to be the option the US prefers to every other, perhaps even to tearing up the paper itself. Not even NATO claimed the attack on Yugoslavia came within the exercise of the right of self-defense of a member state, for the simple reason that no NATO country had been threatened or attacked, and neither NATO nor the UN recognized Kosovo as independent. NATO didn't even claim that it was coming to the aid of Kosovo's right to self-determination. 162. That was ruled out by the same Security Council resolutions that formed the legal basis to which NATO was sensitive, because they also affirmed the territorial integrity of the FRI. The only legal claim with any coherence at all, leaving aside plausibility for a moment, was the remaining one, the so-called right of humanitarian intervention, to be precise a right of unilateral humanitarian intervention that any state or group of states could undertake on its own without the requirement of Security Council authorization. Kossezi's confident assertion that the war was illegal rested precisely on the widely accepted understanding that no such right existed. Indeed, Kossezi really wanted to argue that Kosovo created a precedent in favor of it precisely because it was illegal. Humanitarian intervention by military force finds no place in the Charter of the United Nations, because for the generation who wrote the Charter the scourge was war between states, the violation of national sovereignty that was Nuremberg's supreme crime, the one committed by Nazi Germany that left 50 million dead in its wake. The UN Charter put all its emphasis on outlawing that, whatever the motives. The exception of self-defense against an armed attack proved the rule. The Charter absolutely rejected the use of force in relations between states, enjoining them to settle their disputes by peaceful means and to refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state. It sought to monopolize the use of force in the Security Council. Section 2 even forbade intervention by the United Nations itself, let alone individual member states, save for exceptions specifically laid down in Chapter 7 with respect to threats to international peace and security and self-defense. The notion of a humanitarian war would have rang in the ears of the drafters of the UN Charter as nothing short of Hitlerian, because it was precisely the justification used by Hitler himself for the invasion of Poland just 6 years earlier. Hitler's address to the Reichstag on September 1, 1939 sounds so much like NATO that it seems there must be some logical structure to justifying aggression. All German minorities living there have been ill-treated in the most distressing manner. More than 1 million people of German blood had in the years 1919 to 1920 to leave their homeland. As always, I attempted to bring about, by the peaceful method of making proposals for revision, an alteration of this intolerable position. An attempt was made to justify the oppression of the Germans by claiming that they had committed acts of provocation. I do not know in what these provocations on the part of women and children consist, if they themselves are maltreated, in some cases killed. I have, therefore, resolved to speak to Poland in the same language that Poland for months past has used toward us. 163. Hitler's pretext for taking over Czechoslovakia had also been expressed as a humanitarian intervention in defense of German minorities who had been abused, tormented, economically ruined, and above all prevented from realizing the right of self-determination of nations also for themselves. 164. He also saw his stance as a breakthrough in international law, proclaiming to the Reichstag on February 20, 1938 that the juridical separation from the Reich as far as international law is concerned could not prevail against the universal rights to self-determination. Czech President and belligerado Václav Havel was forgetting his own history when he said, fatuously, during NATO's 50th birthday party, that the war over Kosovo was probably the first war ever fought that is not being fought in the name of interests but in the name of certain principles and values. 165. In fact, it is nauseating how frequently states claim to fight wars for higher values and how rarely the case can be made out. The Charter's attempt to ban non-defensive wars as illegal was not an innovation in international law. Already after the devastation of World War I there was broad agreement on this principle. It formed the essence of the General Treaty for the Renunciation of War of 1928 concluded between the United States and France, and adhered to by them and 13 others, including Germany and Great Britain. It was eventually ratified by 62 nations. The text read in part as follows. Article I. The high contracting parties solemnly declare in the names of their respective peoples that they condemn recourse to war for the solution of international controversies, and renounce it, as an instrument of national policy in their relations with one another. Article 2. The high contracting parties agree that the settlement or solution of all disputes or conflicts of whatever nature or of whatever origin they may be, which may arise among them, shall never be sought except by pacific means. This was the idea that would inform the United Nations Charter, signed in San Francisco on June 26, 1945 after an even more devastating war that ended with the debut of a weapon capable of wiping out the entire human race. And it was the basic idea that informed the Nuremberg trials that commenced that same summer. For the proposition that aggressive war was illegal and criminal when the Nazis waged it, the Nuremberg Tribunal felt it had to do no more than refer to the Kellogg-Briand Pact itself. The nations who signed the pact or adhered to it unconditionally condemned recourse to war for the future as an instrument of policy, and expressly renounced it. After the signing of the pact, any nation resorting to war as an instrument of national policy breaks the pact. In the opinion of the tribunal, the solemn renunciation of war as an instrument of national policy necessarily involves the proposition that such a war is illegal in international law, and that those who plan and wage such a war, with its inevitable and terrible consequences, are committing a crime in so doing. War for the solution of international controversies undertaken as an instrument of national policy certainly includes a war of aggression, and such a war is therefore outlawed by the Pact. 166. The question of the relationship between illegal and aggressive wars is a very important one for understanding America's criminality, not only in Kosovo but in Afghanistan and Iraq as well, so it is worth a momentary digression. As is evident from this passage, the Nuremberg Tribunal did not decide whether every illegal war was a war of aggression, although the only example it mentioned of a non-aggressive war was one conducted within the legal confines of the right to self-defense, implying, as would ordinary language, that any non-defensive war would be regarded as aggressive. The Americans, led by Jackson, wanted to include a definition of aggression precisely along these lines, i.e. the use of force except in self-defense. It read as follows. An aggressor, for the purposes of this article, is that state which is the first to commit any of the following actions: declaration of war, invasion by its armed forces, of the territory of another state, attack, on the territory, vessels, or aircraft of another state. No political, military, economic, or other considerations shall serve as an excuse or justification for such actions, but the exercise of the right of legitimate self-defense, that is to say, resistance to an act of aggression, or action to assist a state which has been subjected to aggression, shall not constitute a war of aggression. 167. However, the other allies were in favor of leaving out an explicit definition of aggression, and the Americans ceded on this point. 168. On the other hand, the Tribunal's charter as finally drafted did include equally as a crime against peace any war in violation of international treaties, for example, the Kellogg-Briand Pact or the present-day Charter of the United Nations. The Nuremberg Tribunal itself did not have to enter into the question of any distinctions between illegal wars and wars of aggression, because it was dealing with as egregious an example of both as you were likely to get: the Nazi war launched to subjugate all of Europe along with large swaths of the rest of the planet. Of course, the lesser crimes within this supreme crime, including the Holocaust of European Jewry, were also of unimaginable enormity. Yet the tribunal insisted that the Nazis' worst sin was making aggressive war. There is a powerful logic to this, especially for Polish Jews like myself. If Germany had not made war on Poland, Polish Jewry would not have been consigned to the gas chambers. This is something we should remember when we evaluate the attempts to use the Holocaust to justify humanitarian intervention in violation of international law and state sovereignty. In fact, the Holocaust proves the opposite. If the other Western powers had only stopped the Nazis at Germany's own borders, in other words stood up for international law and state sovereignty, which they certainly had the power and opportunity to do in 1938, there would have been no Holocaust. 97% of the Jews slaughtered by the Nazis lived in the countries Germany illegally invaded, including the 3 million Polish Jews who made up more than 90% of the pre-war community. The vast majority of the German Jews who perished were also murdered during the war, having been transported for extermination to occupied Poland. 169. Not all illegal wars are the equivalent of World War II, just as all crimes against humanity are not the equivalent of the Holocaust. But the hierarchical logic of the Nuremberg Tribunal seems highly appropriate to the kind of illegality at issue in Kosovo. Here, too, the war crimes owed from the crimes against peace, and whatever point there might be of distinguishing between the aggressive and the illegal also vanished. Because, again, this was no mere technical illegality, but rather something fundamental, the launching of a war contrary to the basic peace-seeking principles of the UN Charter for motives of geopolitical and petty political strategy and greed, whether or not it was technically for conquest, with a predictable price in death and destruction as the result. Legal developments subsequent to the Nuremberg Tribunal have followed the example of the Nuremberg Charter and equated aggressive war with illegal war. The most important was the UN General Assembly Resolution of 1974, which, without a dissenting vote, adopted a definition of aggression that, for all intents and purposes, was the same as that proposed by Jackson at Nuremberg, quoted above. Aggression was defined to include any use of armed force by one state against another in any manner inconsistent with the Charter of the United Nations. Humanitarian intervention was specifically ruled out, virtually in Jackson's terms, by Article 5, no consideration of whatever nature, whether political, economic, military or otherwise, may serve as a justification for aggression. 170 The same article deems a war of aggression a crime against international peace that gives rise to international responsibility. A key provision is Article 2, which provides that the first use of armed force by a state in contravention of the Charter is presumed to be aggression, with only one exception, the authority of the Security Council in conformity with the Charter to decide that a determination that an act of aggression has been committed would not be justified in the light of other relevant circumstances, including the fact that the acts concerned or their consequences are not of sufficient gravity. The negative formulation is of enormous significance. It means that a non-defensive war cannot be deprived of its legal characterization as aggression merely by the veto of one permanent member of the Security Council. It will be deemed to be what it is, namely aggression, unless the Security Council intervenes to say it is not, meaning that all permanent members, as well as at least 4 of the other 10, would have to agree. It would clearly have been impossible for the US to get such a vote in the case of either Kosovo or Iraq, and, given the non-committal nature of the resolutions passed in September 2001, it is an open question what would have happened if the case of Afghanistan were ever put to the test, especially at a remove where its full savagery and lack of redeeming value could be appreciated. In 1986, in the Nicaragua case, the World Court recognized the General Assembly's resolution on aggression as binding international law when it rejected America's claim to have been acting in self-defense. 171 The case also authoritatively and unequivocally reaffirmed the ban on humanitarian wars. 172 The Americans had argued that their violent intervention was not only an exercise of self-defense, but was also aimed at protecting the human rights of Nicaraguans. This too was rejected and the World Court ruled resoundingly against the United States by 12 votes to 3. 173 The official decision was that the United States of America, by training, arming, equipping, financing and supplying the Contra forces or otherwise encouraging, supporting and aiding military and paramilitary activities in and against Nicaragua, by certain attacks on Nicaraguan territory in 1983–84, and by laying mines in the internal or territorial waters of the Republic of Nicaragua during the first months of 1984, has acted, against the Republic of Nicaragua, in breach of its obligation under customary international law not to intervene in the affairs of another state, not to use force against another state, not to violate its sovereignty and not to interrupt peaceful maritime commerce. 174. The case marked the end of American cooperation with the World Court. In fact, the U.S. unsuccessfully tried to wriggle out of the court's jurisdiction in the Nicaragua case itself by giving notice prior to the decision that it was withdrawing from the court's jurisdiction. But the court pointed out that the U.S. had previously committed itself to giving 6 months' notice and ruled that the case had to proceed. 175. At this point the United States refused to participate in the case any further and formally withdrew its consent to the court's jurisdiction for all further cases, unless it should specifically consent to a given case beforehand. The lack of World Court condemnation of U.S. lawbreaking since Nicaragua doesn't mean the Americans have gone straight, just that the law's arm is not long enough. 176. The court's rejection of the humanitarian intervention claim of the U.S. was short and to the point. In any event, while the United States might form its own appraisal of the situation as to respect for human rights in Nicaragua, the use of force could not be the appropriate method to monitor or ensure such respect. With regard to the steps actually taken, the protection of human rights, a strictly humanitarian objective, cannot be compatible with the mining of ports, the destruction of oil installations, or again with the training, arming and equipping of the Contras. 177. The International Court of Justice is the highest authority in international law, so the case bitterly disappointed advocates of unilateral humanitarian intervention. Some have tried to salvage something from the decision by narrowing its precedential value to the facts of the case, claiming that a case for true humanitarian intervention can still be made out if the human rights violations are serious enough and certain other conditions are met. 178 For example, Fernando Tezin argues that there is a moral right, under stringent conditions, for states to intervene with armed force to prevent or end very serious human rights violations in other states. He argues that the Charter, despite its words, should be interpreted to make this moral right a legal right. 179 Of course, the intervention must be truly humanitarian, which entails compliance with a number of strict conditions. Failing any of them would deprive the intervention of its legality, and it is obvious that the war in Kosovo would have met few, if any. First, the intervening state must aim its military action at stopping human rights deprivations by governments. 180. The NATO bombing campaign seemed aimed at anything but stopping human rights abuses. It seemed aimed instead, especially in the early weeks, at encouraging them. Nobody doubts that the situation got predictably worse after the bombing started. Even defenders of the bombing had to admit that NATO's strategy at times appeared calculated more to punish and declaw the Milosevic regime for its past atrocities than to halt the human rights abuses being committed. 181. Second, collateral non-humanitarian motives should be such as not to impair or reduce the first paramount human rights objective of the intervention. In fact, it is only the host of collateral non-humanitarian motives examined earlier that could possibly explain the anti-humanitarian way that NATO conducted its intervention. Third, the means used must always be rights-inspired. A bombing attack clearly aimed at breaking the morale of the civilian population, in flagrant violation of the Geneva Conventions, doesn't exactly fit this criterion. The authenticity of the humanitarian purpose must be ascertained by examining the concrete actions taken by the intervener. Did troops occupy the territory longer than necessary? The KLA is a separatist movement. It insisted at Rambouillet on a NATO-old presence in Kosovo to ensure its future independence. 4 years after the war ended, Kosovo was a NATO protectorate and would remain so for the foreseeable future. Has the intervener demanded advantages or favors from the new governments? How about the overthrow of the government and the handing over of its president for trial as a condition of sanctions being removed? In other words, it was not enough for NATO that the alleged oppression of Kosovo by Serbia and Serbia itself had to install a subservient government and then break its own laws to satisfy NATO's need to see Milosevic brought in chains to The Hague. And the final test will be whether human rights have been effectively restored as a result of the intervention. While the Albanians are no longer the victims of ethnic violence, a Kosovo largely cleansed of Serbs and Roma hardly bespeaks the restoration of human rights. Here's one rights-based assessment of the situation in Kosovo 1 year after the war. Here has been a denial of internationally recognized civil and political rights, among which the right to life, the right to physical and mental integrity, the right to liberty and the security of the person, the right to humane conditions of detention and to freedom from torture and from cruel and degrading treatments or punishments and freedom of movement. Moreover, the general atmosphere of terror has given place to other violations in the fields of freedom of association, freedom of assembly, freedom of expression, freedom of thought, conscience and religion, of the right to use one's own language and, of the right to political participation. Furthermore, there has been generated a constant negation of economic, social, and cultural rights, among others, the right to education, the right to participate in cultural life, the right to health, and the right to social security. 182. Finally, and most importantly for the war over Kosovo, the decisive question is whether there is a nonviolent way of achieving the humanitarian result. Military intervention, as a remedy against human rights violations, should only be resorted to when all peaceful means have failed or are likely to fail. The reason is simple: war is devastating, innocent people die, countries are ravaged and destroyed. The evidence speaks rather of a NATO that worked overtime to destroy all of the many chances for a peaceful solution that presented themselves, right up to the moment of the attack. So NATO's intervention would have failed the legal/moral test of unilateral humanitarian intervention. Lawyer defenders of the bombing had either to ignore the facts, or the letter or spirit of the Charter, or all three. Some just engaged in creative omission, quoting sections of the Charter but omitting the words that made it clear their enforcement was up to the institutions of the United Nations and not its individual member states. 183 others engaged in tortuous interpretations, for instance, American law professors Paul Williams and Michael P. Scharf, former State Department lawyers and NATO partisans, who argued that, since explicitly rejected claims of independence for Kosovo and publicly reaffirmed the territorial integrity and political independence of Yugoslavia, the purpose of the air strikes could not be construed to either impair territorial integrity or to challenge political independence. 184. This requires reading territorial integrity and political independence in Article 2 as not being impaired when one country bombs another into submission to its will, as long as it doesn't formally annex it, rather different from the ordinary meaning of the words. Different as well from the General Assembly's resolution on aggression quoted earlier. And even the theory of unilateral humanitarian intervention holds that the attacker's actions, not their words, must count. 185 Kosovo has in fact been permanently excluded from Yugoslavia, and is now and for the foreseeable future occupied by NATO troops, with each passing month, and every newly paved road, Camp Bond-Steel becomes a more permanent part of the Kosovo landscape, an American emplacement intended for the medium to long term. 186 This was the only possible outcome of a NATO victory, and it was precisely the state of affairs contemplated by the Rambouillet Agreement, the pretext for the bombing campaign. Williams and Scharf also argue that the strikes against Yugoslavia were legally authorized by the Genocide Convention, specifically its requirement that ratifying countries undertake to prevent and to punish genocide. 187, i.e., that the attack itself could be considered a prevention and/or punishment of genocide. One little problem with this is that the evidence of genocide was non-existent, as witness the charges against Milosevic when he was finally brought to The Hague. But even the most blatant violation of the Genocide Convention could not possibly be a legal justification for an armed intervention, because if one takes the trouble to read the Genocide Convention, one sees that there are all sorts of ways in which the ratifying states agree to prevent and punish genocide, with the conspicuous exception of armed intervention. States undertake to enact legislation against genocide, and to have people who commit genocide tried by a national or international tribunal. They agree to grant extradition. Most importantly, they agree that they may call upon the competent organs of the United Nations to take such action under the Charter of the United Nations, as they consider appropriate for the prevention and suppression of acts of genocide. 188 Nowhere is NATO or the US listed as a competent organ of the United Nations, nor is any mention made of bombing the hell out of a country alleged to be in violation of the convention. Williams and Scharf, in the best traditions of American interventionism, humanitarian or otherwise, conveniently ignore this question of means, which is the only real question at stake. Granted, the prevention of genocide is a desirable end, hard to find anyone disagreeing with that. Does it follow that any means are also acceptable? It is no surprise that international law and convention are concerned with means as well as ends. This precise point was also made by the World Court in the Nicaragua case. Nicaragua is accused by the 1985 finding of the United States Congress of violating human rights. However, where human rights are protected by international conventions, that protection takes the form of such arrangements for monitoring or ensuring respect for human rights as are provided for in the conventions themselves. 189. In other words, you cannot use a convention that specifies both means and ends as justifying any means, whether those specified in the convention or not. If it were not for the nerve of lawyers, this would not have to be spelled out. As for competent organs of the United Nations, NATO had every opportunity to make all of these arguments to the World Court when Yugoslavia hauled the US and 9 other members before it a month into the bombing campaign. 190 But instead of stating its case, NATO chose to deny the jurisdiction of the court. This was at the very same moment that, on the other side of town, the US was helping the ICTY assert its jurisdiction against the FRY leadership. By no coincidence at all, both the World Court, a venerable institution dating formally from 1946 and effectively from 1922, and the ICTY are situated in The Hague, the ancient capital of the Netherlands and the site of the important peace conferences of 1899 and 1907. The US obviously wanted to give the ICTY some of the luster of the World Court, even confuse them in the public's mind, which happened often, but they are two very different institutions. Only states, not individuals, can appear in the World Court. Its jurisdiction is purely by the consent of all of the parties, and it cannot order criminal penalties against individuals. It is also a far more democratic and representative body. Unlike those in the ICTY, World Court judges are not subject to the veto rights of each of the VE permanent members of the Security Council. The 15 judges are elected by absolute majority of both the General Assembly and the Security Council, and the veto does not apply. As part of its suit, Yugoslavia requested and received an expedited hearing on provisional measures, essentially asking the court to order a stop to the bombing in the interim until the full case could be heard. On 2 June the court issued its decision denying Yugoslavia's request, without deciding the merits of the whole case, which was to proceed at the ordinary snail's pace. 191 But the decision did nothing to vindicate the legality of NATO's air campaign, quite the contrary. Despite heavy NATO presence on the court, the decision was a clear rebuke by the court of the questionable humanitarianism and legality of NATO's bombing campaign. 16 Whereas the court is profoundly concerned with the use of force in Yugoslavia, whereas under the present circumstances such use raises very serious issues of international law. 18. Whereas the court deems it necessary to emphasize that all parties appearing before it must act in conformity with their obligations under the United Nations Charter and other rules of international law, including humanitarian law. 31. Whereas, whether or not states accept the jurisdiction of the court, they remain in any event responsible for acts attributable to them that violate international law, including humanitarian law, whereas any disputes relating to the legality of such acts are required to be resolved by peaceful means, the choice of which, pursuant to Article 33 of the Charter, is left to the parties. 33. Whereas, when such a dispute gives rise to a threat to the peace, breach of the peace or act of aggression, the Security Council has special responsibilities under Chapter 7 of the Charter. The emphasis on the Security Council was in fact the very crux of the matter. The issue was never one of humanitarian intervention versus just standing by, it was about whether peaceful or violent means should be used and, above all, who should decide this. In fact, in the period since the Nicaragua case, and especially since the official end of the Cold War, the Security Council had been cautiously experimenting with what is called collective humanitarian intervention, namely, intervention authorized by the Security Council. This is what Secretary-General Pérez de Cuellar was talking about in 1991 when he argued, in an often quoted statement, that the defense of the oppressed in the name of morality should prevail over frontiers and legal documents. He was talking about the role of the United Nations after the Cold War, when the Security Council has now moved to the central position from which it can assert the authority that the Charter has conferred on it. As with the recent Gulf War, he was insisting that all measures of enforcement must be seen to issue from a collective engagement which imposes a discipline all its own. 192 The collective/unilateral distinction is fundamental to the United Nations system, designed, according to the Charter, to take effective collective measures for the prevention and removal of threats to the peace and to ensure by the acceptance of principles and the institution of methods, that armed force shall not be used, save in the common interest. 193 There were 4 cases of collective humanitarian intervention in the first half of the 1990s. In these cases the Security Council authorized the use of all necessary means under unified command, but always subject to the close supervision of the Secretary General. Before the resolutions on Bosnia discussed earlier, there were similar resolutions on Somalia, Haiti, and Rwanda. 194 By the time of Kosovo, the power of the Security Council to authorize armed intervention in a conflict within the borders of a sovereign state was well established. Why was it not used in Kosovo? The usual explanation given by the supporters of the bombing, and the main argument for unilateral humanitarian intervention, is that collective intervention was not available because of a paralysis in the Security Council. Williams and Scharf, for example, argued unctuously that U.S. intervention was worth the risk of setting a precedent for other countries to intervene in less altruistic circumstances because of the re-emergence of Security Council paralysis in the face of mass atrocities. 195 Security Council paralysis occurs strongly in the precedent that advocates of bombing sought to draw out of the Kosovo War. For instance, ICTY Judge Antonio Cassesi's unequivocal assertion of the illegality of the war was in no way intended as a criticism. He meant it to establish that, as a result of Kosovo, a rupture with the prior legality had occurred so that a new legal principle might emerge. 196 Cassesi argued for a new rule that would add one condition to the failed doctrine of humanitarian intervention, namely that the Security Council is unable to take any coercive action to stop the massacres because of a disagreement among the permanent members or because one of them exercises its veto power. 197 The amazing thing about the paralysis argument is that anyone would have the chutzpah to make it on behalf of intervention by NATO or the US, because they were the ones doing all the paralyzing. It is true that the Soviets used the veto most in the UN Charter's first generation, but from 1966 to 1997, a rather more relevant period, one supposes, for Kosovo and the re-emergence of paralysis to which Williams and Scharf refer, 86% of the vetoes cast in the Security Council were cast by NATO countries. From 1966 to 1997 the United States cast 72 out of a total of 132 vetoes, the UK 19 and France 14, while the Soviets cast only 15 and China only 3. As the US found itself increasingly in the minority on key issues, its veto use steadily rose from 39% of total vetoes between 1966 and 1975 to 57% between 1976 and 1985, and to 63% between 1986 and 1997. 198 After losing in the Nicaragua case, the U.S. vetoed resolutions calling for compliance with the World Court's judgment. 199 In the early years of the new millennium, the U.S. used its veto to shield Israel's brutal occupation of the Palestinian territories from any collective humanitarian intervention, even from something as mild as an international observer force during a period of intense bloodletting. 200 So if there is a paralysis, it is the United States that is mostly to blame. And since we are talking about paralysis in the face of mass atrocities, it's worth mentioning the most notorious example of this, namely the Rwandan Civil War of 1994, because it is widely accepted that in that case it was the United States of Bill Clinton that paralyzed the UN. That's why it is almost impossible to understand the ignorance of a Michael Ignatieff whose main reasons for supporting the intervention in Kosovo, despite a lack of Security Council authorization, were Rwanda and Bosnia. Sticking only to the most recent and relevant instances, the UN Security Council's failure to prevent genocide in both Rwanda and Bosnia has made it essential that where a veto threatens to make the international community complicit in evil, coalitions of member states should be able to act on their own. 201. Rwanda and Bosnia? It is true that the powerful evidence that America torpedoed peace efforts in Bosnia is not accepted by everyone, though it appears to be accepted by Ignatieff himself. 202 But where Rwanda is concerned, it is almost impossible to find anyone disagreeing that the US was the problem. The judgment of the Inquiry Commission appointed by the Organization of African Unity in its report, Rwanda, the preventable genocide, is typical. Throughout the genocide, American machinations at the Security Council repeatedly undermined all attempts to strengthen the UN military presence in Rwanda. In the end, not a single additional new soldier or piece of military hardware reached the country before the genocide ended. 203. Rwanda was the other country for which an international criminal tribunal was established. It was another case of Western greed, and IMF-imposed austerity, throwing a match into an ancient and highly volatile intercommunal conflict left over from colonial times. The country was 85% Hutu and 14% Tutsi, but the Tutsis were the favored elite under Belgian colonial rule. When Belgium's trusteeship ended in 1959, the Hutus staged a revolution that abolished the monarchy and ended Tutsi domination. In the 1980s, the country was hit hard by declining international commodity prices and austerity programs imposed by the international financial institutions. The decline in coffee prices was no more an accident of nature than the austerity programs. After establishing quotas and price controls to deal with shortages in the mid-1970s, the coffee importers of the rich countries abandoned them at the end of the 1980s because of downward market pressure on prices. The deregulation led to a drop in wholesale coffee prices of about 50%, devastating to the African-producing countries. As the economic crisis hit, Tutsi refugees in Uganda founded the Rwandan Patriotic Front with the aim of overthrowing the Hutu government in Rwanda. Civil war raged in the early 1990s. 204. In April 1994, the Hutu president was assassinated. The RPF launched an ultimately successful invasion, and a terrible outbreak of ethnic violence occurred. 205. By 31 May, the UN's Secretary General reported to the Security Council that a genocide of minority Tutsis was taking place, in which there had already been between 250,000 and 500,000 deaths. And here's where the United States came in. On May 2, 1994, in the midst of the killing, U.S. President Clinton issued Presidential Decision Directive 25, which laid down conditions for not only U.S. involvement in, but also support for, UN peacekeeping. According to the released executive summary, the first criterion for U.S. support was UN involvement advances U.S. interests. 206. The United States did not have to resort to its veto to prevent intervention in Rwanda, but its determined opposition was the decisive factor. According to then Secretary General of the UN Boutros Boutros-Ghali, it was one thing for the United States to place conditions on its own participation in UN peacekeeping. It was something else entirely for the US to attempt to impose its conditions on other countries. Yet that is what Madeleine Albright did. Albright employed the requirements of PDD 25 to pressure the other Security Council members to delay the deployment of the full 5,500-man contingent to Rwanda until I could satisfy her that all of the many U.S. conditions had been met. The U.S. effort to prevent the effective deployment of a UN force for Rwanda succeeded, with the strong support of Britain. The international community did little or nothing as the killing in Rwanda continued. 207. U.S. opposition to intervention in Rwanda is usually explained by reference to American popular outrage the previous October over the killing in Somalia of 18 U.S. soldiers operating under the umbrella of UN peacekeeping. But this cannot explain why the United States would thwart United Nations action, which technically did not require U.S. troop involvement. Furthermore, in the middle of the violence in Rwanda, the Security Council passed a resolution on Bosnia increasing its UN troop presence by 6,500. 208. The only explanation is that the US, in the words of PDD 25, did not deem UN involvement in Rwanda to advance US interests, either because America had no stake in the outcome, or because it actually backed the invading Tutsi forces, and intervention would have prevented their takeover as well as the slaughter. The US had had decent relations with the majority Hutu regime before the invasion, but its relations with the minority Tutsi regime established afterwards have been much closer. America has provided military aid for the Rwandan regime's participation since 1996 in the Congo War, which has benefited so many North American mining interests and taken millions of lives. 209 When Rwanda, the preventable genocide was released, Western editorialists bristled at any other explanation of the tragedy than simple bloodlust or something between collective madness and evil. To them, putting any blame on the US was blaming the bystander. 210 Some bystander. The value of the Rwandan example is not just to show how selective the US is in its humanitarian intervention, but to show how preposterous it is for the United States to rely on Security Council paralysis to justify its unilateral intervention in Kosovo. In the repeatedly invoked paradigm case, the United States was the problem. In fact, there is nothing like a general paralysis in the Security Council. Quite the contrary, prior to the Kosovo War there had been a spectacular increase in Security Council resolutions, from 185 in the 1980s to 638 in the 1990s, with the high water mark of 93 in 1993, the year prior to PDD 25. The 93 resolutions of 1993 should be compared to the 20 passed in 1989, the last year of the Cold War. Resolutions citing Chapter 7 provisions increased from 22 in the 44 years spanning the Cold War to 107 in the 7 years following the fall of the Berlin Wall. 211 Far from there being a paralysis, there had been, prior to Kosovo, an increase in peacekeeping and humanitarian activity by the Security Council. The evidence speaks more of an America paralyzing the Security Council precisely in order to undermine the challenge posed by a revitalized United Nations to U.S. claims to represent the international community. The same thing can be gleaned from the testimony of former UN Secretary-General Boutros Boutros-Ghali, who titled his 1999 memoirs Unvanquished, A.U.S. U.N. Saga. Boutros-Ghali had much reason to resent the Clinton administration, because it was determined to deny him the traditional second term as Secretary General and conducted a vicious disinformation campaign against him. The U.S. ultimately cast the lone vote against Boutros-Ghali in the Security Council in 1996. This was the same year the Secretary General publicly denounced the U.S. for its attempts to starve the UN into submission by defaulting on its dues. 212 But Madeleine Albright told Boutros-Ghali he was being fired for refusing in 1993 to grant the Americans the authority to use military force unilaterally in Bosnia. 213 The U.S. was determined, indeed anxious, long before, 5 years before, the threat of a Kosovo Holocaust, to intervene militarily without UN authorization. 214 The confrontation over Sarajevo occurred in August 1993, a full 2 months before Mogadishu, the occasion for issuing PDD 25. While Boutros-Ghali was unsure of U.S. motives at first, it was clear even before Kosovo that it had something to do with substituting air power for ground troops, and the U.S. for the UN. My responsibility was to promote multilateralism. The emerging U.S. policy was unilateralism, with multilateralism providing a fig leaf as needed. 216 Boutros-Ghali was replaced by Kofi Annan, whose silence during the Kosovo War on NATO's violation of the UN Charter was deafening. This was no accident. According to Boutros-Ghali, the Clinton administration mentioned no one, apparently fearing that its choice would be regarded as America's hand-picked puppet. Inside the United Nations, however, everyone knew that the United States candidate was Kofi Annan. 217 You won't find it in his official UN biography, but Annan was the UN's special envoy to NATO during the Bosnian War, though in fact it was more vice versa, as he supported NATO's case for bombing against the restraint of the Secretary General. According to Holbrooke, that is how he won the job as Secretary General. 218 The Clinton administration chose well with Kofi Annan. From the very moment NATO started planning its military intervention in Kosovo, Annan was at work providing the diplomatic cover. In June 1998 he gave a public lecture that was a very strong and emotional defense of unilateral interventionism, using Kosovo as the example of the next intervention, invoking the Nazi era apropos of it, and explicitly congratulating NATO on Its recent threats to the Fry 219 in January 1999, on the eve of Rambouillet, Annan gave NATO an effective green light for its unilateral military plans. The first ever visit of a Secretary-General of the United Nations to NATO headquarters in Brussels, not Annan's own first visit, of course, took place on January 28, 1999, 2 days before NATO sent its official Rambouillet summons to the Fry government. Annan addressed the NATO Council in closed session, and it is a pretty easy guess what he told them, because even in his official public remarks there was absolutely no reference to the Security Council's monopoly on the use of force. 220 When he spoke to the press, Annan demoted Security Council approval to something only normally required. Asked if NATO could intervene in Kosovo with the express approval of the UN Security Council, Annan said, normally, the approval of the Security Council for the use of force is required. I have always said that. But in what appeared to be a pointed signal to NATO allies not to back off, he told NATO ambassadors, "Let me ask only that we all, particularly those with the capacity to act, recall the lessons of Bosnia." 221. NATO's Secretary-General Javier Solana was quite correct in exploiting the visit by saying, "You have seen from the visit of the United Nations Secretary-General to NATO earlier today that the United Nations shares our determination and objectives." 222 Annan did nothing during the war to disabuse anybody of this impression. Shortly after, he signed a report crudely congratulating the US for what it had done, attacking his predecessor's policies as appeasement, and equating Kosovo to Bosnia and Bosnia to the Holocaust. Whether or not they went to war for the purpose of establishing a new precedent, NATO supporters tried very hard to extract one from it. Tony Blair gave a widely reported speech in Chicago on the eve of the NATO summit, and thus in the midst of a bombing campaign not authorized by the UN Charter, in which he argued that the new world of the new millennium needed new rules, new ways and a new framework. No longer is our existence as states under threat. Non-interference has long been considered an important principle of international order. And it is not one we would want to jettison too readily. But the principle of non-interference must be qualified in important respects. Acts of genocide can never be a purely internal matter. 223. The cornerstone of the UN Charter is here reduced to something we don't want to jettison too readily. Not something we don't want to jettison. Mind you, just something we don't want to jettison too readily. This speech was eagerly seized upon by bombing enthusiasts as meaning that the presumption enshrined in the UN Charter that states should not resort to war except in self-defense and that they should be immune from intervention by other sovereign states had now to be revised. 224 After the war, NATO politicians continued to hammer away at the same theme. 225 Kofi Annan started off the new millennium with an appropriately positive assessment in the Financial Times entitled "The Legitimacy to Intervene." 226 Is there anything to be said for this new precedent? Look at Kosovo itself. In fact, the Security Council was intensely involved in the conflict and managed to pass several important resolutions in the year before NATO's attack. 227 And, of course, Resolution 1244 of June 10, 1999 enshrined the peace deal agreed by the Fry and NATO through the mediation efforts of the G8 nations. None of these resolutions authorized an armed intervention, but that is not because the Security Council was incapable of doing so, as the resolutions of the early 1990s showed. In Kosovo, NATO never even tried to obtain Security Council authorization for armed intervention. Interventionists claim that it was pointless because China and Russia were sure to have exercised their veto. But what does that prove? It's like the police wanting to administer their own justice on the street because they don't trust the courts to convict. It's not just that most of us trust the courts more than the police, it's that we feel better when there are some serious checks on the official use of violence. 228 The proof of this particular principle is in the eating. A veto by China or Russia in the Security Council in the case of Kosovo, if it had been effective in stopping NATO, would have saved thousands of lives, from the very young to the very old, because it would have forced the world to give peace the many chances examined earlier. As the former head of peacekeeping for Bosnia put it, the humanitarian disaster unfolded in Kosovo after NATO hijacked the decision-making process from the UN. 229 Furthermore, had Russia or China defeated this initiative of NATO, they would have been representing the considered opinion of most of the world and its leaders. If NATO wanted to dispute this, they could have gone to the General Assembly of the United Nations with their case. When the United States wanted the United Nations to get around the Soviet veto in the 1950s in the case of Korea, it went to the General Assembly and passed the Uniting for Peace resolution, which allowed the General Assembly to recommend military action if 2/3 of those present and voting were agreed. 230 But the Uniting for Peace resolution has not been used since the West lost control of the voting patterns in the General Assembly, and that is undoubtedly why. The US didn't try to use it in Kosovo. It would have lost overwhelmingly, because the real international community was against the war. 231 This is a question not of substance but procedure, not of ends but means, not of whether the international community should intervene when absolutely necessary in the interest of humanity, but rather of who is to speak for the international community. It is not only that the particular Security Council failings complained of are the unilateral interventionists' own doing, it is that the alternative is not even an equivalent expression of the international community, much less a better one. The question is not how we can let one or two states thwart the international community by their veto power, the question is how do we know it is the international community when there is the consent of neither the Security Council nor the General Assembly. Nor is the unilateral alternative to the Security Council some more effective way of determining that armed intervention is necessary. Kosovo showed that to most people, too. The unilateral alternative to the Security Council is the rule, not of the best, the most humanitarian or the most representative, but of the most powerful. The only thing everybody is really sure of in Kosovo is that the Americans had their way. Under the new rules that would be established by the Kosovo precedent, this would be, in effect, institutionalized. And it would be that much more difficult for world opinion to penetrate the enormous propaganda resources that America can deploy on its own public. As the richest country in the history of the world, America is also blessed with history's most powerful mass media, no innocent bystander, but, on the contrary, a fully fledged member of corporate America locked in holy matrimony with state and government, sharing identical geopolitical interests. With or without the happy coincidence of the U.S. Secretary of State's chief spokesman being married to CNN's lead correspondent on Kosovo, 232 There is no case that the Americans cannot make plausible to their own people, at least in the short run, as the war in Iraq showed beyond any doubt. But it could also be seen in Kosovo. 233 Even Kasazi, writing in the early stages of the war, seems to have thought he had to take the U.S. position at face value. If you can so easily lead an eminent professor of international law by the nose, how difficult can it be for the casual observer? But when it turns out the self-styled humanitarians were lying, where do you go with Kasazi's new rule? How do you enforce it, the part that says intervention is only permissible when necessary in the interests of humanity, and it turns out that it wasn't? Do you go to the World Court? Forget about it, the Americans don't recognize it. The International Criminal Court? Ditto. It was crucial for the American media to discredit the Security Council during the Iraq War, because that was the only institution left with the legal authority to demand that the U.S. prove its case to the world. Abandon that, and the partisan pundits can make any wild claims they want about the law or the facts, without fear that they will ever be tested by any court or assembly with the authority to do so. The UN Charter was an attempt to put stringent limits on the exercise of military power in the aftermath of an unimaginably devastating war. It did this by basing itself on state sovereignty and an almost perfect legal equality of states, the veto of the five being the only exception. The new interventionists have sought to change the rules by hammering away at the idea of state sovereignty. International action to uphold human rights requires a new understanding of state and individual sovereignty, according to Kofi Annan, but the dichotomy is a false one. 234 It is false, in the first place, because what is intended to replace state sovereignty is not individual sovereignty but the sovereignty of the great powers, which means individual subordination to them and their friends. It is the US that is in charge in Bosnia, Kosovo, Afghanistan, and Iraq now, the rest are a distant second. In his wartime speech to the Canadian Parliament, Václav Havel said that he saw Kosovo as an important precedent for the future. It has now been clearly stated that it is not permissible to slaughter people, to evict them from their homes, to maltreat them and to deprive them of their property. 235 But, Stephen Shalom responded. What lesson do we think Turkey's leaders are learning from the attack on Kosovo? Surely not. This shows what happens to all who commit atrocities against ethnic minorities. Isn't it more likely that their conclusion is going to be, as will that of anyone who considers cases like Turkey, Timor, Palestine, and Iraq pre-1990 on the one hand, and cases likely Iraq post-1990 and Kosovo on the other, that serving U.S. interests allows you to do whatever you want with your ethnic minorities and opposing U.S. intervention will get you attacked, regardless of your human rights record? 236. Secondly, the evolution of sovereignty is only partial, and strangely enough it does not apply to the most advanced countries, because state sovereignty is only going to be abolished for the weak ones. A world with a single superpower is a world where only that superpower has a sure claim to national sovereignty, an outdated concept for the rest. 237 There is no question, in other words, of anyone intervening in the United States, a notorious violator of the human rights of its own people, a country of de facto racial segregation, of poverty amidst prodigious wealth, of police brutality, bursting prisons, and the death penalty. 238 When it intervened in Kosovo, the United States shared with Japan the dubious distinction of being the only death penalty states in the developed world, and the American execution rate per capita was 5 times that of Japan. The 98 American executions of 1999 made the United States the 5th biggest overall user of the death penalty in the whole world, after its trading partner China, axis of evil members Iraq and Iran, and client state Saudi Arabia. 239 Moreover, with nearly 2 million adults in jail on any given day, the United States had the largest prison population in the world, both absolutely and relative to its total population. 240 In 1999 there were 15,530 murders and non-negligent manslaughters officially recorded, a regular Bosnian civil war. That same year 89,110 forcible rapes were recorded. 241 Most respectable criminology attributes this to the massive social, racial and sexual inequality that is the American way of life. But the theorists of humanitarian intervention conveniently define these kinds of oppression to be outside the scope of their doctrine. The test is whether human rights violations are sufficiently widespread and pervasive as to justify classifying that society as a repressive state, but repressive state is arbitrarily defined to exclude the particular repressiveness of the United States. Luckily for them, sky-high rates of violent crime and punishment don't count, not to mention massive economic inequality and the purchasing of elections. 242 Even if the theorists weren't so clever, nobody has the power to intervene against America or its clients. Humanitarian intervention is forever doomed to be an asymmetrical right, the right of the powerful to intervene in the affairs of the weak and not vice versa. 243 This was the precise point made by the International Court of Justice back in 1949 when it rejected Britain's claim that it had a right to temporarily intervene in Albanian waters to look for evidence of violations of international law. The court can only regard the alleged right of intervention as the manifestation of a policy of force, such as has, in the past, given rise to the most serious abuses, for, from the nature of things, it would be reserved for the most powerful states. 244 So the crux of the proposed new exception is that it detaches the end of humanitarian intervention from the institutional means of the Security Council and even the General Assembly. In so doing it frees NATO, or more precisely the United States, from the legal discipline of the United Nations Charter and thus any legal discipline whatsoever. This, then, was the legal objective of the Kosovo War, even if it wasn't the main or only political objective, in Kasazi's terms, to make right out of wrong, to replace the complicated and nearly democratic mechanism of the Charter of the United Nations with the far simpler law of the jungle. Will the precedent be accepted? Even Kasazi, putting a wildly optimistic spin on the response of the international community, felt that it was premature to maintain that a customary rule has emerged after only this one example in Kosovo. 245 Kasazi was hopeful, however, because only very few states contended that the action on the part of NATO countries was contrary to the United Nations Charter. That these included Russia, China, and India, with well over 2 billion people between them, didn't faze him. But his statement that the overwhelming majority of states did not condemn the NATO intervention as illegal only had to await the following spring to be proved wrong. At the South Summit meeting of developing countries in April 2000, 133 countries issued the following declaration. We reject the so-called right of humanitarian intervention, which has no legal basis in the United Nations Charter or in the General Principles of International Law 246. According to standard international law doctrine, such an overwhelming rejection means that unilateral humanitarian intervention is just as illegal now as it was before the war, and that is the view of the preponderance of scholars. 247 Two independent commissions that studied the question also had to admit to a lack of consensus on the precedent. One was a Canadian initiative, the report of the International Commission on Intervention and State Sovereignty, and the other was led by South African Judge Richard Goldstone, whose performance as the first ICTY prosecutor was not praised for its independence. These commissions shared the rather thinly spread talents of Michael Ignatieff. Both conceded that you could not get a full-blooded legal precedent from Kosovo, because most of the world still opposed unilateral humanitarian intervention as simply a Western Trojan horse. But both commissions seemed to think it was okay to just do it anyway. 248 So if Kosovo introduced a new element, it was not an authentic legal precedent, but the beginning of an open abandonment of legality itself as a fundamental point of reference in international relations. This only became really clear in the debate over the Iraq War, when America's political and legal theorists started intoning the Charter's last rites. But that was when it also became clear that the other rich countries were having second thoughts about these developments. As long as the vehicle of choice for American military policy was NATO, the lesser members seemed to have had no objections to substituting its authority for that of the UN. But by 2003 it was clear that NATO itself was only a brief stop on the way for the United States. The new doctrine of unilateral, preventive self-defense that emerged after September 11, 2001, under which Bush's America arrogated to itself the right to make war on whoever raised an eyebrow against it, permitted the U.S. to avoid the political limits, minor though they were, that the other 18 members had placed on U.S. war strategy in Kosovo. Afghanistan was strictly an American operation. Even though it was the RST time NATO had invoked its Article 5 Solidarity Clause, NATO countries remained in a RMLY subordinate position, helping only as they were allowed, and completely under American command. Even as NATO expanded to embrace more former Soviet bloc countries, its increasing military irrelevance led commentators to ask whether we were seeing the end of NATO. 249, where only 6 months before the same newspapers were proclaiming it the key institution of the current geopolitical West. 250 And then came Iraq, where the war had to be fought without even NATO's solidarity because of open opposition within NATO itself, led by France and Germany. Now the political G-leaf was supplied by the pathetic, ad hoc coalition of the willing. When Richard Pearl thanked God for the death of the UN on the eve of America's war with Iraq, NATO was not mentioned once, and was even retrospectively renamed. It took a coalition of the willing to save Bosnia from extinction. 251 When, after the Iraq War, Tony Blair tried to get 13 other center-left NATO and non-NATO government leaders at a progressive governance summit to accept a proposal for unilateral intervention. They turned him down and unanimously issued a communiqué affirming, "We are clear that the UN Security Council remains the sole body to authorize global action in dealing with humanitarian crises of this kind." 252 But the question of a new precedent, or even the abandonment of legality altogether, is irrelevant to the nature of what the Americans did in Kosovo, in Afghanistan, and in Iraq, and to what that means for how we decipher international criminal justice. Because the indisputable facts of the war in Kosovo are that it wrought terrible, heartbreaking destruction of life, limb, and livelihood without, as they used to say of pornography, any redeeming value, and that it was illegal. And the illegality was no technical anomaly in need of bypassing or overlooking. It was a flagrant violation of the sound and precious anti-war principles of Charter of the United Nations. This is an enormously significant fact to remember as we examine the work of the International Criminal Tribunal for the former Yugoslavia, for it gets all of its authority from the UN Charter. And since the ICTY likes to trace its lineage to Nuremberg, it is also of enormous significance that, in consciously violating the UN Charter, NATO committed what the Nuremberg Tribunal considered to be a supreme crime against peace, the one from which all the others flowed. The ICTY chose to overlook NATO's crimes, and in this and other ways examined in the following pages, it became implicated in them, and in more than just the obvious way that NATO's other allies did. Because law abhors a vacuum at least as much as nature does, and the overthrow of international law and the UN Charter's fundamental principles was too monumental to have been accomplished without some substitute legality, and the ICTY obligingly supplied that, too. 114 June 5, 04, 1:17 and 15 seconds p.m. June 5, 04, 1:17 and 15 seconds p.m. Part 2. Crimes against Humanity. 4. The War Crimes Tribunal. When Slobodan Milosevic appeared before the judges of the ICTY in July 2001, the RST words he spoke were in English: "I consider this tribunal false tribunal and indictments false indictments." One before his microphone was shut off by the presiding judge, Milosevic managed to add in his own language, "This trial's aim is to produce a false justification for the war crimes of NATO committed in Yugoslavia. As I have said, the aim of this tribunal is to justify the crimes committed in Yugoslavia. That is why this is a false tribunal." 2. At the time, criminal lawyers characterized this as a poor me, you too defense, and offered their wise counsel that this wouldn't get him any sympathy from the court. In fact, Milosevic was appealing to everybody but the court, and what he said rang true to most of his listeners. What's more, it was not all that far from the opinion of U.S. State Department lawyer Michael Scharf, a self-described insider who was actively involved in the formulation of U.S. war crimes policy, and who had a big hand in drafting the law governing the Tribunal 3 shortly after the Kosovo War was over. Scharf wrote an article for The Washington Post criticizing the victorious governments for not being serious about war criminals except as a public relations device to legitimate the use of force against the Serbs. The tribunal was widely perceived within the government as little more than a public relations device and as a potentially useful policy tool. Indictments also would serve to isolate offending leaders diplomatically, strengthen the hand of their domestic rivals and fortify the international political will to employ economic sanctions or use force. 4. Apart from the fact that Scharf intended no criticism of the tribunal itself and only its government sponsors, how different is this from what Milosevic was saying? You could not miss the central role played by the ICTY in the Kosovo War in portraying NATO's unilateral aggression as humanitarian intervention on behalf of the international community. We've already mentioned the way prosecutor Louise Arbour helped NATO play up the Rakok incident as an 117. Mondale 02 Chap 4 117 Mondale 02 Chap 4 117 June 5, 04, 3:36 and 21 seconds p.m. June 5, 04, 3:36 and 21 seconds p.m. 118. Atrocity worthy of war. In the midst of the war itself she would top this with dramatic announcements of indictments against Serb leaders, including Milosevic. There would also be numerous press conference meetings with various NATO leaders who would theatrically hand Arbor dossiers of Serb war crimes and swear undying allegiance to her cause. And after the war, despite well-documented complaints of NATO war crimes coming from all over the world, Arbor would assign the NATO countries a monopoly over the search for evidence. Later, her successor Carla Del Ponte would issue an amateur whitewash of a report, absolving NATO of all charges without even an investigation. She would then lead the call to punish Serbia with economic ruin if it didn't violate its own laws by handing over Milosevic for trial at The Hague. We'll look at these events more closely in this chapter and the next. It's easy to see how all this could help legitimate the illegal use of force by NATO. If NATO was pursuing criminals indicted by the tribunal, it could present its law-breaking as law enforcement. And every aggressor wants to demonize its enemy. The ICTY would officially brand them international criminals, and not just any criminals, but Nazi war criminals. In fact, if there was one service the ICTY performed for NATO that stood out above all others, it was to confirm NATO's outrageous analogy of Kosovo to the Holocaust. The Holocaust analogy. The Holocaust was the dominant metaphor of the war. What had to be stressed was that inaction in the face of Serb atrocities was appeasement all over again, just like the sort that preceded the other Holocaust. On March 23, 1999, with the bombing set to start the very next day, Bill Clinton pointedly asked his television viewers, "What if someone had listened to Winston Churchill and stood up to Adolf Hitler earlier? How many people's lives might have been saved? And how many American lives might have been saved?" 5. The UK's George Robertson repeated the party line a few days later. "We could not simply stand idly by. We must learn the lesson of the early days of Hitler. More than most, the British people understand that appeasement did not work in the 1930s. Nor will it in the 1990s. 6. The Germans, of course, had pulled out the phony Operation Horseshoe in mid-war. As experts on the Holocaust, they could proclaim they had serious evidence of concentration camps and systematic extermination that recalls in a horrible way what was done in the name of Germany at the beginning of World War II. 7. It was enough for the British press to see lines of refugees to invoke the Holocaust in the bombing's very first week, 1939 or 1999. Nazi-style terror came to Kosovo yesterday in a hoary sea echo of the wartime Holocaust. 8. Clinton's Churchill speech was made a day after the Academy Awards, reputedly the most widely watched television show in the world. That night Hollywood had lavished Roberto Benigni's La Vita e Bella with Oscars for a Holocaust-light LM that portrayed the whole thing as essentially about trains and refugees, a LM in which only one actual death occurs and it is off-screen. But, of course, trains and refugees do not add up to a Holocaust. The worst cases of ethnic cleansing in Kosovo, or indeed Bosnia, did not even come close to the extermination program of the Nazis. It does not minimize the suffering of people killed in the thousands, terrorized and expelled from their homes in the Balkan Wars, to distinguish that from being hunted down one by one wherever we lived, or wherever we ran, in a methodical plan to wipe an entire people off the face of the earth. The Nazis murdered 6 million Jews, 2/3 of all the Jews of Europe, 90% of all the Jews of Poland. Of the 8,000 Jews in my father's little town of Apt, a mere 300 survived the war. 9. In the real Holocaust, as it has been pointed out, deportation didn't mean Jews being put on trains to Israel, it meant Jews being sent to Auschwitz to be gassed. 10. Nor did European Jewry have a separatist army like the KLA that was carrying out terrorist attacks on German police and trying to take a piece of Germany away from the Germans. Nor was the United States planning a bombing campaign to help them do it. Nor, for that matter, did the West merely stand by and do nothing during the real Holocaust. Instead, it locked its doors to Jewish immigration and sent people back to their destruction. Nor did the idol of state sovereignty, the one NATO wanted to dissolve in Kosovo, pose any obstacle. 11 Hitler broke that barrier himself in 1936 when he occupied the Rhineland and sent his warplanes against the Republic in the Spanish Civil War, and again in 1938 when he forcibly annexed Austria and Sudeten Czechoslovakia, not to mention his conquest of the rest of Czechoslovakia in early 1939. Had the world stood up for national sovereignty and international law, there would have been no Holocaust. And when the Allies were engaged in a fully legal war with Germany in Poland, and they were begged by Jewish representatives to go kilometers out of their way and bomb Auschwitz, which could have saved hundreds of thousands of Jewish lives, they couldn't be bothered because it didn't tee into their strategic plans. 12 If there was any analogy between Kosovo and the Holocaust, it was that the West didn't give a damn about the Albanians any more than they did about the Jews. The off-chain admission that Kosovo was neither Holocaust nor attempted Holocaust came when Milosevic was read his charges at The Hague, and there was no charge of either genocide or attempted genocide among them, at least as far as Kosovo was concerned, even within the absurdly weak definition of genocide employed by the ICTY. The genocide charges were all for Bosnia, and the only way of explaining the speed with which the press rose to NATO's Holocaust bait in Kosovo was the store of capital that had been built up in the Bosnian Civil War. Bosnia and the birth of the ICTY. The nature of the Bosnian Civil War made the Holocaust analogy slightly more plausible than it would be for Kosovo. Bosnia was a war over territory, and everyone foresaw some sort of coming division on ethnic criteria, so all sides tried to create facts on the ground. Hence the practice of ethnic cleansing, which essentially meant forced population transfers, usually accompanied by terror. Of course, ethnic cleansing was completely different from the Nazi deportations of Jews, even though it employed some of the accoutrements, such as brutal transports and detention camps. One particular difference stands out: the Nazi idea was to rid the world of Jews, not a specific contested territory with some NAL settlement in mind, and hence the transportations were to extermination camps. The term concentration camp was a euphemism for the Nazis, but since then it has stood for what they were trying to hide by the use of it. The Bosnian government based its international public relations campaign squarely on the Holocaust analogy. The campaign found a very sympathetic ear among the opinion makers of its American allies, and was, indeed, managed by the American PRRM Reuter Finn, which Bosnia hired in June 1992. 13 On July 29, Bosnia sent the Security Council a list of 94 concentration camps and prisons under the control of the Belgrade regime and its surrogates, in which tens of thousands of innocent civilians were held, most of whom are women, children, and elderly persons. 14 On July 31, Bosnia's Muslim President Izetbegovic told British television that the Bosnian Serb leader Karadzic was as bad as Hitler, and asked, "Do the European leaders know about the Serbian concentration camps, about the mass killings?" 15 Gruesome articles immediately started to appear in the Western press. In one, Roy Gutman wrote of the Brčko concentration camp where, according to Survivor, at least 3,000 Muslims, prisoners, and townspeople, were slaughtered in 6 weeks, 9/10 of the prisoners immediately. The preferred method was slitting throats. 16 When the self-styled Adolf of Brčko was brought to trial in The Hague some years later, he was convicted of only 12 counts of murder, all by pistol shots, and the number of alleged deaths in the area had dropped to a vague in the hundreds, with a total of 66 bodies exhumed from the mass graves. 17 These were horrible brutalities, the kind that occur in all wars, but Nazi extermination they were not. However, in the early days of August 1992, the Holocaust imagery poured out of the American press. On August 3, liberal columnist Anthony Lewis wrote in the New York Times, "Nazis transporting Jews in 1942? No, Serbs transporting Muslim Bosnians in 1992, one glimpse of the worst racial and religious bestiality Europe has known since World War II. President Bush has been a veritable Neville Chamberlain in refusing to face the challenge in Yugoslavia." 18. Lewis was evidently rooting for Democratic presidential candidate Bill Clinton, and Clinton showed no less restraint than he would as president. If the horrors of the Holocaust taught us anything, it is the high cost of remaining silent and paralyzed in the face of genocide. 19. We cannot afford to ignore what appears to be a deliberate and systematic extermination of human beings based on their ethnic origin. 20. The American Jewish Congress was enlisted to lend its authority with an advertisement entitled "Stop the Death Camps" that had texts such as, "To the blood-chilling names of Auschwitz, Treblinka, and other Nazi death camps there seem now to have been added the names of Omarska and Berchko." 21. The New York Times ran a lead editorial on August 4 under the title "Milosevic isn't Hitler, but..." The only reason the Times could see for distinguishing between Milosevic and Hitler was the fact that Milosevic's lack of military might limited the geographical scope of his final solution. 22. Hitler wasn't even bad enough for Cold Warrior Margaret Thatcher, who had to add Stalin to the mix. The Serbian ethnic cleansing policy combines the barbarities of Hitler's and Stalin's policies toward other nations. 23. For visuals, the press at RST had to rely on old World War II footage from Nazi death camps. 24. But these were quickly substituted by images of actual Serb-run camps LMED by an enterprising British television crew, which made it seem as if the same thing were happening all over again, even though the Nazis were not known for letting Allied news teams into Auschwitz. On August 7, America's and Britain's front pages carried the photo of an emaciated Bosnian Muslim standing behind barbed wire in the Trnopolje prison camp in northern Bosnia. 25. This would become the poster for the Bosnian Civil War. A controversy arose some years later over who was actually inside the fence, the LM crew or the prisoners. 26. But it wasn't the positioning of the barbed wire that made the Nazi link false. A lot of horrible things occurred in these camps, but not extermination. In its very RST case, the ICTY heard charges of beatings, torture, sexual assaults and murder committed against Bosnian Muslims interned in the Omarska camp during June and July 1992. The Bosnian Serb Duško Tadić was sentenced to 20 years in prison, though he was personally acquitted of all murders. 27. But that's not the point. The point is that the counts of murder against Tadić only numbered 9. And even 100 murders by a sadistic Opchale wouldn't make this a concentration camp in anything but the literal sense. For a Nazi concentration camp you need gas chambers and crematoria. And did you ever hear of a Jewish concentration camp where Nazis were tortured, raped and killed by Jews? Because at the same time that the Serbs were being Nazis to the Muslims and Croats were being Nazis to the Serbs. At least that was the ending of the same court that convicted Tadić. In November 1998 the ICTY convicted a Bosnian Croat and 3 Bosnian Muslims for beatings, torture, sexual assault and murder of Bosnian Serbs in the Cielbici camp in May, June, and July 1992. 28. The sentences, as in the Tadić case, were for up to 20 years. In fact, there was plenty of information available in the summer of 1992 to show the Serbs not only sinning but sinned against as well, nor is the cleared earth policy an exclusively Serbian practice. Croatian forces have jumped into the GHT, expelling Muslims and Serbs. And Muslim Slavs have also tried to oust Serbs and Croats, read an August story in Time. No one's hands are clean in this dreadful war, said a UN Eldofsir. All have done horrible things. 29. Canadian General Louis Mackenzie, in charge of UN forces in Bosnia, said there was plenty of blame to go around here and if this war is going to stop, both sides have a significant degree of responsibility. 30. It appears that the Serbs had even been its RST victims at the hands of the Croats in 1991. 31. The very origin of the phrase has been attributed to a Croat governor of western Bosnia in Hitler's puppet state, who urged that his territory be thoroughly cleansed of Serbian dirt. 32. But in August 1992 the crude propaganda campaign to Nazify the Serbs was a Terry success, and it is precisely here that we end the birthplace of the ICTY and its whole modern war crimes progeny. When I came to work on the morning of August 7, 1992, the Department of State was in a frenzy over the ITN broadcast of conditions at the Omarska concentration camp, writes Michael Scharf. 33 Scharf's job was to draft Security Council Resolution 771 of August 13, which called upon states and international humanitarian organizations to collate substantiated information in their possession or submitted to them relating to the violations of humanitarian law, including grave breaches of the Geneva Conventions being committed in the former Yugoslavia, and to make this information available to the Mondel 02 Chap 4 122 Mondel 02 Chap 4 122 June 5, 04, 3:36 and 22 seconds p.m. June 5, 04, 3:36 and 22 seconds p.m. The War Crimes Tribunal 123. Council. The Council had already warned, a few weeks earlier, apropos of the deteriorating situation in Sarajevo, that persons who commit or order the commission of grave breaches of the conventions are individually responsible in respect of such breaches. 34 Now Scharf didn't have to work from scratch on these resolutions. In fact, he borrowed the war crimes wording straight from a Security Council resolution against none other than Saddam Hussein. 35 Gulf War Resolution 674 of October 29, 1990 was the fruit of a campaign publicly launched by UK Prime Minister Margaret Thatcher within a month of the occupation of Kuwait. Speaking on British television of the Iraqi detention of foreign nationals, she said, "If anything happened to those hostages, then sooner or later, when any hostilities were over, we could do what we did at Nuremberg and prosecute the requisite people for their totally uncivilized and brutal behavior. They cannot get out of it these days by just saying, well, we were under orders." That was the message of Nuremberg. 36. President Bush Sr. picked up the torch in October when stories of Iraqi atrocities were starting to circulate. These would later be shown to be total fabrications. 37 Hitler revisited, declaimed Bush. But remember, when Hitler's war ended, there were the Nuremberg trials. America will not stand aside. The world will not allow the strong to swallow the weak. 38 So the whole War Crimes Initiative started life as part of the toolkit for labeling Saddam Hussein the new Hitler, in order to build the case for war against Iraq. To make this even clearer, the idea appears to have originated with the U.S. Army. To make it even more ironic, the people who dreamed it up in turn got the idea from the prosecution of war crimes committed by American soldiers. The U.S. OPCHAL in charge of the Kuwait dossier was in Vietnam, where he successfully prosecuted 28 Marines who had committed acts of murder which could be classified as war crimes. 39 In other words, the idea of prosecuting the Iraqi leader for war crimes came from experience with war crimes committed by Americans. In fact, the Americans seemed to have warmed to the idea of an international tribunal because of the bad press they had received from prosecuting Panamanian President General Manuel Noriega in the U.S. on drug charges, after the U.S. invasion of tiny Panama. That supreme crime took hundreds of civilian lives and was condemned by the General Assembly of the United Nations as a flagrant violation of international law and of the independence, sovereignty, and territorial integrity of states. 40 This time the U.S. preferred an international tribunal for Saddam Hussein, to diminish the impression of Western victors taking revenge on the vanquished. 41 When the Americans decided to end the Gulf War without overthrowing Saddam, they also lost interest in putting him on trial for war crimes, more proof of which was cart and which was horse. But the precedent was a very handy one for the military confrontation brewing in the Balkans. The Europeans, especially the Germans, who had started the whole thing by precipitating Croat separatism, were very happy to use the media campaign to blame everything on the Serbs. German Foreign Minister Klaus Kinkel gave a rabid speech at the EU-UN conference in London later the same month that the barbed wire footage was televised. Invoking the terrible images that can be seen daily on television screens all over the world, he proceeded, "Where does the main source of the evil lie? The answer is obvious, in Belgrade." And he concluded, "Those responsible for all crimes and violations of human rights, both inside and outside of the camps, must be brought to account. An international court of criminal justice has to be created." 42 The French Foreign Minister Roland Dumas made sure to link what was going on to the Nazis by nominating Elie Wiesel for the job of visiting the camps. 43 Wiesel had already involved himself in the anti-Serb campaign, though he had the scruples to stop short of the Holocaust analogy. He was invited in the late summer to visit the Serb-run camps, but he didn't go until November. When he wrote about his experience 4 years later, not only were they not Auschwitz, they seemed nowhere near as bad as a standard U.S. maximum security jail. For instance, of the camp he calls the notorious Manjaca camp, Wiesel wrote, "The prisoners tell us that the food is not too bad, the conditions in general bearable. What are their main complaints? To be out of touch with their relatives, their people. To be cut off from the outside world. To live on the sidelines, to feel superuse. There is a young German among them. He was taken prisoner by the Serbs. Why? How does this war concern him? Oh, I didn't come to GHT, he answers, shrugging his shoulders, but to write a book. And that's why the Serbs arrested you? Well, it's that, they caught me with a Kalashnikov in my hand. I am bewildered, and it was with a Kalashnikov that you were going to write a book? Have pens gone out of fashion?" 45. Wiesel would become a strong Clinton supporter and a prominent Kosovo belligerado. He also claimed joint authorship of the idea of a war crimes tribunal with Secretary of State Lawrence Eagleburger. In December, I had a long talk with my friend Larry Eagleburger, Secretary of State under George Bush, about the means available to put an end to the slaughter in the former Yugoslavia. It was then that we had the idea of an international tribunal. We agreed that not to prosecute the criminals would amount to condoning their crimes. In extreme situations, speaking out is a moral obligation. An initial list of names was drawn up. Eagleburger showed it to his European counterparts. 46. Wiesel's memory is evidently less than perfect. Eagleburger and candidate Clinton had publicly launched the war crimes idea at the beginning of August, some 4 months earlier. 47 Klaus Kinkel, just quoted, put it forward at the UN-EU London conference. But the conference concluded without taking up his suggestion. Its main concern was with peace, and its most important decision was to set up the Permanent Peace Conference at Geneva with Vance and Owen as chairs. The only reference to criminal proceedings was the rather non-committal one that the co-chairman would carry forward a study of the creation of an international criminal court. 48 Far more important for Vance and Owen than a criminal court was the carrying forward of the peace process, which made real gains in the fall of 1992. But a big obstacle to peace was the Americans, who had already blasted one possible peace deal in February 1992, before the outbreak of the Bosnian War, and would repeat this feat over the next 3 years. Now the point of all this is that the Americans used even the idea of a criminal court as a way of opposing the peace process and justifying the military solution that they favored. And it's here that Wiesel's friend Larry Eagleburger comes in. In fact, Wiesel's long talk with Eagleburger came in Geneva at a particularly delicate stage in the peace negotiations. The list of names was not merely shown to Eagleburger's European counterparts, it was announced in public, to the press, as a blistering attack on the entire Serb leadership, in fact a declaration that they would all be prosecuted as war criminals at a second Nuremberg. And this in turn was part of an announcement that the Americans were going to start bombing, and that the people of Serbia had only themselves to blame if, in terms George W. Bush would use in 2001, they shared their leader's fate. Here's the key part of Eagleburger's speech. It is clear that the international community must begin now to think about moving beyond the London agreements and contemplate more aggressive measures. That, for example, is why my government is now recommending that the UN Security Council authorize enforcement of the no-fly zone in Bosnia, and why we are also willing to have the Council re-examine the arms embargo as it applies to the government of Bosnia-Herzegovina. Finally, my government also believes it is time for the international community to begin identifying individuals who may have to answer for having committed crimes against humanity. We have, on the one hand, a moral and historical obligation not to stand back a second time in this century while a people faces obliteration. But we have also, I believe, a political obligation to the people of Serbia to signal clearly the risk they currently run of sharing the inevitable fate of those who practice ethnic cleansing in their name. 49. Eagleburger then named 10 individuals who, according to him, should be charged with war crimes. 7 of them were low-level, but there were also 3 big names, all Serbs, Milosevic, Karadzic, and Mladic. In other words, the proposal for a war crimes tribunal was used by the Americans to justify their intention to go to war, collateral damage and all, by branding their proposed enemies as Nazis. It was also an obvious attempt to derail the peace process. British PM John Major was said to be incensed, though Owen called the charges merely unhelpful, which was putting things diplomatically considering that the Vance-Owen peace plan depended on the involvement of leaders named by Eagleburger as war criminals. The question now arose of whether they should even be allowed into the United States to participate in peace talks. 50. This was NE by the supporters of the international criminal justice movement. They have always found it impossible to understand how anybody could think the minor matter of peace more important than punishing war criminals. Louise Arbour would express this view when she indicted Milosevic. Her predecessor Richard Goldstone had fretted in 1994 over the precedent that might be set by US and UN negotiations for an amnesty for peace swap with the military leaders in Haiti. This is an example of the wrong way to deal with these crimes, he told the press then. It doesn't serve justice and it ignores the victims. His deputy prosecutor Graham Blewett added, if people look at this as being an avenue for obtaining peace, it hinders our work. 51. Michael Scharf called the UN Amnesty for Peace approach infamous. 52. Journalist Carol Off approved of Goldstone's approach, he was right. War criminals were not chattels to be traded for peace. 53. Off was openly scornful of Boutros Ghali's opposition to moves like Eagleburger's. It was no secret that the Secretary-General didn't want the war crimes issue to undermine the peace process. If peace required negotiating with mass murderers, it was important to end other ways of describing those mass murderers in public statements. 54. Yet when Eagleburger made his speech, tens of thousands of Bosnian deaths had yet to occur. Would it not have been worth sacrificing a few trials in The Hague to prevent that? Besides, the idea that the Eagleburger speech was simply an exercise in let justice be done though the heavens should fall by a principled man who just couldn't stand by is in the William Walker realm of fantasy. Though Eagleburger and Wiesel both claim it was a spontaneous result of their fortuitous meeting and their moral outrage, it was no less calculated than Walker's outburst at Rakok. State Department insider Michael Scharf describes it this way. The speech was generally assumed to have been largely impromptu and some press reports implied it had not even been cleared with the White House. Nothing could be further from the truth. The naming names speech was in fact cleared throughout the government in advance, and I, myself, made certain revisions to ensure that the statement contained the requisite legal caveats and quali ERS 55. The very notion of an American administration unable to stand by in the face of crimes against humanity is absurd. Not only did America work overtime to make sure that everybody stood by while Rwandans slaughtered each other, its history is full of active slaughtering, a prime example of which is the Vietnam War, which bears mentioning if only to shed light on Eagleburger's own credibility as a morally driven actor. If you think Christopher Hitchens does a good job incriminating Henry Kissinger for hundreds of thousands of deaths in Southeast Asia, then you may be interested to know that morally outraged Larry Eagleburger worked at the American State Department from 1968 through 1984 as Kissinger's right-hand man. This was a period that included such barbarities as the Vietnam War, the installation of dictator Augusto Pinochet in Chile, and the terror war against Nicaragua. During the Iran-Contra affair, Eagleburger was the third-ranking person in the State Department, in other words, William Walker's boss. Hitchens points out in his book that the American-supported Indonesian invasion of East Timor took between 50,000 and 80,000 lives while Henry Kissinger was Secretary of State, and Hitchens even quotes a declasse ed memo of a meeting of December 18, 1975 to show Kissinger's consciousness of guilt. Lawrence Eagleburger was at that meeting, showing no moral outrage, only supplying excuses. After he left the State Department, Kissinger would profit handsomely from his relations with the brutal Indonesian regime, through his consulting R.M. Kissinger and Associates. Eagleburger was president of Kissinger and Associates from 1984 to 1989, before returning to the State Department under George Bush Sr. to help out with the invasions of Grenada and Panama and the Gulf War, and then to express his moral outrage at the Serbs. 56. The Eagleburger speech was also timed to coincide with the meeting of a commission of experts appointed by the Security Council to investigate Balkan war crimes. Law professor Sharif Bashiani was the American nominee to the commission. An American of Egyptian Muslim extraction, and extremely committed to prosecuting Serbs, Bashiani was another one of those no peace without justice visionaries. According to him, UN resistance to the aggressive American approach was due to that foolish idea that the top priority of the Security Council is to achieve a political settlement, and that everything that impedes this goal should really be checked, and to the great apprehension that the Commission might be an impediment to a political settlement. 57. This, with many thousands of deaths in the Bosnian Civil War still in the future. The Americans provided the Commission with seed money of $500,000 despite a legal opinion by the UN Office of Legal Affairs that this was forbidden, but when would that ever bother the US? When Bashiani took over as chair, he went out and got $800,000 in private funding from the likes of billionaire anti-communist George Soros. Bashiani then set up a documentation center at his own DePaul University, with protection from the FBI. More money and secondments from the US followed. By 1994, Bashiani's commission had compiled a war crimes dossier of 65,000 pages in length, with hundreds of taped interviews, which would become the database for the ICTY's prosecutions. In the meantime, the actual tribunal had been established by Security Council Resolution 827 of May 25, 1993, its statute substantially reacting the views of the American State Department as contained in a draft their lawyers had submitted to the Secretary General. 58. The resolution also contained a helpful provision allowing unlimited direct governmental and private support for the tribunal. 59. This made it possible for the U.S., at the time in its funding war with the cash-starved UN, to contribute directly to the tribunal without having to cut the UN in on the action. Privatization of both the United Nations and justice itself, Diana Johnstone has aptly called it. 60. The U.S. took advantage of this to make sure the ICTY was up and running as fast as possible, basically covering its budget in the early years and ensuring that it didn't suffer from the general austerity at the UN caused by the U.S. delinquency. 61. American personnel dominated the prosecutors of CE. The tribunal's 1995 report has 21 of 35 seconded personnel coming from the U.S. alone, with another 12 from other NATO countries, plus 2 Swedes. 62. U.S. generosity to the ICTY tribunal compared very favorably with neglect of the ICTY's sister tribunal, the International Criminal Tribunal for Rwanda.